It is no secret that Utah has one of the top performing economies in our country. And what many people don't know, though, is that is really fueled by the fact that we have affordable, reliable, secure, clean energy here in the state of Utah. And much of that comes from coal.
We produce enough energy here in a very small footprint to provide about half of what Utah needs for electricity.
If you kind of do the math, coal will continue to be used for, I believe, at least decades into the future. We need to figure out how to use that resource in a way that makes sense, not only for us, but for the future of our children, our grandchildren, and the planet.
The Hunter Power Plant has been a reliable source of cost-effective electric energy to hundreds of thousands of residential and manufacturing or wholesale customers.
Research that we're doing now is enabling the development of this technology that can be installed at full scale in the next 10 to 20 years that would allow zero-emission coal-fired utility boilers.
It's been such a cheap, affordable power that we have here in Utah.
Fossil fuels aren't going anywhere for a while. We all want to live in a world where our energy has no negative impact on the environment, but that's not going to happen for decades because of the technology limitations and also the existing infrastructure we have around the world.
The impact globally of those technologies could be transformational in really enabling the world now to use the world's fossil energy resources in ways that are going to maintain the quality of our air, our water, and our climate.
Well, they wouldn't be the first.
Good morning. This is the September 28th, 2016 hearing date for the Utah Board of Oil, Gas, and Mining. Our first agenda item is docket number 2016-019, cause number ROANG 2016-01 with regard to formal rulemaking on the reporting of undesirable events. And the purpose of this is to receive public comment, take appearances at this time.
Thank you, Mr. Chairman and members of the board. As you stated, this matter is a formal rulemaking that was filed by the division with the concurrence of the board after some informal discussions with the informal rulemaking group. Steve Schneider handles the rules for the division and has done an excellent job of getting this lined up, and he will give you the background prior and give the public some background prior to the opportunity for public comment.
Thank you. Proceed.
Yes, Steve Schneider with the division. The division and stakeholders did work on this rule proposal from the period of April to August 2016 in a phase we call informal rulemaking. That commenced on April 27th with a briefing to the board with a proposal to amend this rule by Kinder Morgan. An informal rulemaking working group for rulemaking was formed and met and reviewed all the wording in this rule. The informal rules review group, a long-standing group that has opportunity to receive notice of all proposed rules before formal, was also given an opportunity to review this proposal. And then finally, August 24th, the board did hear a briefing on the results of that informal process, and those are the rules that are before us today as part of the formal. A quick chronology, the division did file the amended rule proposal with the State Office of Administrative Rules on August 26th. That starts the formal process for the state office outside the board's own process. The division also filed the notice of agency action on August 30th. The notice of this hearing appeared in the newspapers on September 4th. And now the official formal comment period runs September 15th in the Utah State Bulletin. I have a copy here. That's officially published on the rule proposal. And normally it's a 30-day commenting period. Due to weekend times, it would end on October 15th, which is a Saturday, so the official end date is now October 17th. So September 15th to October 17th is the formal rulemaking comment period. So yes, we are here today to accept oral public comments, and written comments can be submitted through October 17th. We will want to, after public comment is accepted today, have the board continue this hearing to the next hearing on October 26th, such that we can keep this matter open and the board can make likely a final decision on the rule on October 26th. I know there are members of the public who wish to speak to this rule today, and possibly this would be the right time for that.
Thank you very much, Mr. Snyder. If members of the public, if you'd like to come forward, identify yourselves for the record, speak closely into the mic, and we welcome your comments.
Thank you, Mr. Chairman, members of the board. My name is Lee Peacock. I'm president of the Utah Petroleum Association. We appreciate the opportunity to comment on the proposed rule. Our organization has participated throughout the informal rules process. We appreciate the engagement by the division. They've been very accommodating as to facilitating a discussion around this important topic. We were able to suggest some changes in language, and we suggested a few comments. Some were adopted, some were not throughout the informal process, but that's the nature of that portion of the process. So we feel good about where we are in this rule. We are comfortable with the language as it now stands, and would just encourage the board's favorable recommendation when the time comes as we near passage of the formal rulemaking part of the rule. Thank you.
Next.
Good morning, Mr. Chairman, members of the board. Lowell Braxton, representing Western Energy Alliance. We, as well as the Utah Petroleum Association, participated in the informal rulemaking. We submitted some comments, some of which were well received and some of which were not adopted, but we're highly supportive of the process. We think the dialogue that's that's allowed by the division through its informal and formal results in solid rulemaking that is good for the state and good for the industry as well. So thank you very much for the opportunity to speak to this, and once again, congratulations on the process that you're utilizing.
Thank you very much. Other members of the public? Seeing none, then we come back to the board. It's been proposed that we continue this matter until our next regularly scheduled board meeting. Is there a motion?
So moved.
Is there a second? Seconded. The issue before you is to continue this matter until our next board hearing in October. All in favor say aye.
Aye.
Any opposed? Let the record show that that is unanimous. Thank you very much for the public comments and for the presentation this morning.
Sure.
Our second agenda item is docket number 2016-016, cause number 222-17, in the matter of PATMOS Energy. And we'll just take a minute, let the parties get organized.
Mr. Chairman, I think you read PATMOS as the next item, and that matter was at the very last minute. I don't know if you've seen it, but there was a motion to continue that matter for one more month.
Okay, that'll be so noted.
Thank you, Mr. Chairman.
Then what I think we're going to do, we're going to take we're on agenda item number 3 then. Let me read that into the record. It's docket number 2016-017, cause number 139-139, in the matter of Axia Energy 2. I think what we're going to do is allow council to discuss an issue, and then we'll come back. So we're going to take about a 5-minute break, or until you're ready to talk to us.
Thank you.
Council, are you ready?
Yes.
Okay, at this time, we will take appearances of council.
Yes, H. Michael Keller and Matt Brahana of Fabian Vancott Law Firm for at Energy 2.
Steve Alder with the Utah Attorney General's Office for the Utah Division of Oil, Gas, and Mining.
Any other parties? Okay, Mr. Keller.
Thank you, Mr. Chairman, and members of the board. We're here today to pool two of the 1,280-acre units that were spaced under cause number 139-138 by your order in, I believe, July 23rd, or excuse me, July 18th? Yeah, July 18th, excuse me, and 139-138. And that spacing order covered four contiguous stand-up 1,280-acre units just south of Roosevelt. And we are seeking to pool two of those today in our request for agency action for pooling. And neither of those currently have producing wells in them of any type, vertical or otherwise. And we're going to use two witnesses today, Mr. Adam Sayers and then Mr. Rick Gallegos. I would like to have them sworn in, if I might.
Let's have all the witnesses sworn in. Mr. Alder, do you have witnesses that will be?
No, I don't believe we'll have any direct testimony.
Okay. Let's have the witnesses sworn in. Mr. Sayers and Mr. Gallegos.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you.
Mayor Adams' credentials.
All right, let's proceed.
Yeah. We'd like to start with Mr. Sayers. Mr. Sayers, would you state your name and your current responsibilities and educational background for the board?
Sure. My name's Adam Sayers. I'm currently president and founder of at.a.m Energy 2. My education background is a bachelor's of science in petroleum engineering as well as a master's of engineering from the Colorado School of Mines. And really my responsibility is actually to incorporate all aspects of the business, whether it's business development, budgets, debt, technical. Essentially, the day-to-day operations flow through me.
We would move to have Mr. Sayers admitted as an expert in petroleum engineering.
Mr. Alder.
So you, just if I could clarify that, Mr. Keller, he will be testifying as to petroleum engineering matters relative to these wells?
Yes, as to the two initial wells.
And that would be the extent of his expert testimony qualification?
Yes, and otherwise he would offer factual testimony.
No objection, Mr. Chairman.
Board members. Okay. He is so admitted as a petroleum geologist or petroleum engineer for the purposes of this hearing.
Mr. Sayers, are you familiar with the drilling status of the number 32-144H-21 well?
I am.
Would you describe that well and where it's located?
Sure, and if I may, I'll give a little bit of background. As was previously mentioned, we got spacing approval on July 18th of this year. 2 days later, we obtained our permits on the first two wells that we planned to drill, and we had testified to the commission that we planned to drill. The Butcher Butte 32-144H-21 and the Butcher Butte 33-34H-21. But we're real proud of the fact that we got the permits real quick after spacing, and we started building location 1 week after that spacing order approval. We spud the wells in August 1st of 2016, and we're currently drilling both wells as of right now. And so first I'd like to update you on the Butcher Butte 32-144H. Here is what is unique. It's actually a 2-well pad. We testified that one of our goals was to minimize surface impacts, which we did. And so this is a 2-well pad. It minimizes obviously gathering lines, water lines, and saves the surface location. But we did spud. We are drilling these wells concurrently. I'm not sure if the board is familiar with stomper rigs, but we actually drilled the surface hole of one well, skidded the rig over, drilled the surface hole of the next well, and went back and forth. And so I'll give you our current status as it stands today.
Mr. Sayers, and could I draw your attention to petitioners filed Exhibit C,
Yes.
entitled Butcher Butte Regional Map, and could you reference that in your testimony about the wells?
Sure. You can see there in 2 south, 1 west, in sections 29 and 32, the 1280 that was spaced earlier. That is the 32-144-21. That is drilling and the long lateral in the Uteland Butte Formation. And the well just to the east, the 33-34H, is drilling the upper Wasatch, what we call the Wasatch 5. So let me give you the update on the 32-144H. It is currently at just under 15,000 feet measured depths at 14,956. We have drilled over a mile lateral, just over 5,300 feet of lateral, and we've got about 4,400 feet left to go. I would tell the commission everything's going as expected, with the exception of we're seeing a little bit more pressure, which is encouraging. We're seeing good shows. So we're very encouraged about what we're seeing currently. On the 33-34H, that is penetrating the Wasatch Formation. We plan to drill a 2-mile lateral there. That's currently at 98.13 measured depth. We set 9 5/8 inch casing at that particular point at a 60 degrees inclination. And we plan to drill the 2-mile lateral with an 8 3/4 inch bit once we're done with the first well. So our plan now is to continue for the next week or so to finish up the 32-144H in the Uteland Butte. We'll run our 5.5 inch casing, cement it, and then we'll skid the rig back over and finish up and drill the lateral on the Wasatch 5. So suffice it to say, we're real proud of the fact that we came and said we're going to get out here and get some activity going, and we've accomplished that, and we're moving quite quickly once we got approval.
Mr. Sayer, does the board have any questions about those 2 wells?
I think we'll wait till the end.
Sure, fine. Mr. Sayers, what are your plans for future wells?
Next year we're planning on bringing in a drilling rig. We need additional locations to drill, so we'll bring in a drilling rig probably February timeframe is our plan right now. And we'll keep plans right now are for about a 1-rig program, and just from a timing perspective, you generally drill 1 well per month.
Thank you. That's all the testimony we have for Mr. Sayers right now. We're going to reserve the right to recall him after Mr. Gallegos' testimony on the land title and notice issues.
Okay. We'll go to the division.
Yes, I have a few questions. Mr. Sayers, when did you apply for your APD for these 2 wells?
I'm not sure of the exact timing. We applied well before our spacing order in anticipation of quicker approval once the spacing order was approved.
So you don't know when you applied for the APDs?
I don't have that memorized, no.
When did you finalize your plans for the drilling of these 2 wells?
Well, it was a consistent work in progress. I would tell you that the finalized plans didn't occur until we got the rig out there to drill. But it's a ever-changing process. But I would tell you early summer is when the general concept of what we were going to do here.
And when did you commence the land work for the determination of ownership for these 2 drilling units?
Early in the year. I mean, this was, we started title work really as soon as we acquired the properties.
So did the notice go out ahead of the APDs, or do you know the notice to the owners of the AFE? Did you prepare an AFE for this well?
We did prepare an AFE.
And did you
for this
prepare
well.
that?
It was prepared underneath my supervision.
And is that part of your testimony at another time?
We're going to have Mr. Gallegos testify
Okay.
to the
All right.
AFE and the notice and
Okay, then that
the
may
ownership.
be all the questions. So you spudded both of these on August 1st. That was your testimony?
Yeah, I would tell you we took it depends what's defined as spud date. We had a spudder rig, a surface rig out there on July 29th actually with the spudder rig, and we spud both wells from the 29th to the August 1st, which is what should have been my testimony. So that's when we spud conductor on both wells.
And do you have partners in these wells?
We do have partners on these wells.
Who are they?
Probably a better question for Rick.
Okay, maybe these questions. If I could just reserve the right to recall Mr. Sayers if necessary, Mr. Chairman, I think that's all the question.
So noted.
Okay.
Okay. Board members, any questions? Mr. Sayers. We're back to you, Mr. Keller.
Yeah, I'd like now like to call Mr. Rick Gallegos. Rick, would you speak to your current position and experience in the oil and gas industry?
Yes. Currently, I am the Vice President of Land for at.a.m Energy 2 LLC. I oversee all land activities for Axia. I've got about 30 years experience, roughly, in the land business.
Yeah, and did you testify as an expert in oil and gas land title matters in the spacing hearing in cause number 139-138 before the board?
Yes.
I would like to offer Mr. Gallegos as an expert in oil and gas land title.
Division.
Well, to the extent that expert testimony may be necessary, I suppose I would disagree that it's necessary that he be qualified as an expert, but it's certainly would take no objection to his 30 years of experience and his experience as part of that testimony. I guess if there's an opinion testimony offered on behalf of him at that point in time, we would reserve the right to interpose an objection to the testimony.
So noted. Board members? Questions on that? I think we don't normally have expert land testimony, but if you want to go down that road, let's start down it, and we'll.
Yeah, I mean, while we're having Mr. Gallegos, we're having him testify as to the ownership of the lands and the organization of the tracks.
That's more of a fact witness than an opinion of an expert.
Right, but also he will testify as to the efforts that were made factually, and also as to the AFE on the wells.
Okay. He certainly has the qualifications, and the division has reserved the right to object. But for the purposes of going forward, he is admitted as an expert in land management.
Thank you, Mr. Chairman. Acknowledge that.
Mr. Gallegos, are you familiar with the board's spacing order in cause number 139-138?
Yes, I am.
Could you briefly describe the terms of that order, spacing order? for the board?
Yes, what that order did is it established 4 1,280-acre stand-up drilling units. And on those drilling units, we are authorized to drill up to 32 wells in the Green River and Wasatch formations.
And which of those drilling units are we seeking to, are you requesting pooling for today?
The drilling unit comprised of sections 29 and 32 in 2 South, 1 West, and the drilling unit comprised of sections 28 and 33 Township 2 South, Range 1 West.
And those are the 2 drilling units for which Mr. Sayers just described the long lateral horizontal wells being drilled?
Yes, they are the 2 drilling units depicted in red on the exhibit.
Let's see. Yeah, I'm directing your attention to Petitioner's Exhibit C, captioned Butcher Butte Regional Map. Was that prepared by you or under your direction?
Yes, it was.
Yeah, and what does it show?
It depicts the 2 drilling units that we would like to pool today, as well as the application lands that we will be filing, we will be discussing this afternoon, spacing lands.
I would move that Exhibit C be accepted into evidence.
I'm going to hold off on that till the end of your presentation.
Okay.
And then we'll take all exhibits.
Okay, thank you. Let's see now, let's go to Exhibit D. Now, Mr. Gallegos, directing your attention to Petitioner's Exhibit D, would you describe it?
Yeah, that is the well location plat for the Butcher Butte 32-144H-21 well. And what that does is it depicts the surface location, which is off the units in the northwest quarter of Section 4. And
Of the same township? and range?
no, of
section?
Of the township, that's in 3 South, 1 West. Oh, okay. Yeah, the surface location would be in 3 South, Township 3 South, 1 West, Section 4, northwest to northwest quarter. And then it shows what is the bottom hole, to be the bottom hole location of the well and the well pattern.
Mm-hmm. Now let's go to the mineral tracts. And that's now directing your attention to what's Petitioner's Exhibit D, page 2, entitled Oil and Gas Tract Plat. Would you describe that exhibit?
Yeah, that shows the different mineral tracts within Section 29, 2 South, 1 West.
Okay, let's go to the next one. And was that prepared by you or under your direction or
Yes.
supervision? Yeah. What was the source of the information for the tract map?
That came from a title opinion rendered by a licensed attorney in Utah.
Yeah. And when were those title opinions rendered?
They were rendered in April of this year.
2016?
That is correct.
Thank you.
April for that, yeah, that's correct.
Thank you very much. Anything else? Now, directing your attention to Petitioner's Exhibit D, page 3, also entitled Oil and Gas Tract Plat. Would you describe the exhibit?
This one breaks out the mineral tracts in Section 32 of Township 2 South, Range 1 West.
And so that is the other half of the stand-up
That is correct.
1,280-acre drilling spacing unit.
Yes.
Yeah. And what was the basis for the information presented in this exhibit?
This also came from the information gathered from the title opinion prepared by a title attorney licensed in Utah.
And when were those opinions rendered?
This was the same time, in April.
Of 2016?
That is correct.
Thank you. I'm showing you what's been submitted as Petitioner's Exhibit E. Would you describe it?
Yes, this is another well location plat, and this is for the units comprised of Section 28 and 33. They stand up 1,280 acre drilling unit. It also depicts the surface location, which is essentially, it's like within 4 feet of the surface location for the prior one we just looked at. And this one is for the Butcher Butte 33-34H-21 well.
Mm-hmm. Okay, let's go to the next. Oh, did I say what that was? Go back to that. Was this prepared by you or under your direction or supervision?
Yes.
Yes. Now showing you what's been marked as petition filed as Petitioner's Exhibit E, page 2, entitled Oil and Gas Tract Plat. Would you identify the exhibit?
Yes, this is an exhibit that shows the various mineral tracts for Section 28 in Township 2 South, Range 1 West.
And was this prepared by or under your direction?
Yes.
And what was the basis for the preparation of this exhibit?
A title opinion that had been prepared by a licensed attorney in Utah.
And what was when was that opinion rendered?
Approximately in May of this year.
2016?
Yes.
Thank you. Okay. I'm showing you what was filed as Petitioner's Exhibit E, page 3, also entitled Oil and Gas Tract Plat. Would you describe the exhibit?
Yes, this shows the various mineral tracts in Section 33 of Township 2 South, Range 1 West.
And was this prepared by or under your direction or supervision?
Yes.
And what was the basis for this exhibit?
A title opinion rendered by a licensed Utah attorney.
And when was the opinion rendered?
In May of 2016.
Thank you. Yeah, and this is also, this is the other half of the second drilling unit for which we're seeking spacing or pooling today. Okay, now let me go on. I'm finished the track plats. I think we need that. Yeah. Now, I'm directing your attention to Petitioner's Demonstrative Exhibit 1. Do you recognize this?
Yes.
And what does it show?
But this depicts all of the working interest ownership within the unit comprised of Sections 29 and 32 2 South 1 West.
And this relates to the corresponding oil and gas tract plats and breakdown of the tracts that you testified to earlier for these two sections?
Yes, it does.
Yeah, and what does it show?
What it does, it shows the working interest, everything that's been leased. So that's 98.9% of the unit is under lease. And of this working interest owners that are depicted here, Crescent Point has elected to participate in the well. Lynn Energy Properties has, due to reasons that they have internally, they have requested to go ahead and be force pooled on this. And I am in negotiations with the remainders of the working interest owners to reach an arrangement for them to either participate or transfer their interest to Axia.
Yeah. And would you name those, for the record, name the other interest owners? Working
yes.
interest owners, excuse me.
Yes, the working interest owners that I'm in negotiation with right now are Badlands Energy Utah LLC, Newfield Production Company, Newfield RMI LLC, Rig 2 LLC, and Wyatt Energy LLC.
Yeah, now, directing your attention to the footnote on the demonstrative exhibit 1, regarding efforts to contact Wyatt Energy. Are you familiar with that?
Yes.
Yeah, and would you explain what those efforts were?
Well, initially they were unlocatable, but I have since been in contact with them.
And when you say unlocatable, what do you mean by that?
Unlocatable, the address that we sent notice to, was delivered to us as non-returnable.
Non-returnable.
Yes.
Yeah. And was there a notice by publication?
Yes, there was.
And are you familiar with the notice?
Yes, I am by publication.
Right, yeah.
Yes.
And was Wyatt Energy included in that?
Yes.
Yeah. Okay, should we go to the next? Do we need? Okay, now showing you what's been marked as petitioner's demonstrative exhibit 2. Do you recognize that?
Yes, I do.
And would you describe it?
Yes, this is
Mr. Chairman, if I could interpose, I can't see these exhibits. Do you have hard copies that you can provide council?
Excuse me, I was just thinking about that.
It's really hard to, at this distance, read what's on the exhibit. Thank you, Mr. Chairman.
If I may for a minute, could I go back to the first page of this exhibit, Exhibit 1, with the working interest owners? Directing your attention to the far right-hand column entitled Source, would you explain to the board what we've identified there with the exhibits?
Well, this would be the well proposals.
Right.
For the wells. And in those well proposals, we offered each working interest owner an option to participate in the well or enter into negotiations with us for some other alternative. And in that well proposal, we provided a cost estimate that set out their interest in the unit and their estimated share of the drilling and completion cost for the well.
And the corresponding exhibit, for example, Exhibit N in connection with Badlands Energy Utah, included copies of those letters and offers.
Yes.
Yeah. And so forth for each of those owners. Those were exhibits that were filed with the board.
That is correct.
Okay. Moving on to demonstrative Exhibit 2. Would you describe this for the board?
Yes, this is a list of all of the unleased and non-participating mineral owners. And as you will note, it's a total of 1.09%.
Yeah, and this is in...
We were very successful in leasing almost 99%. And most of the issue that we have here is we just could not find these folks.
Right, and so this relates to the spacing unit 29/32.
That is correct.
And it's also relates to the 32-144H-21 well.
That's correct.
Yes. Now, on the, would you describe there's different categories of individuals depicted here, some with an asterisk, some without. Would you describe, their status?
Yes, some are unlocatable. The address that we sent the mailing to was delivered to us, and we have been unable to locate them. And in other cases, the parties have elected just not to lease or participate.
Yeah, in the far right-hand column of demonstrative Exhibit 2, there's a list, it says source in the column, and there's a list of exhibits, and then there's identification of with the word unlocatable with respect to certain owners. Would you describe the difference between those and what that's intended to show?
Yeah, the unlocatable ones are ones where we just did not or have an address that was delivered to them. We could not find their address.
Would you describe what efforts you took to find addresses for individuals in these drilling and spacing units?
Sure. We did a search of the county records, and we also had a title opinion that was rendered by a licensed title attorney in Utah, and through their searches as well, they furnished us with all the addresses, and that is what we really used to identify the folks and all the different interests within the unit.
So with regard to those individuals identified on demonstrative Exhibit 2, those mineral interest owners, as unlocatable, your testimony is that those were individuals for which the efforts to find addresses were unsuccessful?
That is correct.
Yeah. Now there's another group of individuals for which there's an exhibit identified in the far right-hand column of demonstrative Exhibit 2. Could you describe the efforts to contact those individuals and the meaning of the reference to the exhibits?
Yeah. Those individuals were sent out letters and received letters in which they were offered an opportunity to participate in the well or lease their interest. And as far as the participation goes, we did set out what their proposed interest in the unit was, as well as their estimated costs of drilling and completing the well. In terms of the offers to lease, the terms were consistent with what we offered others in terms of bonus and term within the drilling and spacing unit, and the royalty was actually a little greater than what the weighted average royalty will be, and we will be showing you that later.
Okay. Some of the individuals, the listed mineral owners, have an asterisk after their name. Could you describe for the board the meaning of that?
Well, some of these, yeah, there were, we had sent out the well proposals to them and the offers to lease, and they were returned.
So even though you had an address, the mailings were returned?
That is correct.
All right. Now, I'd like to, and as to those individuals that were either identified in the far right-hand column as unlocatable initially, or for whom your offer letters were returned, did you take steps to further notify them?
We did. We did some internet searches and those type of searches, but we're unable to find these folks.
Did you provide notice by publication?
Yes, we did.
And pursuant to a board order?
Yes.
Okay. Now I'd like to draw your attention to Exhibit BB, which relates to mineral interest owner Judith Ann Hires.
This is
We'll put that up on
Baker BB.
BB, yeah, Baker BB.
Okay.
Okay. And this was a filed hearing exhibit.
Okay.
Why don't we? So I don't know if he has a copy of that. Yeah, can you see it on the screen there?
And could you expand the relevant portion of this exhibit?
Yeah. Can you see it now?
Yeah.
Yeah. And what does this exhibit generally contain? Everything.
Well, it's a green card that shows that it has been mailed
To
Judith Ann Hires.
right. Okay. And signed.
I guess
By her?
mailed and it's proof of receipt.
Right.
Yes.
Okay. Good. Okay, and I'm going to page 2 of Exhibit BB, and do you recognize it?
Yes, that would be the proposal to lease and or participate.
And was that sent by or under your direction?
Yes.
And basically, what did it provide?
It provided the opportunity to either lease or participate in the well.
And what is the date of that letter? June 30th.
June 30th.
Blow it up a little more. Yeah. Were the terms of this offer to lease or participate in the Butcher Butte 32-144H-21, were those customary and reasonable in your experience
Yes,
in the Uinta Basin?
they were customary and reasonable and consistent with what we have done in the unit.
Yeah, would you describe the basic, the royalty rate?
The royalty rate that we offered there was $360, the primary term 3 years, and the bonus $350 per net acre.
Okay, thank you. Okay, is there another page or is that it? Okay, there, yeah, and here's page 2 of the offer letter to Ms. Hires.
Yes. And on page 2 is what we did. We furnished her with an operating agreement as well in the event that she should elect to participate in the well. We had set out what her proposed interest in the unit was, as well as what her share of the estimated cost to drill and complete the well would be.
And did you provide her an AFE or authority for expenditure on
Yes, we
the well?
did.
Yeah. And what period of time did you give her to respond?
30 days, essentially. It was August 5th, so that would delay. It was dated June 30th.
Okay. So we're going to go through now could we go back? Are there anything else on that? Could we go back to the big? Yeah. Now, returning your attention and the board's attention to demonstrative exhibit 2, you were just testifying as to the substance of the offer made to Judith Ann Hires set forth in exhibit BB. Were similar letters and terms and conditions are identical with the exception of the address sent to the other mineral interest owners within the 29-32 drilling unit?
Yes.
And when were those letters sent?
They were sent out on, I believe, July 1st.
Okay. And they offered similar terms and also at least 30 days to respond?
Correct.
Right. Okay. And on the demonstrative exhibit 2, the first 3 names I'm going to withdraw that question. I think we finished with that. We'll go to the next. Okay. Now I'm, Mr. Gallegos, I'm directing your attention to Petitioner's Demonstrative Exhibit 3. Would you describe it?
Yes, this is a list of the working interest owners for the drilling unit comprised of sections 28 and 33, Township 2 South, Range 1 West. And as you will note on this particular drilling unit, we have been successful in leasing us or the other working interest owners 99.2%, 1% of the unit.
Right. And would you identify the working interest owners?
Yes. Let me start with the bottom one, David Poor. He has elected to participate and sign the JOA. And as with the other unit, I am in negotiations currently to work out an arrangement with these parties for either their participation or our acquisition of their interest. Okay. Directing your attention to the far right-hand column of Petitioner's Demonstrative Exhibit 3, under the heading Source, it references various exhibits. Would you describe what those exhibits are? Yes, as with the previous unit, these are exhibits for well proposals wherein the parties were sent a well proposal with an AFE, a cost estimate to drill and complete the well, along with a breakdown of what their proposed ownership was in the unit and their share of the cost to drill and complete the well, along with the option to work into an alternative arrangement to participating.
Okay. Now I'd like to direct your attention to Exhibit P, which was filed with the board, and we'll put that up on the screen. Okay. Do you recognize the first page of Exhibit P?
Need you to blow it up just a little.
Yeah, sorry.
Okay, yeah. That's a certified mail receipt for Newfield Production Company.
And it shows that it was a delivery.
Yes, showed delivered to the mailroom in Spring, Texas.
Okay. Now would you go to the second page of Exhibit P? And do you recognize that?
Yes, I do. That would be the well proposal.
To Newfield RMI LLC?
Correct.
And what's the date of that letter?
July 1st, 2016.
Yeah. And could you describe the basic, terms and conditions of this letter?
Yeah, this is just simply it's an election to participate in the drilling and completing a well that has a cost estimate attached to it, as well as a joint operating agreement. And as I mentioned earlier, it sets out what their proposed working interest is in the drilling unit, as well as their share of the costs to drill and complete the well.
Right. Would you go to the second page of the letter? And how much time was given to respond to the letter?
It was sent out on July 1st, and the date on which we asked for a response was August 5th.
Right. And were similar letters to this sent to each of the working interest owners in the 28/33 drilling and spacing unit relative to the 33-34H-21 well?
Yes, they were.
And those, the documentation of that is reflected in the corresponding exhibits shown on demonstrative Exhibit 3 for those working interest owners?
That is correct.
Okay. Now directing your attention to demonstrative Exhibit 4. Would you describe the exhibit for the board?
Yes, this is a list of unleased and non-participating mineral owners for the drilling unit comprised of sections 33 and 34, Township 2 South, Range 1 West. Let me correct, that's for sections 28 and 33.
Yes, thanks. And that's for the 33-34H-21 well?
That is correct.
Right. On the list of mineral interest owners, can you blow that up a little more? Certain individuals are identified as unlocatable in the far right-hand column. Would you describe what that refers to?
Unlocatable, once again, we were unable to find an address for them.
Right. And then there's a group of individuals for which there's an asterisk after their name. And would you describe their status?
That was where we had an address, but the address we sent it to, we had it returned to us as undeliverable.
Right. And then the other individuals listed, mineral interest owners listed, you had addresses and sent offer letters?
Correct.
Yeah. And those offer letters and the returns are included in the corresponding exhibits in the far right-hand column with respect to those owners?
Yes.
Okay. Which one are we using? We did BB before. Yeah. Are these offer letters similar to the offer letter Exhibit BB to Ms. Hires on the other unit that you described earlier?
Yes, they are basically the same letter, and but they're tailored for their interest in the unit and their cost of the well in the unit.
And it included a a lease offer with a 3/16 royalty and a 3-year term?
Yes, as well as an election to participate
Right.
as well, and a JOA, should they choose to do so.
And did it include an AFE?
Yes, it did.
Do some of the owners on either of these spacing units either just refuse to lease or participate?
Yes.
Did the letters that you sent to all of the interest owners in both drilling units inform them of Axia's intent to seek forced pooling of their interest if they did not elect to lease or participate?
Yes.
And did the letters sent to all of the mineral interest owners in both of the subject drilling units inform the recipients of Axia's intent to seek a statutory non-consent penalty?
Yes, they did.
Thank you.
And one thing I guess I would note here too is that of the unleased non-participating interest in this unit, it only made up 0.78%.
Right.
We were successful in having under lease over 99% of the unit.
Right.
And then the total unlocatable was 0.16%.
And then with respect to those individuals that were initially identified as unlocatable for lack of an address, or for whom an address was discovered but the mailing was returned and are indicated by an asterisk on demonstrative exhibit 4, were further efforts made to give them notice?
We made further efforts to try to find their address, but further mailings were not made to them.
And then were they given published notice?
Yes, they were.
Pursuant to the publication of notice was made in what newspapers?
In the Salt Lake Tribune, the Desert News, and the Uinta Basin Standard.
Yeah. Okay. Yeah. Regarding the lease offers and the proposed leases to all of the individuals in the 2 drilling and spacing units, did those leases contain a pooling clause authorizing pooling on a 1,280 acre basis?
Yes, they did.
And yeah, and do the people that did decide to lease, do their leases include pooling clauses authorizing pooling on a 1,280 acre basis?
Yes.
Okay. And is that true for both the 29-32 drilling unit and the 28-33 drilling unit?
Yes.
And do all of the JOAs provide that the 2 drilling units may be pooled on a 1,280 acre basis?
Yeah, they are set up for 1,280 acres.
And is Axia requesting that the pooling order be made effective upon the date of first production from the subject wells
Yes, we are.
in these 2 drilling units? Yeah.
Correct.
Yeah. And is your intent that the order will provide for a full and equal accounting of the well costs and proceeds from production among all of the owners with interest in the drilling units?
Yes.
And that it will ensure that all owners share in the pool equally?
Yes.
And
Equally based on their interest.
in accordance with their
Yeah.
percentage interest?
Yeah.
And that the requested pooling order would allow unleased owners who did not elect to participate to receive their acreage-weighted average landowner royalty from the date of first production?
Yes.
Okay. Now, we want to go to the, all right, we're not going to post that. Okay, put the cover page up. Now I'm directing your attention, Mr. Gallegos, to the the screen, we posted the cover sheet of the request for agency action in this matter for cause number 139-139. Are you familiar with the request for agency action?
Yes.
And did you authorize its filing?
Yes, I did.
And did it contain a certificate of mailing?
Yes, it did.
And does that certificate show that it was sent certified mail on August 10th, 2016?
Yes.
And is it your understanding that the request was mailed to everyone on the list who is identified on the certificate of service with a valid address?
Yes.
And
Every address there got a letter.
Yeah, right. And then the proof of service of the request of the request for agency action, have you reviewed that?
Yes, I have.
And is that set forth in Exhibit ZZ?
Yes.
And to your knowledge, is that true and accurate?
Yes.
And you've testified earlier, I believe, that notice of publication was provided for the all the individuals who are either initially identified as unlocatable or for whom your offers to lease or participate were returned as undelivered.
Correct.
Right. I think we've testified as what the efforts they made.
As well as any owner that elected not to participate or had not elected to participate.
Thank you.
Yes.
Yeah. Is it fair to state that Axia, made reasonable efforts, all reasonable efforts to try to locate interest owners in the two drilling units?
Yes.
Okay. Now we're going to go to the publication. Yeah. Did Axia seek leave to file notice by publication to unlocatable owners in this cause?
I'm sorry, repeat the question.
I said, did Axia seek leave to file notice by publication to unlocatable owners in this cause?
Yes.
And would you describe the efforts that Axia made
For,
to seek leave to file notice by publication?
okay. Yeah, we filed notification in the Salt Lake Tribune as well as the Desert News, and that was done for a consecutive 2-week period. And then also we filed notice in the Uinta Basin Standard, and that was done for once a week for 2 weeks.
All right. And I would like the record to reflect that as council, we filed the proofs from the newspapers of the period of publication and copies of the notice with the board.
Division.
Mr. Keller, do you have a copy of the notice? Is that attached to that affidavit? The notice itself that was sent, that was published?
Yeah.
Is that the best we got?
Right.
What is that exhibit then?
Yeah, that wasn't identified as a separate exhibit. We, pursuant to regulation, we filed the return proof with the board, but it wasn't identified as a separate exhibit.
And this is attached to the exhibit you're referring to right now, which is what number?
Yeah, it doesn't have. Yeah, it's filed of record, and it doesn't have an exhibit number on it. I'm sorry. We can go back to the first page if you would.
I'd just like to be able to have it so I
Right.
could clarify what the notice says.
Yeah. Yeah, we submitted a notice of filing affidavits of publication with the board secretary,
And what date was that filed?
and we submitted that. Go down to the on the 23rd of September, together with, in addition with the proof of publication, together with a copy of the notice that was published.
Okay, that'll help us find it. Thank you, Mr. Chairman, for that, allowing that interjection.
Thank you.
Sorry for the confusion on that. just to reflecting on the publication with the Salt Lake Trib and Deseret News, what was the period of publication? I realized that we stopped and started a couple of times, but the 2-week period was, could you describe that, Mr. Gallegos?
Yeah, it was published for 2 consecutive weeks, and that was between August 28, 2016 and September 13, 2016 in the Salt Lake Tribune and the Deseret News.
And those are daily papers?
And then published once a week for 2 consecutive weeks on September 6, 2016 and September 13, 2016 in the Uinta Basin Standard.
Which is a weekly paper?
Correct.
Yeah. The board, to clarify, the board may recall, the board chairman, that we sought leave to publish and then amended that twice. And so we're talking about the ultimate 2-week period for which publication was given. There actually was a prior publication, and then the notice was revised on 2 occasions, just to clarify.
So noted.
I'm going to go to the estates. Mr. Gallegos, I've put up in front of the board paragraph 14 of the request for agency action in this matter, in which a number of estates were identified in each of the drilling units. Are you familiar with the information about those estates?
Yes.
And would you describe that for the board?
Well, these were estates that have not been probated.
Right. And how did you identify their existence?
This was through the title opinion.
That were rendered in the spring of 2016?
Correct.
And is this the list of estates for each of the 2 drilling units?
Yes.
And is it your Axia's request that the board include these estates as subject to the force pooling order that you're seeking?
Yes.
And with these estates, the individual's name of the decedent was included in the published notice to unlocatable parties, is that correct?
That is correct.
And again, is that a copy? Well, I guess we don't have an exhibit list on it, so anyway. Yeah. I'd like to go to the JOAs. Okay, Mr. Gallegos, I'm now directing your attention to Exhibit F that was filed with the board. Would you describe it?
Yeah, that is the operating agreement that was attached both to the well proposals to the working interest owners and attached to the offers to lease and participate to the unleased mineral owners.
And to which drilling unit and lands does that apply?
Sections 29 and 32, 2 south, 1 west.
And then was a similar JOA prepared and provided to interest owners on a drilling unit for 28/33?
Yes.
And with the exception of the identification of the correct lands, drilling unit, name of the well, and the owners, are the terms of the 2 joint operating agreements the same?
Yes, they are.
And so we're going to have you testify regarding the terms of Exhibit F, but that would apply equally to the JOA for the 28/33 drilling unit?
Yes.
Okay, which is, I think, is reflected in Exhibit G, but we won't go through that at this time. Okay. Are you personally involved in Axia's negotiations involving JOAs?
Yes, I am.
Okay. And are you seeking the board to adopt the terms of the JOA to the extent that terms are covered by the force pooling statute in Utah?
Yes.
Yeah. In your regard, are the JOA terms and conditions reasonable and customary for the Uinta Basin
Yes,
and fair for all parties?
yes.
Could you briefly summarize some of the key terms of the joint operating agreement?
Yeah, I guess some of the key terms, the big one is the non-consent penalty, which under the JOA is 100% on surface and then 400% on all downhole operations. It also provides for an accounting procedure, which is important because that governs the allocation of costs and expenses from date of first production.
So the JOAs provide for a 400% non-consent penalty.
Correct.
To the extent the terms of the JOA would apply to non-consenting owners in one of the respective drilling units, do those terms conform to normal industry standards, customs, and practices in your experience?
Yes, they do. I've seen them vary from 400 to 300, but any more, 400 is very much the norm.
And the other terms and conditions are customary in the area?
Yes.
Now, the JOA has the 400%, but in this pooling procedure, we're seeking an order from the board imposing what level of non-consent penalty?
On the first two wells, 300%.
Yeah.
And that'd be the first well in each drilling and spacing unit.
And those are the two wells that have been defined by Mr. Sayer?
Correct.
Yeah, earlier. Yeah. AXI is requesting the board to approve an interest rate that would be imposed on outstanding costs and expenses incurred in drilling the respective well in each of the two drilling units. What is that rate?
It'd be prime plus 3.
Is that reasonable and consistent with the JOA?
That is consistent with the JOA, yes.
And in your experience, is that customary under current conditions in the Uinta Basin?
Yes.
Okay. We need anything else? Okay. Okay. Now let's go to. Okay. We're actually making good progress, Chairman. I'm sorry. It's a little tedious, I agree. Okay. Now I'd like to direct your attention what has been filed as Exhibit H. Do you recognize it?
Yes, I do. Is this for me or Rick? Oh, sorry.
We're going to have, I'm sorry, we're going to have Rick.
You recognize it? I recognized it.
We
recognized it.
We've got numerous witnesses who recognize these exhibits. Excuse me. Yeah, okay. Excuse me. Mr. Gallegos, do you recognize Exhibit H?
Yes, that's a cost estimate. I gotta see which well. I can't tell which well falls from here. Let's see. Oh, yeah. Yes, that is a cost estimate for the Butcher Butte 32-144H-21 well.
Yeah.
And it's a cost estimate to drill and complete the well.
And it's entitled Authorization for Expenditure?
That is correct.
And is that commonly referred to as an AFE in the parlance?
Yes, it is.
Okay. And this applies, as you said, to the Section 29-32 drilling unit?
Yes.
And was a similar authorization for expenditure sent out for the drilling unit in 28/33?
Yes, it was.
And that's Exhibit I?
Yes.
They're reflected. So refer back to Exhibit H, but are the terms of the AFEs essentially the same, although the costs vary by well?
Yeah, basically, it's terms are the same. However, the costs do vary. We're drilling to two different formations, so yeah, you have a variance in cost.
And so, do these provide all of the cost estimates of all the costs of drilling the respective subject wells?
Yes.
Yes. Did you provide a copy of either Exhibit H or Exhibit I to the respective working interest and mineral interest owners in each of the respective drilling units?
To all of the unleased mineral owners and then to all the working interest owners.
Thank you. Do these AFEs provide to each unleased owner that owner's share of the expenses, in
No.
proportion to their ownership interest?
No, the AFEs do not. That was set out in the letter.
In the letter
Yes,
that you previously testified
that's
to?
correct.
Okay, thank you. In your experience and opinion, are these costs consistent with Axia's experience with drilling similar wells in the vicinity?
Yes, similar the first well, yes. Mhm.
Okay. Now, go to Exhibit J. What's Exhibit J? That's the. Okay. Now, calling your attention to Exhibit J, entitled Authorization for Expenditure Remedial Workover. Do you recognize it?
Yes, that is a cost estimate for the plugging abandonment cost associated with the Butcher Butte 32-144H-21 well.
Yeah, and so what do those costs include in general?
Mr. Chairman, I'd object to the, I guess he can testify as to what it includes and whether he sent it, but I assume he's not the expert or the witness that would have the expertise as to what was involved in preparing this exhibit. Is that right, Mr. Keller?
Yes.
Okay, so I'll withdraw the objection.
That's a good point. We'll get to that. I think the key question so this covers the AFE for plugging and abandoning the well.
Correct.
And in this case, Exhibit J is the plugging and abandoning AFE for the Butcher Butte 32-144 well, correct?
Yes.
And Exhibit K, are you familiar with that?
Yes.
And what is that?
That is the cost estimate for the plugging and abandonment of the Butcher Butte 33-34H-21 well.
And that's in the other drilling unit, the 28/33 drilling unit.
Yes.
Right. Were these AFEs sent to all of the interest owners?
Yes, they were.
Yes. Respectively for each drilling unit.
Yes.
Right. Okay. Now, I think we go to Exhibit L now. Okay, now directing your attention to Exhibit L, Petitioner's Exhibit L, filed in this matter. Do you recognize it?
Yes, I do.
Was this prepared by or under your direction?
Yes, it was.
And what does it describe?
This basically is the computation for the average weighted acreage royalty for those owners that have chose not to lease or participate in the various wells.
Mm-hmm. And so which well is it? This is the... Yeah, so this Exhibit L relates to the interest owners in the 29-32 drilling unit?
Yes.
Yeah. And did you make the calculation?
I supervised the calculation.
Okay, so the calculation was prepared under your supervision or direction?
Yes, it was.
Yeah. And basically, how do you calculate the acreage weighted average landowner royalty for each drilling unit?
Go back to the last slide and so I can walk you through it. Yeah. I don't want to bore everybody here, so I'll try to walk you through the spreadsheet here. But essentially, what we do is we look at the total leased acres, and then we do a weighted average, which is based on the net acres of each party relative to their royalty interest. And from there, we take their net acres divided by the total net acres within the unit that are leased, which gives us a participation factor. We divide that by their particular royalty rate, and then we do that for each party, and then the cumulative of it is what turns out to be the weighted acreage average royalty for the unit.
And for the 29-32 unit, what was the calculated acreage weighted average landowner's royalty?
17.025%.
Oh,
You have to blow that up so I can see
does
better.
this relate, are there any, does this just for the fee lands?
Yes, this just pertains to fee lands.
Yeah, are there any other lands in
Yeah,
these
there are
dwelling
some.
units?
There are also some state lands within those units.
Right. Are there any federal lands?
There are no federal or tribal.
All right. Now, referring you to Petitioner's Exhibit M, do you recognize it?
Yes,
And what does it show?
that is simply the calculation for the weighted average acreage royalty for sections 28 and 33 in Township 2 South, Range 1 West.
Yeah. And was this prepared by or under your direction?
Yes,
And was it prepared in the same manner that you described
Yes.
for Exhibit L?
yes, the computations are the same.
Right. And so what was the calculated total acreage weighted average landowner royalty for fee ownership in the 28/33 drilling unit?
17.95%.
Okay, as shown on the exhibit
Yes.
M. Yeah. Now, referring to the exhibits we reviewed during your testimony, you're familiar with all those exhibits and their contents?
Yes.
Right. Oh, on the, which one's that? Oh, we skipped that? Well, that's good. We need to go back to the, excuse me, Mr. Chairman. Yeah, I wanted to back up quickly, referring you to Petitioner's Demonstrative Exhibit 4, and I wanted to, I'm not sure I covered this, with regard to, again, the right-hand column on Demonstrative Exhibit 4, entitled Source. It references a variety of exhibits, Exhibit GG through UU, WW, and XX.
I don't see those. We have HH.
Yeah, and then down
Oh, I see.
below there's GG and OO. Excuse me, it's a little confusing, I agree. And you testified, drawing your attention to those exhibits. What do they include?
Well, they include an AFE and a offer to lease
Or to participate?
or to participate.
To
Correct.
each of the corresponding mineral interest owners?
Yeah, along with a JOA as well.
Right, yeah. And I think that's all we wanted, just confirm that those exhibits covered those offer letters to those individuals in the 28/33 drilling unit. Now, referring to the exhibits we reviewed during your testimony, were you familiar with the exhibits, including all of their contents?
Yes.
And were they prepared by or under your direction, with
Yes.
the exception of the AFEs?
Yes, the AFEs were not, neither were the for plugging or drilling and completion.
Right, exactly. But all the other exhibits were prepared by or under your direction?
That is correct.
Yeah. So, which are so we will we'll move for admission of all the exhibits. We'll cover with the AFEs again with Mr. Sayers.
Yeah, let's do that. We'll just wait to the end.
Okay.
And then,
Yeah. Sorry for all the confusing exhibits.
unless it would facilitate any discussion on those, That's a lot of exhibits for one witness. Just a little advice or thoughts on that division?
Mr. Chairman, I would like to discuss at a break perhaps the demonstrative exhibits. In my opinion, they're probably not, they should be part of the record, and I'd like to just discuss that with council before I make that motion.
We wouldn't object to that. We were trying to find a way to organize all the information, given
I
the
think
fact
it's very helpful. Okay.
that the filed exhibits consumed over 400 pages to get everybody's letter and AFE and JOA and everything. So, anyway.
Okay. All right, then we won't have to have that discussion.
Right. Yeah.
All right, so
Yeah, I think we're finished with Mr. Gallegos, unless Mr. Alder has any questions of
we'll
him.
go to the division now.
Could we have just a few minutes? We do have quite a few questions for Mr. Gallegos, and I just want to make sure that I'm covering the points the division would like covered as well.
Fine.
You pass the water. Well costs. He was also going to talk about our request to apply the order to future wells, which we were putting to the end. But that's basically the testimony that we have additionally.
I think
for your timing, and then of course.
I think for our purposes, we'd like to bifurcate that just a little bit.
Okay.
And go through the conventional force pooling part of this and the questions, and then come back and reserve the right to come back to him for then the next part of it.
Okay. Either way,
we'd like to compartmentalize the force pooling for the present wells.
I just wanted to let you know what additional evidence we were contemplating for timing purposes. Excuse me.
And we'll probably take a break around noon, depending on where you are, or a lunch break.
Yeah, I don't think it'll take very long to go through the well cost information, but Mr. Alder has questions.
Yeah, let's go through the questions for Mr. Gallegos.
Okay, thank you, Mr. Chairman. If you're ready to go on the record. So, Mr. Gallegos, let's start with just going through some of the testimony in the order that you presented it. And if you could turn to Exhibit D for me. Okay, oh, excuse me, I guess the following exhibit, Mr. Chair. There we go. So that is exhibit which? That's Exhibit D2, right? Page 2 of Exhibit D. So you said that for these tracks, you had title work done by a licensed attorney?
Correct.
And when was that licensed attorney commissioned to do the title work?
They were commissioned, my recollection on this, the abstracts were completed in the latter part of April, on some and some on March, and they all differ because we got people out there that are compiling these abstracts, and then they give them to the title attorney who does the opinion. But in general, the abstracts all came in kind of in that April-May time frame, and that's when the title opinion, they were working on those opinions as soon as they received them.
And what does the abstract contain?
The abstract is it's all the documents that pertain to the mineral interest in those two sections. So it is a chronological order of every single document.
From the BLM to the present?
Yeah, from inception to present.
I guess it's federal government rather than BLM.
Yeah.
Okay, and you received a final report of some sort in April, did you testify?
Yes, I believe April on some and it was May on the other. There were 4 different sections here, and they all came in at differing times.
And so would there be one title opinion for each tract?
That is, no, there's one title opinion for each section.
For each section. That's the infamous, they have to add up to 1. Right?
That is correct,
okay.
yeah.
And so for each of these tracts, what is the basis of the tract?
The basis of the tract is differing mineral ownership.
At what time?
I'm sorry, what was the...
At the present?
Yes, at the time that the title opinion was rendered.
Okay. So for each of those colors, there's one mineral owner.
No, it's just a differing mineral ownership, not one mineral owner. You could have, within some of those colors, there's 30 mineral owners, possibly.
But they all have the same source of...
That is correct. They have common ownership.
So would there be one lease for each of those tracts?
No, within the tract, you may have 30 mineral owners within a tract, so you have to have 30 different leases.
And have you determined the percentage of ownership that Axia has leased in each of those tracts?
I can tell you what we have within the drilling units. And I do have that information. I don't have it readily available within the tract, but I can tell you what it is we own in the drilling unit, and the title opinion does have that information. It's very long.
Okay, but for each tract then, partially leased or not, depends on the status of the negotiations, I guess, for each of those tracts.
Yes, and as I testified to earlier, I believe in one of the units it was almost 99% of the entire unit was leased, and in the other, over 99% of the drilling unit was leased.
So that does raise a question that I tend to get to later, but would you clarify right now, what is the difference between leased and then on your exhibit, demonstrative exhibits 1 through 4, what do you mean by in negotiations? The lease itself, is the lease final?
Yes, when I was speaking to that had to do with just the exhibits that were addressing working interest owners only. And as you will note from the exhibits, Exhibit 1 is just a list of working interest owners, which means that all of those interests are under lease. And Exhibit 2 was unleased and non-participating mineral interest owners. So that is the computation of all the unleased mineral owners.
And again, the same thing on Exhibit 3, then you have the working interest owners in negotiation, and then the next page is
unleased. Yes.
For the other drilling.
So as to the leased, what does in negotiations mean?
Well, that means I'm in negotiation not with any of the mineral owners, with the mineral other working interest owners, lessees that own those leases. So that's who I'm in negotiating with. It's other industry partners is what it is. Really, that's not individuals per se. It's other industry partners.
Does that make sense? I'm really a little unclear about this is why I just did the regulatory side. What is the difference between that? Can you make it clear for a lay person? Or maybe Matt wanted to explain it to me.
Yeah. And I'll go through like Exhibit 1 again. That is all of Exhibit 1 represented there. All the interest there is under lease. It's all under lease.
Right.
And the parties that I'm in negotiating with, we own 57.66% of the leases in that drilling unit. And then the other parties represented there, they own the other leases in the percentage set forth by their name.
Right. So you're negotiating with them on, and they represent they have the leases.
That is correct.
So, go ahead. So is that lease fixed, or do they have the option to lease to you?
No, that lease is fixed.
Okay.
There isn't, yeah.
And would the lease fix the royalty then for each of those?
That is correct.
So the royalty's not subject to negotiation?
Absolutely not. The royalty, anything that is under lease, the royalty is set. So the only ones that would get these weighted average royalty that we referenced earlier in our testimony would be these unleased and non-participating mineral owners.
Okay. And is the JOA fixed by the lease?
No, the JOAs are subject to negotiation. Once the JOA is executed, it's fixed. But until that point, it's subject to negotiation.
So certain things like that you testified were included in a JOA, such as the penalty, and the interest rate, those things are subject to negotiation?
That is correct.
And so for those people that are listed there, is the penalty part of the negotiations that you're discussing with some of those parties?
In all cases, there's none of them in which the penalty is a negotiation issue.
Okay. What about interest rate terms? Or is that part of the JOA negotiations?
No, that is not.
So is it just whether or not or how they pay their share of the money?
A lot of these parties that I'm talking to, I am actually talking to them about doing some kind of an arrangement to acquire their interest in this well. And the parties that want to sign the JOA, and I'll lead you to Crescent Point, the issue that we have with them on the JOA that we're discussing, and the only issue is the gas gathering portion of it.
So when you acquire their interest, you essentially become the lessor?
Essentially the lessee, that is correct. Subject to the terms of the underlying lease.
So pretty soon you're going to have this well close to production.
It'll probably be November when that happens.
When do you anticipate concluding your negotiations?
We sometime before that well is completed.
I kind of thought that might be your answer. We may have more questions about that, but as to page 2 on that demonstrative exhibit, that's just kind of a good one to work from. You gave notice by publication, and Julianne was kind enough to provide us a copy of that. To your knowledge, what did that notice by publication provide the people to whom it was directed? What was the notice of what?
Well, it provided a notice of the RAA that had been filed.
Okay. Anything else?
Yeah, as well as the opportunity to participate.
Okay.
Or lease.
I don't know if I asked you, but did you update the opinion that you used in April to July 18th?
What we did is not to July 18th, but to July 1st, when all those proposals were sent out. The opinion was rendered it was rendered prior to that July 1st date. So what I did is I put a landman in the field to go make sure that nothing else had been recorded subsequent to the rendering of that opinion that would change the interest in any way.
Okay.
And we did that up to that July 1st date when we sent out the notices and well proposals.
Okay. You provided Exhibit BB, I think, as an example of one of the notices that went out. Could we pull that up on the screen or refer to that exhibit for your testimony? So what is that exhibit again? Could you describe Exhibit BB?
Okay. Is that it right there? Okay. Yeah, that is just we send our well proposals and offers to participate by certified mail to ensure that the parties receive them. And this is simply a signature page from the party showing that they did receive the documentation.
And I can't see a date on that where that one was received. Do you know the date that was received? Is that on any other exhibit?
Yeah, it's on there.
Yeah, there's a date of delivery there, and from here I can't read it either, but there is a date of delivery.
Where is that?
No, there is a date of delivery.
It's right after her name.
Yeah.
No. Populate field.
Oh, is it?
Yeah,
No.
her name printed into the date of delivery.
Yeah.
Okay. Oh, it is. Yeah, that's right. Her name was printed over that.
Okay.
Yeah, I guess that one doesn't have it on there.
Sure.
All right. So there are others that do have the date. I just didn't know if it was somewhere, if you had another exhibit for that particular person.
I don't believe we do for that particular person.
So leave this one up. This was one I did want to ask
Which
about.
exhibit is this?
This is CC.
So this is Exhibit CC. Does that show a date of delivery?
Yeah, it's got the July 8th. Looks like July 18th is, or 8th. Maybe that's 8th. I can't tell from here.
Okay, looked like 18th to us. If it is the 18th, if it's the 8th, either way, did the letter that went with this require their response by August 6th? Is that what you said, or August 5th? What was the date?
The letter that went with it asked for their response by the 5th, but we have actually taken other leases well after this date, and if anybody would call me today and say, I want a lease instead of being force pooled, up until that order's issued, I'm fine with honoring what we sent out, and we have. We've entered into some leases that were subsequent to that date.
And what if they didn't want to lease, but they wanted to participate?
Same thing. If someone wants to participate, if they sign the JOA and they'll give me an election to participate prior to the date of when the order is issued, I'm glad to let them do so. Okay. We're not trying in any way to prevent anybody from leasing or participating.
And you've received no request by anybody for additional time or responses after August 5th to lease, or have you?
We received responses from parties that did want to lease and send their paperwork in after that, and we've entered into some leases after that date. And as I say, we would still enter into a lease with any of these folks should they want to before the pooling order is issued, or allow them to participate.
But your letter doesn't say that, does it?
No, the letter doesn't say that. We do ask for a response by August 5th, just because we have to put a date on there. We can't leave it open-ended.
Okay, and additional people who were to lease that could modify the average royalty.
Yes, that would modify the weighted average royalty calculation. Very minimal, though, because if you've got 99% that are leased and you lease out to another 0.01, it's going to have very little impact.
Okay, I wasn't clear on your testimony about the effective date of the pooling order. Maybe this is a question for your attorney, but what's your understanding of the effective date of the pooling order?
The date of first production.
Okay. But you would include all of the costs in this well from spudding on, I suppose. And
well, yes, and any cost associated with the well. That is correct.
Okay. What was, I guess, is someone else going to testify as to the reasons, or do you have an opinion as to the reasons that a 300% penalty is appropriate for these
Yeah,
non-consent?
I'll probably defer that to Adam.
Okay.
I will say that based on my experience, that 300 was very consistent, but as of the last 5 to 10 years, that number has jumped to 400. And I will let Adam address the technical merits of it.
Okay. As to the reasonable efforts that you made to locate all owners, as to the unlocatable people, can you give us more testimony as to what efforts were made by AXIA to give notification? For example, if you got a return card that said they were not at that address, what would be the actions that AXIA took typically?
Well, we, in addition to what the abstract that was built for the opinion, which should capture everybody's addresses, but
Okay,
we've got a
but for the record, that is built from the public records.
That is correct.
So
and
nobody
then
at the attorney's office went and did a Google search.
Well, no, what we did do is we went back and we did a grantee search on a county-wide basis when we did not receive these. When we found out that we had some people that we just couldn't find through the abstract and the title opinion, we did a grantee search on a county-wide basis to see if we could come up with these addresses.
And that would have been done by the attorney prior to the title opinion then?
No, that was done after the opinion,
Okay.
because the opinion did not furnish us with an address.
Okay.
So that's what we did. And then I had our land brokers as well do some work on the internet to see if they could find these folks.
Who are the land brokers?
The land brokers, Green Shell Energy.
Have you worked with them a lot?
Yes, I do.
Do you know what they do?
As
far as trying to locate people, what efforts specifically?
I'm not exactly sure what they do, because I myself did not do that.
Do they get a bonus or benefit for locating somebody?
No.
Okay. So as far as we know, you had somebody, Green Shell did some work, but you mostly located addresses from the public records and then sent these letters to those addresses.
Right. And we not only, because these addresses were not found within the title that was done in the drilling units, we did do a countywide grantee search as well.
Some of the letters appear to have been sent to addresses that were out of state. Do you know if there was any effort to do a Google search for those people in those states?
I can't tell you exactly what the effort was.
Okay. But you did file an affidavit requesting notice by publication. Was that prepared by your attorney?
That was.
Do you know if it detailed any additional efforts besides the failure to reach them by mail?
I am not aware of that.
Okay. I think that's all I have, Mr. Chairman.
Board members, any questions for this witness? Back to you for follow-up questions, and then we're going to break for lunch. Oh, you did have a question? Sorry.
In calculating the weighted average royalty, do you include the leases that the joint, or the like Newfield and the other?
Yes, we include every single.
So they give you that information in order to calculate it?
Yeah,
okay.
we include every single lease in the drilling unit.
Good.
Yeah, it comes from
on the
title.
2833 well, the total acres 828 acres. What's the difference between that and 1280? Is that
the state lands?
State lands, okay.
Two things: any unleased lands, because they would not be in that into that 1280. So we subtract unleased lands, and then the state lands.
Okay.
And in the 2833, there is a big state component. If I remember right, I think it's at least 200 net acres.
Newfield has a large interest in these two wells. Did they provide any expertise, anything about as you've drilled these wells? I mean, did you solicit? Just wondering.
Not that I'm aware of, and that's something that Adam could answer better than I could. But I just did want to point out that Newfield is a huge working interest owner in both of them, and we've had conversations with them relative to what we are doing with the pooling order, and they've had no issues or obviously filed no protests. So we're working with them currently.
Okay.
Newfield did file a response, though, in this matter. They had no objection. Is that correct?
That is correct, yeah.
Okay, thank you. Back to you, Mr. Keller, for any follow-up questions, and then we're going to take a lunch break.
Yeah, just one quick question regarding the process of certified mail. Are you familiar with how the process works,
Yes.
Mr. Gallegos?
Yes, I am.
And so when someone receives a letter at the post office addressed to them and then they're notified, when does the return get signed?
No, not immediately sometimes. It takes, sometimes that'll hit the post office and it'll stay there several days.
So the individual has to come down and sign for it, and that is, pick it up, and that is the date that they receive
That's
it.
correct.
Okay.
And whose responsibility is it to get that date on that return? Is that the post office? Like that one we saw didn't have a date. Is that just the post office didn't?
Yeah, generally
do their
it's,
job?
it's stamped by
Yeah.
the post office.
Yeah.
Or if it's delivered to the home, a lot of times where it says date of delivery, they will have them sign for it and date it. And date it both, but in that case, they had them sign for it and they didn't have them date it. Yeah.
Okay. Any more questions?
Not of this witness.
Then we're going to take a break till 1 p.m.
Okay.
And we'll meet you back here at this time.
Thank you.
Thank you.
Thank you.
Yes, Mr. Chairman. Mike Keller for Axia 2.
Hey, we're back on the record.
Yes. I had a request. We wanted to bring back Mr. Gallegos. I know I told that we were finished, but there were a couple of little items I wanted to cover. I discussed it with Mr. Alder, and he might have a couple of additional questions, too, of Mr. Gallegos before we get to Mr. Sayers.
Proceed.
Mr. Gallegos? We need to get close to our microphones here.
Yeah, we have a system where we record as well as have a court reporter. So if you're not speaking into the phone, you'll get or into the microphone, you'll get reminded.
Right. I wanted to address a couple of things. In your earlier testimony this morning, there was an interchange with you and Mr. Alder regarding the unleased mineral interest owners and the offer that was made to them, which gave them roughly 30 days plus, but had a date of August 5th by which they should consent or not, or they would be subject to forced pooling proceeding. And you said you'd be, I believe your testimony was that, you know, we would continue to accept those lease offers. Would you like to comment on that, and did you have a correction?
Yeah, what I did, I said that we'd accept any leases, or we'd honor any leases that we sent out to go ahead and lease before the forced pooling order was issued. But in further discussions on this, we realized that if we do that, we would have to really essentially cut it off today, or we'd have to completely come back here to redo the weighted average royalty calculation. So I wanted to make that point.
Yeah.
And as it applies to the working interest owners, that's still anything before the order is issued, we're fine doing anything with them prior to that.
Yeah. And that, with regard to, does that clear that up, I hope? In other words, that we'd probably need to close off with today's date leasing to unleased mineral interest owners, that they would need to be forced pooled, and we'd need to determine that as of today's date.
I think we understood that.
Okay.
But
we were
from our past hearings.
Exactly. But we were concerned that.
But I'd like to have Mr. Alder address that.
Mm-hmm. Yeah, we did have a question about that, because if you look at your demonstrative Exhibit 1, and just for example, and the people that you're in negotiation with, if those negotiations are not successful and they are force pooled, then wouldn't the royalty rate be the royalty rate determined by the board in this hearing? Or would it be the royalty, or is that royalty rate established by the existing leases?
That royalty rate wouldn't change at all, because there was already a royalty rate established under the leases to those working interest owners.
So force pooling would not supersede that? The
The
force pooling order?
No, the force pooling order would not impact the
Working interest owners.
lessors at all.
Fees.
Well, if the lessees were force pooled, it wouldn't impact the lessors, the folks that granted the lease. Yeah.
And so, in other words, the royalty under those leases to the other working interest owners was factored into your calculation of the acreage.
Yeah, that's already been factored in, and that doesn't change at all.
Okay,
Yeah.
thank you.
That would have no impact.
Now let's go back to the. Okay, the other point we wanted to address was there were some questions about efforts to contact people and the affidavit support for the motion for publication by service by publication. And we've put up for the board's attention the affidavit that supported the ex parte motion. And is that the revised one, or is that the original one? This was the original motion. We supplemented it, but the affiant was Rick Madison, not Rick Gallegos. And would you explain to the board who Rick Madison is?
Yeah, Rick Madison is a land broker with Green Shell Energy, and they work for Axia 2 on this project.
Yeah, and so did he work under your supervision
Yes,
and direction?
he did. Yeah, he was doing all this under my direction.
And did you direct him to make efforts to contact people?
Yes, I did.
Yeah, okay. So that was all I had.
Any board members, any questions of Mr. Gallegos. I need to disclose that I did, during the lunch break, have I saw a friend in the audience and had a discussion and was told some things. I think I just need to make you aware that a lessor was here. I don't know if you want to say the same things again, but I feel like it was outside of the normal hearing, and I needed to disclose that. If you'd like her to repeat it, it's up to you, but I just want to make sure you were aware of that.
I think we appreciate your disclosure, and I have no objection.
Okay. Then we are, I believe, back to Mr. Sawyer.
Mr. Sayers, yeah. I'd like to recall Adam Sayers.
Sayers.
Sayers,
Beg your
excuse me.
pardon.
It's okay.
Let's get Exhibit H. Okay. Mr. Sayers, I'm going to show you what's been marked as AXI Exhibit H and put it up on the screen. Could we enlarge the first page? Do you recognize it?
Yes, that's at our AFE, our authorization for expenditure for the Butcher Butte 32-144H-21. It's our cost estimate for the drilling and completion and equipping of that particular well.
Right. And are these costs consistent with Axia's experience with drilling similar wells?
Yes, they are.
Would you discuss with the board the nature of the risks involved in drilling the 32-144H-21?
Yes, certainly. The risk predominantly is in relation to the cost of the well. You can see here we expect to spend just over $13 million on this particular well. It's well documented, the amount of resource in place here. We've spent a lot of time on our spacing exhibits talking about the amount of control, the well log data, the core data, and probably most importantly the well performance that we've seen near here. In the same sense, this is the first well drilled within that unit horizontally, and so what we're trying to do is drill a 2-mile lateral and obviously achieve over 1 million barrels here for expected results. So that really the risk lies in the amount of dollars that we're expending on this particular well.
Was this AFE in Exhibit H prepared by or under your direction?
Yes, it was.
I see. And is it a customary AFE, and including the elements that are customarily included in an AFE?
That's correct.
And you want to put up the Exhibit I? Yeah. Now I'm refer your attention to Exhibit I. Actually, Exhibit I. Would you describe it?
Yes, this is an AFE or cost estimate for the drilling, completion, and equipping of the Butcher Butte 33-34H-21.
And was it prepared by or under your direction?
Yes.
And what does it show?
It shows our estimated cost to be $13,500,000 for the drilling completion of this particular well.
This one's.
What?
This is the second well.
Yeah.
So it's,
What did I say?
it's 13. It's
Go down.
yeah.
Yeah, you're not
Yeah.
scrolled down all the way.
Right. Okay.
Yeah,
Yeah.
$13,548,000.
Okay. Are these costs for the drilling of the well, in your view,
It's for
consistent with your experience?
It is.
Customary?
It is consistent with our experience.
And is your testimony with regard to the 33-34H-21 the same in regard to the nature of the risk involved in drilling a well, or are there different risks with the second well?
It's very similar. Again, we have good control around the area in terms of documenting the resource. It's a matter of getting the oil out economically, and like the previous well, our Uteland Butte well, we are completing it a little bit differently. We're spending a little bit more money doing some different things, and so we have expected increased performance. And so, but again, the risk lies in the fact that we're spending a lot of dollars here.
Yeah. What is the risk compensation non-consent penalty that AXI is requesting for the 32-144H-21 well and the 33-34H-21 well?
300%.
And what is your basis for that?
Just given the amount of risk here that we're seeing, we feel that's customary and current day practice. Yeah. Now, in your opinion and experience, are the requested 300% non-consent penalties for these wells reasonable, appropriate, and warranted? Yes.
Based on the costs and risks?
Yes.
Yeah. Now, we have discussed with Mr. Alder and earlier with the board chairman about addressing future wells. I would like to just have Mr. Sayers explain why we have making that request. We won't go into lengthy testimony on it.
Let's finish the cross-examination as
That's
to
fine.
this, and then we'll start that phase of it.
Oh, excuse me. Yeah. Let's, excuse me. Yeah, I need to refer your attention to Exhibit J. And what is this?
It's a cost estimate for the plugging and abandonment of the well if it doesn't work, and this is for the Butcher Butte 32-144H-21.
And is the elements of this AFE customary in the industry in the Uinta Basin?
Yes.
And what does it show?
It shows the cost to plug and abandon the 32-144H and the total amount of $196,500.
Mm-hmm. Okay. Was this prepared by or under your direction?
It was.
Yeah. Okay. Now let's show the other one. Now I'm referring your attention to Exhibit K. And would you describe it?
Again, this is an AFE or a cost estimate for the P&A for the Butcher Butte 33-34H-21.
And when you say P&A, do you refer to plugging and abandoning?
I do.
And is this AFE a customary form used in the industry?
Yes, it is.
And what is the estimated total cost for plugging and abandoning the subject well?
$196,500.
Yeah. And in your view, is that cost estimate reasonable in the Uinta Basin?
Yes, it is reasonable.
Yeah. I think that's all we have on this, other than having him address sort of their perspective on future wells.
And so what I'd like to do is have a cross-examination, board questions, admit what exhibits you want to have admitted at this point. We're going out of, I told you we'd do it at the end.
Right.
We're doing it at the end of this compartment. And then if there are other exhibits that go to his next stage.
We don't really have an exhibit, and it was more just testimony.
So we could pretty well take care of all the exhibits now
Right,
while it's
yeah.
fresh on our mind. Okay. Mr. Alder, do you have any questions of Mr. Sayers?
Yes, we have a few questions about the AFE and the plugging and abandonment costs. If you could turn to the exhibit, and I apologize, I don't know the number for the AFE for either of the wells.
Which one's this?
H.
For plugging and abandoning?
No, the AFE
Drilling.
for the drilling. Yeah. When was this prepared?
I don't know the exact time when this was prepared, but early summer, June.
It's got a date on it. It's dated.
Does it have a
Yeah,
date?
it looks like June 28th,
2016.
2016. Thank you.
So was this prepared in anticipation of being sent to the people that, I guess the notice was sent out to on June 30th? Or?
I would have to refer to Rick as to when the notice was sent out.
Was this prepared for your engineering department or your construction department?
It was prepared by my engineering and construction department in anticipation for Rick to send out to owners.
And is this an actual in-house budget? I noticed the version I got was not signed. Does it
Yes.
require signature?
Typical procedure for us is to sign that, yes.
Is there a signed version of this AFE?
Yes, there is.
So it's been approved by who approves it in your office?
I do.
Okay. And how does this work relative to other owners, like, for example, Badlands Energy that's in negotiations with you? If it turns out that the costs are less, will they pay the lesser amount?
That's correct.
And if they were to join, they would have to pony up the amount of the estimate right now, though.
It depends upon, that comes under, I'd have to refer to Rick, that comes under the JOA. Those things are negotiated whether, you want to make sure an interest owner in any business situation is capable of paying their proportionate share if they elect to participate. And so what's been standard practice for us is when we get prepared to drill the well, we call just the drilling dollars at that particular time.
Okay. And to your knowledge, have any of these people who are listed as in negotiations paid any of the drilling dollars for these wells?
Well, no, if it's still in negotiation, they still haven't decided to participate for the well.
So the decision to participate is not based on just the JOA. They're also negotiating the price, or if they're negotiating the JOA, I'm just not sure how it works.
Well, so sure. Any business negotiation. Look, we if we have partners in this particular well, we have people that are deciding whether or not to participate or not. We present to them what we believe to be the cost of the well. Then what they would do is, in a normal procedure, call us and talk to us. What are you going to do? How are you going to drill this thing? It's not a cost negotiation. Costs are what they are. In a typical situation, when you have partners, if there's ways that partners have great ideas to save money, we'd be silly not to consider that.
So do you foresee a possibility that a proposed or negotiating working interest owner would pay the money and refuse to sign the JOA?
Yeah, I'd probably have to refer that to Rick, but I don't. I'd have to refer to Rick on that.
Okay. You are the person who has the experience in budgeting these kind of wells, I guess. So.
That's correct.
And what is your experience with drilling 2-mile-long wells, horizontal wells?
Well, we've, in our company, our chief operating officer ran Burlington Resources operations not only in Canada but the United States. At one point in time had 60 drilling rigs. Was part of the first horizontal drilled in the Williston Basin. We have horizontal experience in East Texas, the Permian Basin, the Sandwash Basin. There's experience in drilling horizontal wells in the Piceance Basin. Tremendous amount of horizontal experience.
And are you using some of the same equipment, same personnel and equipment for these wells?
Yes, we've given a brief history of Axia. We've got 18 employees, most of which have been together for over 20 years. Our drilling site supervisor has been with us since, been working together since 2000. He's drilled a lot of horizontal wells in the Williston Basin, along with our drilling engineers. So a vast amount of experience there.
And in your expectation, based on the geology, are these wells going to be any different or more difficult or less difficult than wells you've drilled, say, in the Piceance Basin?
We drilled from 2011 to 2013. We drilled 45 wells in the Uinta Basin, And we also have the ability, and we've looked at data from Newfield, which has drilled over 60 horizontal wells in the Uteland Butte, Wasatch, and other zones within the Green River, as well as Crescent Point. So we've reviewed all that data, and I tell you, we've got 5,300 feet of lateral drilled in the current well, and things are going as expected.
So of the 45 wells you've drilled in the Uinta Basin, how many of those have been 2-mile laterals?
0.
So this is your first attempt at that. But is your estimate of the cost similar to your estimate for other 2-mile laterals?
Yeah, this is consistent with other 2-mile laterals.
Okay. What is your rate of return that you anticipate for this well?
I'd say upper 20s for a rate of return at current oil prices.
Okay. Are there geologic risks associated with the Wasatch Formation that don't exist for the Uteland Butte or the other horizons that you have targeted?
There are some differences in fracturing and so forth, and in terms of there's some water. Generally speaking, the Wasatch has a little bit more water. You could always run into geohazards, which would be some sort of fault or displacement that would hurt as you're drilling the particular lateral. But I will tell you that our control around here was pretty good. To the north of us we have EP wells. To the south of us we have Newfield, and then we've got 8 wells within our acreage position that we've got a lot of control.
So you sound pretty confident about this well.
We're confident in terms of the geologic risk, in terms of the resource in place, and that's well documented with offsets. Again, where our risk lies is, I think you've seen, and the state has seen testimony from Newfield where they're drilling wells for under $9 million, and that's largely, it's not because we don't know how to do it, it's because we're taking a different approach. We are doing different things on the completion. We're drilling bigger hole. We are running 5.5-inch casing. When you run 5.5-inch casing and you drill with larger hole, it takes longer to drill the well. We're doing that so we can pump at higher rates. We're doing different phasing. We're cementing. You can see from the APD, we're cementing that long string, that 5.5-inch casing in place so we can do perf and plug, and so we can have more confidence in the placement of the fracs. All these things add up and really are the difference between the $9 to $10 million that the state has seen to our 13.5. So the risk lies in, can we make obviously Axia believes in spending this additional $3.5 million is justified by the results that we anticipate. So we anticipate better completion results than what you've seen from previous testimony. So again, I'd like to reiterate, the risk is really in the amount of dollars that we're spending.
And if someone is non-consent and the board grants your 300% penalty request for these 2 wells, then even though they have a lease or the JOA, I guess I'm not clear how that would affect whether they have a lease that provides for a different non-consent penalty.
No, leases don't contain any language on non-consent.
Just the JOA.
Correct. There's 2 items that address the non-consent penalty. One is the JOA, and in some cases, sometimes you have operators that will not sign a JOA. In our particular case, again, in the we have a unit that is 98% leased, and we have a unit that's 99% leased. So the unleased and the owners that we can't find are less than 1%. So it's leased, and so in those particular cases, what we need protection from is in the case where somebody does not want to sign the JOA. We need to be able to have, there needs to be some sort of a penalty. It's not fair to allow somebody to write it down and come in after payout.
Okay, so I sometimes get confused between the lessor and the lessee and who the party is that signs the JOA. But for purposes of the lessor, he generally grants to the lessee authority to enter into a JOA. Doesn't the lease address JOAs and the authority to enter into those?
Yeah, you have a pooling clause. Is that what you're referring
Yes.
to?
Yeah, isn't there?
Yeah, well, I'll be honest, Steve, I'm not the one to answer about a pooling clause on a lease, but Rick sure is.
Okay. That's probably all the questions I have, Mr. Chairman.
Board members, any questions of Mr. Sayers?
Oh, we didn't address the P&E costs, and I mean the plugging and abandonment costs.
You said you were going to.
Yeah, I apologize. Co-counsel here reminded me. And if I could, Mr. Sayers, and I apologize to the board, we were wondering why those costs are substantially. You mentioned why the costs of the drilling are higher than other costs we've seen, but those P&E costs are about twice what we have seen for other, or more than that, for other horizontal wells, and wondering if you could explain why that might be.
Well, my guess is a lot of the horizontal wells that you've seen are 1 mile. These are 2 miles, so you're talking about balanced cement plugs within the lateral. There's wire line costs in here to perforate at shoes and displace cement if we need to. You can see we've got location costs of $40,000. Obviously, it's a 2-well pad, so that's actually split. $40,000 for each well, so that cost was split. And so, we hope that we're not discussing P&A in this well, and by all counts and measures, we're not going to be doing this. But the costs are what the costs are, and the other thing I'd tell you is when you look at, in particular, what Newfield and others are doing, they're running 4.5-inch casing. We ran 9 5/8 to 9,300 feet, and so bigger casing, more cement, and so forth is required to plug these wells.
And just maybe for clarification, as to put that question in context, these costs will actually be the actual costs incurred, and they won't be called until you actually plug the well.
That's correct. Yeah, we would never bill for something that we're not going to go do. And I just as a reminder, Axia is incentivized, as is every other working interest owner, to keep costs at an absolute minimum. And so we would do our best to minimize those costs. But this is just an estimate and would not be called unless we were prepared to go do the work.
Okay, thank you. That answers our questions.
Thank you. Mr. Hanson? Okay, I have a couple of questions that are more for my information. They have to do with the contingencies on your AFE. So to go to one of the drilling AFEs, I've seen them as high as 20%, maybe even higher than that, but very seldom, if ever, I've seen one below 10%. And if I'm reading that right, on the first one, which would be Exhibit H, you've got roughly 400,000 in contingencies and another 300,000, which is about 5.8%.
You'd have to point them out to me. I'm sorry, I can't.
5-90.
Hey, okay.
$830-80, and then down below you have.
Yeah, I see. In both of those cases, I would have to go down and drill down on that. It's listed as other intangibles and contingencies. I would tell you typical practice for us on contingencies is 5%. Yeah.
And just for my information, the certainty,
it's a really good question. We pride ourselves in trying to be as accurate as possible in our estimates. It's very, very important budgeting wise. I'd tell you, when we look at contingencies and we put 5%. We look at this on a well-by-well basis. In this particular case, at the time that we put this AFE together and the cost for completions and the cost for water and so forth, that's very, very expensive. You can see the majority of our costs are in the water and in the completion. And we don't have agreements in place, but we are working very hard to try and get agreements that allow us to get water from cheaper sources. And so at the time of when we put this AFE together, we have to make an estimate, and we have to really live with, if we get no other deal, what would it cost us today? And so just because we set up an AFE on June 28th of 2016 doesn't stop our guys from doing everything they can to minimize these costs. And so what I'm getting at is, while we have a 5% contingency, we also, in this particular case, feel really good about our ability to lower the water costs and adjusting completion costs based on data that we're getting daily on the cores and the logging daily. So what it did in a roundabout way is it gave us a good feeling at the 5%. While that might have been a little bit tight, we feel good about two of those line items as it stands today.
Thank you. Okay, Mr. Keller, we're back to you.
I don't think we have any further testimony relative to the two wells, and I think the question about the pooling clause, we testified to earlier that the leases contained those, so I don't think we need to.
Okay, and then that'll conclude yours, and then we'll go to the division for any. So are we, that concludes your
Yeah, we will move to submit the exhibits.
Okay, let's just go to the division now. Do you have any
testimony?
So this is just as to these two wells.
Correct.
I don't think we have any testimony or questions that we're going to present.
Do you have a position, does the division have a position with regard to this component of this hearing, which is the force pooling dealing with the two wells?
Yes.
No, I think the questions that we had about the adequacy of the notices have been addressed. There's obviously always questions you can ask on that, but we think they've met a minimum burden on that, and so we have no other objections to the subject to the boards. And of course, we aren't going to make a particular argument as to the force pooling penalty. 300% is in line with other long horizontal wells that have been drilled in this area, but that's up to, of course, to the board, and it's been our practice not to opine on that unless we thought it was out of line. And I think all the other issues that are required for a force pooling order have been addressed, and so we think that the board could grant the request.
Okay. Then let's go to the exhibits, admit those, and then we'll go to the next phase.
Yeah, I'd like to move the admission of petitioners' filed exhibits A through Z.
And now, we didn't talk about some of these.
Yeah, they were.
You want to address, since they were never presented, offered as evidence specifically, but they're the same as, for all intents purposes, and materially.
Right. With regard to the exhibits that relate to the offers extended to working interest owners or mineral interest owners, and we did put on testimony, we had the demonstrative exhibit, and we can admit that too, which then summarized all of these exhibits.
That's let's do that, and then that includes them all.
Okay.
Okay.
So we would move the admission of exhibit A through Z, and double A through double X, XX, and then also exhibit ZZ. We left open YY, and if it's the division board, we can designate the affidavit of publication and the returned proof of, is it the affidavit of publication or
the return proof is ZZ.
CZ, and the affidavit of publication
We'll take administrative notice of
that, right,
of the
yeah. And then also we would...
affidavit of publication.
Right, that is part of the record, yeah.
Okay.
And then we would also request admission of petitioners' demonstrative exhibits 1, 2, 3, and 4, which reflected the working interest and unleased mineral interest in each of the drilling units.
No objection by the division to those.
Board members? Okay, all those exhibits are admitted.
Thank you, Mr. Chairman.
Administrative notice of the affidavit, I believe that's everything, is it not? Okay. All right. Now let's move to the next phase then.
Okay. In connection with our request, as the board is aware, we also requested that the pooling order be extended beyond the initial 2 wells, which have been discussed today, to the future wells in each of the 2 drilling units that were authorized by the spacing order issued by the board in cause 139-138. And I would like to call Mr. Sayers to testify in support of the request for applying the pooling order to future wells in the 2 drilling units. And again, we're defining future wells as defined in the spacing order. So those wells, subsequent wells that would be allowed subject to the setbacks, other limitations and requirements of the spacing order.
Yeah, thank you. So yeah, that does make our order or RAA unique in that we are asking for the future pooling or the future force pooling of future wells to be drilled, which is obviously unique, and I thought it would be worthwhile to explain why we think that's important. You know, the reality is when we look at this, there's a tremendous amount of costs associated with force pooling. And, you know, we put in some exhibits, and I think the exhibit showed our estimated cost was $25,000. I'd tell you it's double that. Just our publication costs alone were just under $20,000. Then legal representation is going to, you know, push us up to that $50,000 range. And so that happens every time we force pool a well. In today's day and age, when we're looking at drilling wells and so forth, we have to plan ahead. Permitting, gathering lines, all these things come into play. And so when we look at having to come back and force pool on a well-by-well basis, it becomes very, very expensive. And when you look at, in particular, this 1280, you've seen testimony from us that we believe there's going to be up to 32 wells being drilled. And we talk about force pooling on, you know, each well, that sort of cost spread out. Then, and probably more importantly than the cost is the amount of time. We are a very small shop. We're a small operator, and this takes a tremendous amount of time and effort from our technical staff. I mean, you have 3 vice presidents and a president here, so this is our team, and we are currently drilling horizontal wells, and it takes away from that. And so, and even more important is the board's time. We've spent all morning up until now talking about the force pooling, and we're not getting away from the fact that you'll need to force pool and go through the hearing on the first well in each particular 1280. I'm talking about subsequent wells within that 1280. And so when you think about Axia later this afternoon is going to present 10 more spacing units. So that brings in a total of, we have 14 spacing units, potential for 32 wells in each. We could be here doing this consistently every month, and that to me is a concern from a human capital standpoint. In the same sense, I recognize the rights of the owners, and we have to preserve those rights. And so when we looked at this, and I read Mr. Alder's memo to the board, and I apologize, I'm not an attorney, but when I read it, I saw 4 main concerns. I saw, number one, how do you how do you look at the changes in well costs over time, and how does the division make sure that the well cost is just and reasonable? That's number one. Number two, the P&A cost of the wells. They could change over time. As Mr. Alder pointed out, we're not going to drill all 32 wells in that unit tomorrow. There might be wells drilled 2 years from now, 3 years from now down the road, and it's a good observation. But again, well costs, P&A costs, how does the state make sure that that's just and reasonable? 3 is we could have changes in landowner royalty over time. Very true, we could. And so how would we address that? Then 4 is at the time that the well's drilled, how would the board make it just and reasonable in terms of the non-consent penalty? In other words, should it be 250, 300, 400%? So those are really the 4 main concerns, and I think these are all very, very solvable concerns, and preserving all the rights of those owners, and not only that, but preserving the well-by-well election that each owner has, that the state has been very adamant about. We're preserving that. So how do we do that? Well, I think we could come together and come up with a solution with a certain amount of notice. If we're going to go drill a second well in a unit that already has forced pooling, we could provide to the state our estimated costs to drill and complete the well, and the division can check the box and make sure it's just and reasonable at the particular time that the well is going to be drilled. Secondly, we have changes in costs and P&A. Same thing. When we're drilling a well 3 years from now, we can come up with an estimate of what the current day cost is to plug and abandon the well, provide it to the state. They can check the box and make sure it's just and reasonable. In the same sense, landowner royalty, it's just a calculation. All we have to do is at the time that this happens, the time we drill the well 2 or 3, we calculate what the current royalty rate is at that particular time, and that's what the unleased owners would get that are force pooled. And then 4, and this goes to the good faith. I think you heard testimony from Rick that currently most non-consent penalties that we see in different basins across the United States are 400%. You saw today that we asked for 300. That was our good faith, putting our good faith forward, saying, look, we'll take something less than 400%, but we'll have discussions on what makes sense. And so one thing that we proposed is the first well being 300%, which we talked about today. Subsequent wells that are drilled in that same target interval would be 250%. That's what we propose. We feel like, to me, to come back and argue 32 more times over whether it's 300% or 250% is a complete waste of time, honestly. And so I think there's a way that we could get a working group together, address the concerns of the state, which I recognize, and then but also help an operator cut costs. If we have to spend, 50,000 times 30, we got to spend an extra $1.5 million just force pooling interest in a particular unit. That's $1.5 million less in drilling, completing a well, or putting towards a different well. So the cost is very impactful to a company our size. More importantly is our particular time, which I think we can save. And still we can find a way to get all these 4 items addressed, and then still provide notice and publication, which still would satisfy the division. So to me, all these things and all these concerns that we have are completely solvable outside of a full-blown hearing on each particular well.
Mr. Sayers, as part of your proposal, would you describe that the proposal as it relates to making a separate offer to lease and participate on each subsequent well?
Well, I'd probably have Rick testify to that.
But is that is part of your proposal?
Yes, I mean they all the rights that they have currently, they'd still have in our proposal.
Yeah, on a well by well basis.
On a well by well basis. That is, I know that's a very, very important piece with the state, and they would still have that, the right to participate or not participate, go non-consent on each well.
I think that's basically the presentation that we had on that. I think we've Adam
So
laid
is
it
it
out
fair
very well.
to say that you're encouraging a working group or a smaller subset of those involved in working on the issues and coming up with something else?
Yeah, we in the request for agency action, we proposed that we would give, repetitive notice per well. Then we received Steve Alder's memo, raised some additional concerns about these other particulars of pooling on the royalty rate, the costs, and then in my responsive memorandum, I suggested that we'd be willing to add additional protections, provide additional information on each well, costs, etc., documentation of offers as part of the APD process at DOGM. And I gathered from the discussion I had with Steve, board or DOGM counsel, and that the board would like us to try to go about that rather than try to hammer out those details today.
Yeah, and I wanted you to say that so all the board heard it. And, but we've already just had a little bit of a discussion on that during the lunch break.
I felt inspiration coming from your direction.
I don't know that I'm speaking for the whole board, but there is a desire to work through this, take the issues, see how many of them we can solve, with a view at some point of going to rulemaking, so that we can let people, one of our goals as a board has been to let people know the rules of the game before they play. And see if we can't solve some of that. So that's kind of where we're coming from. Mr. Alder, do you want to now, just knowing kind of what the propensity is, do you want to discuss this further?
Well, so I guess I'm not sure that I need to get into the issues that were discussed by the memos. I think the board's read those and appreciates the differences of opinion. One of the primary issues is whether we can do something as part of this order or whether it should be by rulemaking or maybe by some other subsequent ruling by the board. Maybe it doesn't have to go to board order, but to board rulemaking. But at this point in time, it's the opinion of the division that this is very early, particularly for this drilling unit, to be making these guesses, and it's the first time that it will have been done by the state of Utah. So far, although the statute says that we drill all the owners in a drilling unit, we've never established an order for a drilling unit that didn't also include a specific well. And I think that that's the gist of our argument that we made in the memo. So I think if we're going to go beyond that and we're going to come up with some method for future wells, requires a lot of good minds. I guess the one thing that I think was missing in the proposal, in the memo, in response to the division's memo, was an opportunity for hearing. Currently, these are boring hearings, and in the past they've been delegated to hearing examiners for a good reason, that there's a lot of detailed information, a lot of exhibits, and yet the findings are pretty routine, but you have to go through the process. And that's required by the statute as we read it, and it's required to be done by the board as we read it. And so if we're going to change any of that, it should be done carefully. And so I guess if I hear counsel for Axia correctly, what we're suggesting is that we either bifurcate or withdraw the request as to this particular order and undertake some rulemaking. Is that right?
Let me just so that we have a sense, let me throw out a proposal or an idea. And that is that for purposes of the force pooling of the 2 wells, the board will make a decision, if possible, today and conclude that. As to the other part, the other phase and component, we would take that under advisement, leave the hearing open, let counsel for all parties know that additional testimony may be requested, and additional discussion and arguments, perhaps even briefing, with the idea that a smaller group, I'm thinking a couple of us on the board and all the council and other interested parties, try to at least make a list of the issues and see if there isn't a solution to that, and then the ones that there isn't a solution to, we'll bring back before the board with the idea that we very well will continue this till the next hearing. Now, could you address whether that, how that affects each of your
I
positions?
think that certainly from Axia's standpoint, they're very amenable to that and appreciate the board giving it that depth of consideration. And you know, the only other observation I would have is that the issues are well taken, but we got no pushback from any of the landowners or the working interest owners on it. No objections on this, and the future well aspect was vetted in the notices repeatedly. That was in big bold letters many times, so I thought that was interesting. But anyway, you know, we appreciate that process. I think that's something we'd like to try to work through and give it a go.
Mr. Chairman, I think the division agrees that would be a good first step, and we may decide after continuing for 1 month that we need to establish a rule group or not. Mr. Rogers was wondering if he could address the board on this question.
Okay, and then, just so you're aware, Mr. Kendall has a question, and Mr. Sayers.
Maybe we would prefer to hear Mr. Kendall's question.
The Wasatch and Green River are treated as one formation in this area, common source of supply. Is it possible or feasible or even planned at this point to have more than one lateral from a single vertical well bore in this 32 well mix?
That's a great question. What I heard was, is it possible to get multiple laterals out of a single well bore, if that's what I'm hearing? So from a mechanical standpoint, it is possible to do multilaterals. We actually have experience with that, with different patterns in the Williston Basin. The problem is the stimulation that's required. Because we need to fracture stimulate, it is very hard to exit a certain lateral and drill and isolate that particular zone. And so we're technology limited right now in terms of being able to accomplish that.
Okay, thank you.
You're welcome.
What examples in other states have you seen of force pooling applying to more than just one well?
Well,
any experience with other states?
Yeah, I think I can address some of that. Well, do you want to? Yeah, in Colorado we had some experience on force pooling, and we can spend all afternoon on this, so I'll try to be brief. But we're in a new age of development. We're in a resource place. We just don't have. I know we try to make our spacing units no bigger than what one well will drain. It's impractical. It doesn't happen anymore. That's why we have spacing units with increased density. You have 1280s with 32 wells, for instance, in our spacing order. In resource plays where a company like us gets concerned is where somebody will come in and not participate and write it down. In Colorado, for instance, we asked the state for multiple well non-consents, because if the reality is if you have 32 wells to drill and you don't have to participate in the first one and you let an operator go prove it up, you have 31 more wells to drill And we can argue that, well, you know, Garden Gulch isn't Uteland Butte, and, you know, there's different zones, but the reality is a lot of those, they benefit from each other. There's no question. You learn. And so we get concerned, quite frankly, when, you know, an operator will go non-consent on a well-by-well basis, which is what the state of Utah goes off of. This non-consent penalties is really important, but a lot of companies are willing to let the opportunity go on one well because of the 31 wells behind it. And so I think in the course of how we're thinking, Mr. Alder, you know, mentioned about, you know, we haven't done this before. It's a new step. I realize that, and we're going to have to think outside the box. But resource plays are a lot different, and so I do think we need to think that way. But in Colorado, we got multiple well, and so it was more. What it did was it made, look, if you're a working interest owner, you know, you're either going to participate or you're not, and so what it did was it made it more equitable for everybody. If you didn't participate, you didn't get to participate in a number of wells following, whether it was, you know, 3 or 4. I think we proposed 4 in that particular case. So it made it more punitive. But what it did was it made people think hard about participating, because we want participation.
Adam, could you describe, I think what you're saying is that the Colorado order you're talking about, it pulled us to the first well and then 3 or 4 or 5 additional ones initially within a period of time.
It did.
And then it covered future wells, but those would be then noticed up per the Colorado regulation.
Correct. Yeah, so in that particular case, it was a spacing unit. The JOA or the non-consent penalty was if you went non-consent or you got force pulled in the first well, you were out 4. Beyond that, it was a well-by-well election at that point.
Mr. Rogers.
Yes, Chairman Gill, I just wanted to go on record as we are talking about this working group that as you think about that, there's a very definite definition of what that group is, who's involved, how many people, so it's just not a flexible, unworkable group. And if that group is put together, how are decisions coming out of there? Does it have to be a majority of the group or a unanimous decision? That should be spelled out, yeah, definitely. And then what happens if that group cannot come to a decision? What is its next recourse?
I think I can address that. It would be a board-appointed group. The ownership of the final decision would be the board, as it is in any other hearing like this. Doesn't matter what your vote is, because the board's going to decide what the board's going to decide, but you'll just make recommendations as best you can. The idea is, though, that if you could, and it came across flippant, and I didn't mean it that way, so please don't take it. The idea is to see how many of the issues can be put to bed, and then there are some that are just policy issues that we're just going to have to work through as best we can, recognizing that the division would be one of the critical parties to this group. And so, I mean, it's a case of first impression. We're going to try and give it the best we can. I'd like to see if we couldn't put this group together in such a way that we get the whole thing done between now and the next hearing as best we can as to this case. And then as we learn more, we'll go from there.
Mr. Chairman? Roland? Yeah, I was just going to say maybe we should be careful to keep the rulemaking idea separate from this case. I think the hope, as I understand from what I've heard board members say in deliberations, is that if some sort of stipulated outcome can arise in this case from discussions among the parties, that might provide some kind of blueprint for a potential rulemaking going forward to tackle this issue more broadly. But for purposes of this case, the hope was that maybe...
I meant to say that.
That's what I understood. That's the way I saw it, Mike and Mr. Chairman. And
But
I also,
but our ultimate goal would be to try to address this rather than just say no.
yeah, and my understanding also, or my impression of it also was that even if there wasn't 100% agreement in our group, we would have put the issues out there. And the board would look at the work product and say, I don't think you got there, or maybe you did, or it'd be like that.
Yeah, if it's not resolved through those discussions, maybe they at least get distilled down for presentation to the board on the second phase of it, and then the board just decides.
And I guess the only caution I have is that since this likely would create a precedent that would apply beyond this case and may require either waiver of existing rules or some kind of modification, that may be a very big job to try and undertake, but we're willing to consider it.
We go talk about it, board members? We'll be back shortly.
Thank you.
I'm going to announce the decision of the board and then have an open vote on that to make sure that it's in an open meeting. Board's decision in phase 1 is to approve the request for agency action as submitted. On the second phase of it, dealing with future wells, we'll take that matter under advisement, and counsel for the board will be in contact with the attorneys of where we go from here. You've heard that. Will someone make a motion to approve that?
So moved.
Is there a second? Second. Just heard the motion. All in favor, say aye.
Aye. Aye.
Any opposed? Let the record show that was unanimous. Thank you. Okay, we're going to go to the next hearing. If the attorneys for that will start to get ready, I'll read it into the hearing. We are on agenda item number 4, docket number 2016-018, cause number 139-140, in the matter of Axia Energy. And we'll give you some time to get ready. Will counsel, when you get ready, let us know.
I think we're ready, Mr. Chairman.
Okay. Are we live? Okay. We're back on the record in the agenda item number 4, the Axia matter. We'll take appearances of counsel at this time.
David Bolda with Beatty and Wozniak on behalf of Axia Energy 2 LLC.
Steve Alder with the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Brent Chicken, Fox Rothschild on behalf of Respondent EP Energy EMP Company LP.
Okay. Mr. Bolda? Just to get started, we're going to accept the exhibits at the end.
That's great. One sort of matter of housekeeping here. Mr. Chicken and I were discussing beforehand, since they have formally responded and are here to cross-examine and present a case themselves. Are there any suggestions of how best to do this to help it flow? To imagine maybe our witnesses testify, the board, the division, and EP has an opportunity to cross. I don't know what the other parties think is best way to handle this here.
The way I'd like to do it, with the board's approval, would be to have the petitioner go first, respondent second, staff third, rebuttal by we'll go to that point, but I think rebuttal, then to the respondent, then to the staff, and you have the final word.
Okay.
And if you would want to proffer something that is not in dispute, that would be appreciated.
Okay. We'll try to work that out as we go along. Okay, at this time, I'd like to introduce the witnesses for Axia. Just to my left, Rick Gallegos. And then we have Taryn Frenzel, David Schmoody, and then Adam Sayers sitting back behind us. And I'd like to ask at this time that these witnesses be sworn in.
Okay, and then Mr. Chicken, I'm going to ask you to identify your witnesses and have them sworn at the same time.
Sure.
Would you speak into the microphone so it's recorded?
Sorry, Chairman. My first witness is Michael Walcher. My second witness is Angela Kennedy, sitting in the middle, and the third witness is Steve Biancardi.
And would you spell
Biancardi? And Mr. Walcher is Walcher. Sorry.
Okay. And the division?
No witnesses.
Okay. Witnesses, the 7 witnesses, if you'll please stand. Reporter? Pardon me, 6 witnesses. No, I have 7 witnesses.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, I'd first like to offer a summary, and then we'll get to our witnesses. I want to first point out that the subject lands are located in Duchesne County, directly north and contiguous to Newfield Central Basin property. The application lands are also located just to the west of Axia's previously approved spacing order and cause number 139-138. Indeed, many of the exhibits that you'll see today and some of the testimony that you will hear today, it will be similar to that from that prior cause. As was pointed out in the matter just before this one,
Since approval of that prior spacing request, AXIA has immediately began operations to drill 2 wells on that prior spacing order. As you'll see from respondents, exhibits, and testimonies, the lands at issue today are within an area that EP has identified as its area of interest, a larger area of interest. However, EP only owns a relatively small interest in these lands. Comparatively, AXIA and Newfield, who has filed a letter of support, own a much larger interest in these lands. You're going to hear 2 different approaches as to how these lands could best be developed, all while preventing waste and protecting correlative rights. And in the end, I think that, from the testimony and the exhibits presented by AXIA, I believe that that'll bear out that its approach to development in this specific area will maximize resource recovery by many multiples and resulting in much less waste while still protecting correlative rights. A lot of AXIA's exhibits and testimony are based on data sets from a third party, and that's Newfield. There's a very good reason for this, and that's because, as I previously mentioned, Newfield's lands, Central Basin lands, are located directly to the south. I believe that if Newfield were in here today making this request, that there wouldn't be any argument that this was some sort of pilot project with too many unknowns to grant what has been requested by AXIA. So for this and other reasons, AXIA is requesting that the board approve AXIA's request to create 10 1,280-acre spacing units comprised of the lands which will be further discussed during the testimony. Notice of this request and this hearing was sent via U.S. mail to all owners in the area where spacing is sought and to all administrative agencies having jurisdiction over lands in which the spacing is requested. All such mailings were mailed to the last addresses disclosed by the relevant federal, state, and Duchesne County realty records and from AXIA's internal records. There are a number of parties whose last addresses disclosed by the relevant records were undeliverable or unreturned. However, notice of this meeting has been published in the Salt Lake Tribune and Deseret News on September 4th and in the Uinta Basin Standard on September 6th of 2016. EP Energy, E&P Company LP filed a response on September 12th, 2016 and entered their appearance. The division submitted a staff memorandum on September 21st. Newfield filed a letter of support on September 26th, and the BLM filed a comment letter supporting AXIA's request on behalf of the BLM and BIA on September 27th. No other responses to the request were filed, and no other appearances have been made. At this time, I'd like to call my first witness, Mr. Rick Gallegos. And since he is a fact witness, there will be no reason to qualify him as an expert. Can you please state your name and business address for the record?
Sure. Rick Gallegos, 1430 Larimer Street, Suite 400, Denver, Colorado, 80202.
And again, if you haven't heard, we would request that you speak to the mic and that you speak close to the mic, and close is defined about 2 inches.
Okay, Mr. Gallegos, could you please state your current position with AXIA?
Yes, I am the Vice President of Land and oversee all land activities.
And that includes the AXIA's Uinta Basin assets, inclusive of the lands at issue today, correct?
Correct.
Okay. At this time, I would like to turn your attention to exhibits C, D, E, and F. If you can grab those exhibits. Yeah, exactly. Were these prepared by you or by AXIA personnel with your input and review?
Yes.
Okay. Although I didn't show you at this time, Exhibit B, can you please explain what Exhibit B is as filed in this matter?
Do you have it? I don't have it.
Well, I don't need to turn it up. It's just the prior orders. Prior orders. Yeah, contains the true and correct copy. The prior orders.
Yeah, Exhibit B contains the true and correct copies of the prior orders relating to the application lands that are at issue today.
Thank you. Okay, we'll first go to Exhibit C. Can you please explain what this exhibit is?
Yeah, that is just merely a locator map that shows where their lands are located within the state of Utah.
Thank you. Exhibit D, can you please explain what this exhibit is?
Yeah, Exhibit D is the outline of the area that we are seeking to have spaced on 1,280 acre stand-up drilling units. And on that Exhibit D, you will see that there are 2 existing wells, both of them that are operated by Axia, and as set out in our application, it is our intent that these will remain on 640 acre spacing.
Okay, and at the time of filing this request, there were a number of APDs located or relating to these subject lands. Can you please speak to those?
Yes, there were about approximately 8, of which the bulk of them were BBC permits, which are now Axia permits. And then subsequent to the filing of this application, EP has filed approximately 6 new permits on these lands.
Okay, thank you. And within these application lands, can you give an approximation of ownership as far as working interest goes?
Yes. Within the application lands, and this is very important, I feel, is that we show EP to own approximately 10.4% of the interest within this area. And between Axia and Newfield, who has given us a letter of support, we own over 71%. So almost 7 times more of the lands.
Thank you. Turn your attention to Exhibit E. Can you please explain this exhibit?
Yes, Exhibit E shows prior causes that have been filed in this area. And up in 2 South, 1 West, that's cause 139-138. This is where Axia had recently established 4 1,280 acre stand-up drilling units. And then just south and contiguous to the application lands is cause 139-134, where Newfield established 45 stand-up 1,280 acre drilling units. The terms in them are very similar to what we are seeking today, with 330-foot east-west setbacks, 560 east-west, and 330-foot inner well setbacks.
Okay. And in the area just to the south, Newfield Central Basin, do you have an approximation of how many wells have been drilled in that area?
It's over 50.
Okay. Yeah. Thank you. And the status, the current status of the spacing within the application lands, can you just give a brief summary of what that is?
The current status of spacing in the applications land is 640 acre spacing with 660-foot offsets both on the east-west and north-south lines and 1,280 inner well setbacks, allowing up to 4 vertical wells per 640 acres.
Okay, thank you. Now turning to Exhibit F, can you please explain what this exhibit is?
Yeah, that was what we used as the notification area for those that were notified. Everybody within the red line got notification of the spacing application. And there are some lands to the south there that you see border right up to the application lands. Those lands are already at 330-foot setbacks, so we are not trying to encroach on those lands any more than where they are on our lands. So.
Okay. And can you please explain the mineral ownership within these application lands? What type of interests that we have?
Yeah, it's comprised of fee lands, state of Utah lands.
Administered by the TLA.
Yeah, administered by the Trust and Land Administration, federal lands, BLM, BIA, and tribal lands.
Okay, thank you. At this time, this is not an exhibit, but I'm showing you a certificate of service that is a pleading already on file in this matter. Was this prepared by you?
It was prepared under my supervision.
Thank you. And do you recognize the names on this list?
Yeah, I recognize the list. It's a big list to recognize every name, but yes, I do recognize the list.
Right. And do you recognize these names as the owners in the area where spacing is requested, along with governmental agencies with jurisdiction over the lands in which spacing is requested?
Yes.
And,
as well as lands offsetting.
Yeah, the buffer zone.
Yes.
Okay. And how was this list compiled?
This was compiled through both through title opinions that we have in the area, and also through landman takeoff in the area.
Okay. And these would be considered business records of Axia, correct?
Correct.
Okay. Mr. Chairman, this concludes my examination of Mr. Gallegos.
Okay. Mr. Chicken, you have any cross-examination of Mr. Gallegos?
Okay. Yes, we do. I was under the impression you wanted them to all go first, but that's fine. Okay. So, Mr. Gallegos, just a couple of questions here. I need 1 second. Mr. Gallegos, would you agree that a 640-acre owner in an existing vertical well can maybe worry about competitive drainage from a horizontal well drilled within the setbacks being requested?
I would probably defer that to Taryn.
Okay.
Yeah. That'd be more of a technical question that I'd like to defer to Taryn.
So let me ask you another question. How do you think the spacing requested would work with respect to existing joint operating agreements on the lands? Well,
they would have to be modified to conform to the 1,280 acres.
Right, and specifically, I guess maybe I should be more clear. I apologize. Right now, you've testified that the lands are currently the way that the lands are currently spaced. The request would convert that spacing after the first long lateral well is drilled in each 1280. Is that correct?
Well, anything that's existing would remain on 640 acre spacing.
Correct. And then after a long lateral well is drilled, every well, long lateral, short lateral, vertical or horizontal, after that point, then is within a 1,280 acre spacing unit. Is that correct?
That's correct.
Okay. So how does how are correlative rights affected when you have a JOA that is set up with interests in a 640 and then it becomes a 1280?
Well, when we go to drill our first well, which will be a long lateral horizontal well, as a 1280, we would send out a JOA to supersede the other JOAs. That would be on a 1,280 acre basis.
So what about a JOA between two other parties in these lands that EP is not, or that Axia is not a party to?
Well, in almost all cases, we are the majority owner in the 1,280 acre drilling unit. And as part of and conforming with the new spacing pattern, we would certainly ask at that time that this JOA would replace and supersede.
Well, and specifically, what I'm trying to get at is that you've got two parties that have a contract that they've got a JOA that covers 640 acres for all the wells that are going to be drilled in there, and then some of those wells will now become spaced on 1,280 acres. Do you see any issues with the correlative rights of the parties to that JOA when Axia is not a party to that?
No, I don't, because your interest in the 1280 will be based on your leasehold interest or your mineral interest that you own within the 1280. So a new operating agreement that supersedes that, it would be, I don't see any issues.
And I think what we'd be getting at is these two parties, maybe they own 50-50 in the 640, and then one of those parties owns more than that when it becomes a 1280. Let's say that the other party owns all of the additional 640 acres that's added. Do you see that?
Yes.
Do you see that as an issue at all? Or?
No, I don't, because under a scenario like that, then one party would own 75% and one would own 25% in the 1280, and it's developed on the 1280 basis. So the correlative rights should not be impacted at all.
Okay, but wouldn't that require then an amendment of that JOA, though, which has an Exhibit A that says 50-50?
That would be, require that JOA to be superseded.
Okay. So, and if I'm directing any questions, obviously, that you think are better answered by subsequent witnesses, just let me know. So when we talk about conversion from a practical standpoint, right, the standpoint of filing APDs, and maybe I should back up. The conversion from the 640 to the 1280 happens upon completion of the long lateral, correct?
That is correct.
And so isn't it true that sometimes completion occurs in a well, but nobody but the operator and maybe select non-operators would know that completion happened until the confidentiality period has passed?
No, I don't believe so. When a well is completed is public record, maybe not the results, but any of the working interest owners that would participate in that well would get well information and would know exactly what's going on.
Okay, so then everybody knows the well's completed, and once that happens, based on the application, any wells drilled after that point would then be spaced on that larger 1280?
Yes, as requested, yes.
So what happens at the time of completion if there is an APD in Mr. Hill's office awaiting completion that says it's on a 640?
Well, the way it is structured now, that would be on a 1280.
Right, but I guess what I'm getting at is you submit an application for a well on a 640 acre basis, and the long lateral gets drilled and completed before that APD is approved. What happens to that APD?
It would probably go away.
Okay. So, same question basically, but what if instead of an APD, it is a well that is being drilled? So there's a well that's being drilled, it's been permitted and approved on a 640. It's in the process of being drilled, and now long lateral is completed. Everything changes to a 1280. What happens to that well? Is that well now spaced on the original 640 that it was permitted under, or does that then become a 1280 well because it won't be complete? It won't be completed until after the fact, until after the completion of the long lateral.
Well, if you've got a horizontal drilling at the time, and someone's going to drill a vertical well, I think they're aware of what the rulings would be and the timing would be. I mean, this is something that someone as operator should be able to figure out what the timing of that would be.
Okay, I understand. So and if I get this wrong, please correct me. So before you go and drill your well on your 640, you have to estimate when a currently drilling long lateral would be completed and figure out if you're going to finish your well before or after that one's completed.
Well, let me just say this, that we are not opposed at all to coming in here and just doing 1,280 acre spacing from day one for any well drilled, whether it be a vertical well, short horizontal lateral, or long lateral horizontal, if that helps with timing issues. The way our application is stated is that the wells drilled, any short horizontal lateral or vertical drilled subsequent to the completion of a long lateral horizontal would then be on 1280s and 640s if they were preceded the completion of a long lateral. But if that causes complexities to both the division and other owners, we are open to having it all on 1280s day one.
May I also state, we, not knowing how this would play out, we did after receiving your response, prepared an additional exhibit that discusses this issue, but in anticipation of you presenting your certain case and having your witnesses, that we then had an exhibit that would help explain where we were at in this, and that there's actually the testimony was going to be from Mr. Adam Sayers.
And that's fine. If we can actually add that. I was just interested in bringing that issue up, and we can wait till we've got our exhibit and Mr. Sayers is able to comment on this as well. And so I guess the only other kind of correlative rights really question that we'd have at this point is really, well, I guess it's kind of twofold. One is correlative rights, and one is just operations. The first one is the relief that's requested, the spacing that's requested. How dependent is the protection of correlative rights on full development of each 1280? In other words, you're asking for 32 wells. Once that first long lateral is drilled, how dependent is full development on the correlative rights of all the owners being protected?
I would defer that one to Taryn.
Okay. And just one other question, and you may end up deferring this as well, and it's twofold. In the area that you mentioned in 139, 134, and I don't know if we want to go back to that exhibit. Thank you, David. 139, 134, you know, and the information that's contained in there. How much work had Newfield done inside of that area before seeking the spacing that it was granted?
I'm not aware of that. I don't know.
Okay. Do you know how many pilot programs were involved in that area?
I do not have that information.
Okay. And then Do you know if any of the horizontal wells in 139, in that 139, 134 area have been drilled closer than 1,000 feet laterally?
I'm going to go ahead and defer to Taryn on that as well, because he'll know that information.
Thank you. We don't have any further questions.
Division?
Thank you, Mr. Chairman. I would just like to make sure we're clear about what the various orders that surround the application lands provides, and perhaps Mr. Gallegos, you could help us with that. So for the lands in the 139, 134, the new field wells below, those stand-up 1280s, are you familiar with the order?
Yes, I am somewhat.
And as I understand, that allows for a combination of either vertical, short horizontal, or long horizontal wells. Is that your understanding?
Yes.
And with regard to the short and the vertical wells, were they limited to the amount, the number of wells that would have been allowed under the previous order? So I think 8 wells per 1280, either vertical or short. Was that your understanding?
That I'm not sure about. Yeah.
There was a total number of wells allowed per 1280. I can't remember the number of that either. Was it 29 or 27?
It was 17 horizontal wells and 8 vertical wells.
Thank you,
Is
Mr.
my
Chairman.
recollection, if that helps you.
All right.
Mike can also help me if that's different.
Okay, thank you. That's helpful. And so the 8 vertical wells are on the 640 spacing, and the other wells would be on the 1280 spacing. Okay, and as to the 139, 138 order, we have sort of a flexible arrangement, which is you can have 32 wells, as I understand that order, and they can be short or vertical until such and the short and vertical would be spaced on the existing 640 acre spacing.
If drilled and are completed prior to the completion of the long lateral horizontal.
Right. Okay.
And that's where we have flexibility.
Right, and that's the same thing you're asking for here.
Correct.
Okay, and so one additional question then is, would it make any difference if the cutoff, instead of being the date of completion of the short or the vertical well, was the date of the APD approval for those wells?
I think that would be a possibility, but certainly it would make the most sense if they were just all 1280s day one.
Right.
And we our technical folks had testified to that last time, and that how that would help minimize surface disturbance, not having a 640 and then a 1280 right with the same, on the same lands.
Would it make any difference if you kept the verticals on a 640 and had all the horizontals be on 1280s?
It would make a difference. It would certainly complicate the accounting side of that, and also from a surface disturbance standpoint, that would impact us.
So are you amending your request, or are you asking the board to approve 1280s for all wells, 1,280 acre spacing for all wells?
We are going to address this later in our testimony.
Okay, I'll withdraw the question at this time then. That's all I had, Mr. Chairman.
Board members, any questions? Okay. Back to you, Mr. Bolda, for your next witness.
Okay. Okay, at this time, call.
Unless you have follow-up questions, I'm sorry that if I cut you off on that.
No, that's okay. A lot of this will be addressed in the testimony to come, so we'll clear some of this up. At this time, I'd like to call Dave Schmoody, Can you please state your name and business address for the record?
Yes, David Schmoody, 1430 Larimer Street, Suite 400, Denver, Colorado, 80202.
Can you state your current position with Axia?
Vice President of Geology.
Okay. And you have not previously testified before the Utah Board of Oil, Gas, and Mining, correct?
No, I haven't.
Okay. I would like to get this slide up. I'd like to have him qualified as an expert in geology for purposes of this cause, but in order to do that, I'd like to ask him a couple questions to go over his qualifications. Is that okay? Okay. Can you please explain your educational background?
Sure. I have a master's and bachelor's degree in geology, both from Oklahoma State University. I have 25 years of experience in the oil and gas industry. I'm also a certified professional geologist in the state of Wyoming, have been for over 10 years, and I have testified before the Wyoming Oil and Gas Commission multiple times.
Were you recognized as an expert in
Yes.
geology for Wyoming?
Yes, and submitted testimony and exhibits as such.
Based on his testimony, experience, and background, I'd like to have him qualified as an expert. If you have any additional questions, you could ask at this time.
Mr. Chicken, any objections?
Nope. I don't have any objections.
Mr. Alder?
It would help me understand his expertise better if you could tell us a little bit about your experience in the Butcher Butte project.
Sure. I've been involved with the project since coming to Axia Energy. Actually, it's been almost 2 years. In January, it would be 2 years. It's a project we initiated with Axia Energy 2 shortly after I started, and I've been involved with the geologic mapping and interpretation of the data, and since then and currently.
Thank you. No objection.
Board members, any objections or questions? Okay, you'll be admitted as a expert witness for purposes of geology.
Thank you. At this time, you have your exhibits in front of you. I'd like you to flip to exhibits G, H, I, and J. And were these prepared by you or Axia personnel with your input and review?
Yes.
Okay, thank you. Let's turn to Exhibit G. Can you please explain what this exhibit represents?
Sure. Exhibit G shows the spacing order interval that we're requesting, essentially from the Mahogany Zone down to the North Horn, which includes the Lower Green River and Wasatch formations collectively. Also shown on the right is a map showing the location of the application lands and a location of the two wells that were used to show the spacing order interval just discussed. Also shown on the image to the right is Newfield's North Mighton Bench field area, and as you can see, our application lands are direct northern offsets to that existing development by Newfield.
Thank you. Turning now to Exhibit H, can you please explain this exhibit?
Sure. Exhibit H shows a type log in the general area showing the formation names on the right and our frac zones or our zone nomenclature on the left. Through the interval, we see multiple targets. Initially, we identified up to potentially 9 horizontal targets that we could exploit. 5 are which we deem primary targets and are shaded in the green color. Be noted that 5 of these zones already have horizontal wells within them just to the south of us in the Newfield's North Mighton Bench field. And that would include the Wasatch 3, the 4, the 5, our Uteland Butte, and the Castle Peak frac zones. So there is some significant development that's already occurred to the south of us. I'd also like to add that currently the wells, we have 2 wells currently being drilled. One is targeting the Wasatch 5 interval, the other the Uteland Butte interval. And in addition to drilling these long laterals, we're also have acquired additional data to support the zones above the two that I just mentioned to give us further information on the prospective nature of those zones. And I will add that the data acquisition went very well and looks very encouraging for those zones above us.
Okay, thank you. Now to Exhibit I. Please explain this exhibit.
Sure. Exhibit I on the upper right shows a structure map at the base of the Uteland Butte Formation to give you some perspective of the nature of the dip in the area. There's structural elevation on the base of the Uteland Butte varies by about 1,000 feet across the application lands, as you can see. It also, in the lower part of the image, you're trying to show the continuity of the different stratigraphic members within the section in discussion to show that they are consistent and correlatable across the application lands.
Okay, now Exhibit J.
Exhibit J is just an example to show the petrophysical model that we have put together. This is the same image you saw previously that we in the previous testimony have showed, and it basically shows that we've one of our frac zones kind of shown up closer, the Uteland Butte frac zone, and the log indicates the lithology porosity data that's tied to core and XRD data, and then the methodologies that we used in order to develop our resource in place. Would add too that we have employed a consultant, Dick Merkel, on the petrophysical side, who is a former Newfield employee that's now a consultant, and he was responsible for generating Newfield's petrophysical model for their North Mighton Bench area. And we are using the same methodology and workflow to develop our petrophysical model, and it conforms well with the data that we've been able to compare it to as far as results from Newfield's operations to the south.
Okay, thank you. I have no additional questions at this time for Mr. Schmoody.
Thank you. Mr. Chicken, any questions, Mr. Schmoody?
Yes, I do. I'm gonna.
If you
have one moment, I'm going to play a little musical chairs. And just a housekeeping issue. I'm assuming you guys have K through P. Those geology exhibits are for later.
The next witness.
For the next witness. Okay. Yeah. I just want to make sure. Can we go to Exhibit H?
Can we speak a little closer to the mic,
sorry,
please?
Can we go to Exhibit H, please? As I've stated before, I think it's always funny because usually everybody's telling me to quiet down. So on Exhibit H, Mr. Schmoody, I have the first question is, what well did Axia use for its type log here?
I believe that's the 1022 well, which is located in 2 South 2 West Section 22, I believe. And currently it's a well that Axia operates.
And so when you look at this type log, what were the frac zone thicknesses?
Excuse me, could you repeat, please?
Sorry, what are the frac zone thicknesses on this type log on Exhibit H?
300 feet.
And some of these questions are necessarily just information gathering, and that's exactly what that was. Can we go to Exhibit I? Can you tell us if the frac zones thicken from the type log towards the western portion of these application lands?
No, they do not. If you go back to the previous exhibit, I can explain further.
Please.
As you can see, the frac zone names, and perhaps we shouldn't have named them interval or member names because some of them do transgress. So these zones thicken and thin, and we're basing the frac intervals up based on accessible resource that we can gain from one horizontal well. So yes, as you move from east to west, the intervals stay 300 feet thick, but they may include different stratigraphically equivalent intervals from one area to the next. If you want to go to the last slide that I showed with the Uteland Butte as an example. For example, here, this is called our Uteland Butte frac zone, but you can clearly see that it also includes the lower Castle Peak above, and includes the stratigraphic interval of the what we call the Ostracod below. So the interval is called the Uteland Butte, but it is a 300-foot interval, and so that interval height doesn't change from east to west, but the rock it interacts with can vary.
So what happens if it pinches out? Are you still going to have as many targets?
None of the units that we've mapped pinch out.
Okay, thank you. Can we look at Exhibit J? Or, I'm sorry, it is Exhibit J. We keep hopping around. So on Exhibit J, which well was used in this petrophysical model?
I believe that's the 1022 again.
As well. Okay.
Yes, it
So
is.
the same one in Exhibit H.
That's correct.
Okay. So on that lithology column there, can you explain what whether or not the yellow represents sandstone?
No, the yellow represents a quartz component. This rock is, yeah. The yellow represents a quartz component.
Okay, thank you.
And, that's an important clarification, because just because it has quartz doesn't mean it's a sandstone. So, no, it doesn't mean that it's sandstone. It means that there's that much percentage of quartz in the rock.
Okay, thank you. We don't have any further questions at this time.
Division?
Just one clarification, and maybe you're not correcting this, but excuse me, one question. Thank you. Regardless of the lithology that's shown on Exhibit J, are we correct to understand that Axia will expect that there will always be a 300-foot fracture zone associated with the development, the horizontal development?
I'll defer that to Taryn. He's more
Okay.
the expert on the stimulation.
And just, you may have answered this, or maybe this is from another hearing, but I think I've heard the answer. But would you clarify, how would you compare the geology for the application lands to the Newfield lands to the south?
Sure,
it's obviously deeper, but
Yep, and that is one of the key differences. Is as you go north, you get deeper. The intervals are, as we've shown in exhibit that shows exhibit I, that across the application lands, and in fact one of those wells actually does dip down into Newfield's lands to the south. But what I can say is that overall the trends in thickening and thinning are very similar from Newfield's lands to our lands, and there are some units, for example, in this image, the Douglas Creek, that consistently thickens to the west, and it does so as well to the south. So I would say that they're fairly consistent. The biggest difference would be we are deeper in our application lands than where Newfield is.
and being deeper, is that more likely to be productive of oil and gas?
We believe so. With depth comes both increased temperature and increased pressure, which are both instrumental in moving the type of hydrocarbon that we're trying to exploit here.
Okay. That's all the questions I have.
Board members, any questions of this witness? Mr. Hanson.
On Exhibit J, can you just give me a rough idea where the horizontal well would be? Where would you locate that in this column?
Sure. You know, can't speak for all of the wells within that frac zone, but we would like to optimize recovery within the 300-foot fracture interval, and we would target the most complacent rock to stimulation that is also what we believe through modeling is going to access the entire 300-foot interval. With that being said, it's typically closer to the lower end of center of that 300-foot interval, in that your frac height tends to get more frac height growth upward than downward. And what I can say about the current well drilling in the Uteland Butte right now, we are currently targeting that cleanest interval that's shown by the bluish color within the Uteland Butte. So very close to the base of the Uteland Butte there is where our current 144H well is being drilled.
Okay, thank you.
Other questions? Okay, we're going to take a short break. Would 10 minutes be too long? Okay, we'll be back at 3:30.
Yes, they are. Why would I go long ways down one of these when I can go vertically through all of them? Why doesn't that work?
Mr. Bolda, will you call your next witness?
Yes. Yeah, just a second, please. Okay, I'd like to call Taryn Frenzel. Can you please state your name and business address for the record?
Taryn Frenzel, 1430 Larimer Street, Denver.
And your current position with Axia?
VP of Engineering and Completions.
Were you previously recognized as an expert in petroleum engineering in the previous spacing request, docket 2016-011, cause number 139-138?
Yes.
Board members, for purposes of this cause, I'd like him to be recognized as an expert in petroleum engineering, if that's okay.
No objection by the division.
Mr. Chicken?
No objection.
Board
No
members?
objection.
Okay. Yours, Mr. Frenzel is admitted as an expert engineering witness.
Thank you. Mr. Frenzel, I'd like to turn your attention at this time to substitute Exhibit K, Exhibits L, M, N, O, and P. And were these prepared by you or Axia personnel with your supervision and review?
Yes.
Thank you. Let's turn then to substitute Exhibit K. Could you please explain what this exhibit represents?
Yes, there's a lot of information on this. We'll just kind of walk through one of the examples. Dave Schmoody on the previous slide talked about the petrophysics. Very important piece that we built across Newfield's lands, and that was we were helped with that petrophysics by Dick Merkel, PhD petrophysicist that actually started at Newfield and was there when their horizontal play started as well. So everything kind of starts with the petrophysics, and then it's just kind of plug and chug as far as the results on this table. So we talked about a 300-foot frac interval. That's what we expect within each of these. We can address that a little bit later, but we have modeling that will get us 300 feet, and we'll design each zone to accomplish that task. So of that, 283 feet of that is net pay, which means it'll move oil. 7% average porosity, formation volume factor is 1.4, oil saturation 74.8%. This is a 1280 spacing unit, and that gives you about 105 million barrels in the Uteland Butte. When you do this petrophysics across Newfield's lands and take all of their results within the Uteland Butte, you get about 10 to 15% recovery factor. We actually average about 12.5%. So that's your checks and balances to make sure that the in-place matches the results. When you do that, essentially we use 10% just to be on the low side, the conservative side of what we expect in our particular well bores. At 8 wells per 1280, you end up with 1.3 million barrels. At the current strip price, August, $11.8 million AFE, that's 43% rate of return. Just one thing I'd like to add on that is this is initial costs. We're getting core, we're getting samples, we're checking our shallower zones on this, so we're at $11.8 million. We fully expect to get this cost down. We get these costs down every day. We're still working on this. Development, we expect to get down to about $9 million. And what that does is, if you look at the bottom row of the Wasatch 5, that takes that from a 16% to a 32% rate of return. So about double the rate of return once you get to a full rig program out here.
Okay, thank you. Turning now to Exhibit L. Can you please explain this exhibit?
Yeah, we wanted to introduce this again. We brought this up last time, called it a W pattern, staggered pattern. We're basing this off of more senior plays like in the Permian Basin where they already have stacked horizontals, and we're just learning from their best practices essentially. We're basing these results on 660 spacing, which matches all the microseismic in this area. And essentially what the staggered pattern is, as you can kind of see from the diagram, but we'll drill 660s within each interval, but when we move up to an adjacent interval, we'll go 330 to the east or to the west. So we never drill directly on top of each other in an adjacent interval. So what this does is this minimizes any possible interference from hydraulic fracturing. What the Permian Basin has seen is they're seeing new reserves and uninterfered reserves by doing this and applying this method. So again, it's just to prevent any possible interference from hydraulic fracturing to maximize reserves.
Okay, thank you.
I'll keep going here.
Yeah, go ahead.
Also, as in approved dockets 131-141 and 139-134 will be no closer than 330 foot laterally within the same zone from a producing interval of any existing or future vertical or horizontal well. Again, this is what Newfield asked for in the south, as they have existing vertical wells also, and then Crescent Point has also asked for the same thing. Stacked laterals being located at least 100 feet in vertical distance, directly above or below, and will have no interval setbacks laterally. So what this means is as long as we move up at least 100 feet from our lateral, we have leeway to move east or west any distance we need to drain that particular interval. One more?
Let me ask you a question. Would you just say that again?
Okay.
I didn't understand that last.
If we drill in a lateral, as long as we move up at least 100 feet above that zone, we have the leeway to move east or west. We're saying 330, but we don't have to. There's no interval setback from this point in space. So as long as we're 100 foot up, we can place a wellbore at least 100 foot right above us if we choose.
Okay.
Which again is the same as what has been approved at Newfield and Crescent Point as well. If you put your eyes on the diagram, this is kind of what this looks like. The shaded colors are our 5 primary targets from Douglas Creek down to Wasatch 5. And as you can see, obviously 8 wells per 1280. There's 40 wells to be drilled, and we're asking for 32. If you look on the grade sections, the grayed out area, these are areas that will not be drilled under this current docket, and we're okay with that. What we said last time as well is we'll gather the information within the setbacks, bring that back to the board at a later time such that we can drill 330 from the line at that point when we prove the spacing in between. So there's 3 wells on the left-hand side, there's 3 wells on the right-hand side, both that are 330 from the line, and then there's also 2 wells on the lease line. I think this has come up before. But our plan would be come back and do a sharing agreement on the lease line as we see fit, proper to drain those minerals as well.
Okay, moving on to Exhibit M. Please explain this exhibit.
Yes, this is essentially maximum stress direction. We use this information to tell us which direction the hydraulic fractures will be going. So you can see we have a data point in our area, north 64 west. We have this from FMI data. Again, this will tell you which direction the fracture will propagate. I'll use this angle for illustrations on setbacks.
Okay, and that is Exhibit N.
So on Exhibit N, let's start on the diagram on the right-hand side first of all. You have the darker colored well, which is the Uteland Butte. And then you have the lighter colored well to the west, which is the Castle Peak. Again, this is just an introduction of what we want to do in the future. Come back after we don't have approval to drill this current well right now, but I wanted to show how it fits in our scheme of spacing. There's still room, 50 feet room on the left-hand side from that wellbore based on current microseismic, so it'll fit in nicely. Also keep in mind that this wellbore is 300 feet off the page now. We're in a different zone. We're above the Uteland Butte, 300 feet, and we fit essentially 330, fits nicely within our 1280 spacing unit. In the Permian Basin, they're spaced on 8 wells per 1280, and they're actually starting at 330 and ending at 330 on the other side, so they don't have to do a lease line well. So this is kind of taken from what they've already started. So with that being said, we're asking for 560 east-west setbacks. Again, the same as what we've seen in the south and what we presented before, based on dockets 139, 129, and 131-138 and 139-113. These are microseismic wells. We were partners in one of those wells. The average east-west half length at North 64 West would be 280 feet from the wellbore, leaving about 380 feet to the lease line. As well, in the north-south direction, asking for 330 north-south setbacks. Again, using the microseismic wells at North 64 West would be 136 feet from the wellbore at the toe, leaving 194 feet from the toes at the lease line as well, protecting correlative rights. Again, these reduction of setbacks from 660 down to 560 and 330 respectively gives us access to greater than 40 million additional reserves per 1280 units, otherwise stranded, thereby reducing waste.
And as a point of clarification, these setbacks would pertain to the proposed stand-up drilling and spacing units, correct?
Yes.
Okay, thank you. Okay, we'll go to Exhibit O now. Can you please explain Exhibit O?
Yes, so we have an interesting occurrence across these lands. The maximum stress direction rotates as you move from east to west, and it rotates to the north. So you can see we have a few good data points north 64 west and in the northeast, and then a really strong data point on the southwest of our acreage at north 24 west. If you extrapolate between these two data points, and we have other data that makes our chart here, our map here that we can't show in public forum, but we get 44 degrees right on the township line. So if you can imagine at 44 degrees maximum stress direction, we have a choice. We could actually drill this well north-south or east-west and have the same stimulated reservoir volume by the hydraulic fractures. But every foot to the west of that, now it becomes more advantageous to do a laydown. Originally on this docket, we asked for the ability to go north-south or east-west, west of this township line. However, since we've submitted these, we've worked hard to try to get as much information we could to clarify, do we want to go laydowns, and that decision's been made. We've talked with Newfield and worked with them, and they're actually in agreement with us. They've voiced their concern about stand-ups in this area, so it confirms the data that we saw. And also El Paso has submitted some of their slides and some of their orientation as well, which also solidified what we were thinking. So with the support of Newfield, we would do laydowns from the township line over.
And I just want to point out here that does is a change from our original request, where we asked for the ability to go stand up or lay down depending on what the additional data gathered revealed by the time they were ready to drill there. But they've now determined that they would like to go lay down in that 2 south 3 west township. Moving then to Exhibit P. Please explain this exhibit.
So Exhibit P, again, this is representing what a laydown setback would look like. So the biggest difference is the setbacks now switch. So in the east-west direction, we'd ask for 330 setbacks, and the north-south direction, we'd ask for 560 setbacks. Using an angle of 34 degrees, which is right in the middle of this western 41280s, just took an average within that section. Using the same microseismic data as we had before at 34 north 34 west, we'd be 174 feet from the wellbore in the east-west direction, which leaves 156 feet now to the lease line to the east. Similarly, in the north-south direction, using the microseismic wells at 34 degrees, now we'd be 263 feet from the wellbore, leaving another 397 feet to the lease line, protecting correlative rights. And again, this reduction of setbacks gives us access to over 40 million more additional reserves per 1280 unit spacing unit, reducing waste.
Okay, that's all the questions I have at this time for Mr. Frenzel.
Okay, Mr. Chicken.
Thank you, Mr. Chairman. Mr. Frenzel, I'd just like to kind of go back to some of the questions that were punted to you, and hopefully talk about some of those. Those are obviously not quite so exhibit-based, but I'm happy to go back to those exhibits if we need to. So one of the questions I had asked Mr. Gallegos is, from a correlative rights standpoint, how dependent on full development is the spacing and setbacks and well numbers that Axia is requesting? How dependent on full development is that?
Are you asking if one well drilled in a 1280 holds a 1280 and no more wells are drilled? Is that protecting correlative rights?
No, when the spacing unit converts and people that were spaced on a 40 or a 160, and I guess in this case it's 160s, all of a sudden they're in, if another well is drilled in there, that interest becomes not their acreage over 160, it becomes their acreage over 1280. How long, how much development has to occur before they come out even?
Well, with what we're showing on the long laterals, we are getting so much more oil out of this, and that existing vertical well shares in the 1280. In their individual wellbore, that's their interest, but it will share in the success of that single long lateral. And like I said, and we'll get into volumes of recovery, but the amount of oil that we're pulling out of a long lateral will certainly benefit the existing owners that are out there.
And maybe I need to articulate better. Just to be clear, the request says that anything that exists is going to stay spaced the way it was, correct?
That's correct.
Okay. So I'm talking about, I'm trying to come up with a hypothetical here that works. You've got a person who owns 160 acres, and they've got 2 out of the 4 currently allowed wells on those 160 acres. A long lateral is drilled, and now the other 2 vertical locations on that 160 are going to not be spaced on a 160. They're going to be spaced on a 1280. How many vertical wells do they need to share in before they make up what they would have had under the old spacing for those 2 new wells?
I'm not following. Maybe I'm not the one to ask.
Even if you just the issue I'm trying to get at here is, you would agree that after a long lateral well is drilled, that new 1,280 acre spacing is going to dilute the interest of somebody over a vertical well under the current spacing? Paul, it's a difficult question to ask.
I think Mr. Gallegos is prepared to respond to that in its current form.
Thank you.
Okay. Well, if the new long lateral is drilled, that they would share on the 1280 basis, sure. So they'd be shared in production from not one vertical, but from a horizontal well that is drilled and crosses 2 sections.
Sure.
And that horizontal well will produce significantly more than any of the vertical wells will. So I would say it would greatly benefit them. And I would, I'll defer to Adam or Taryn for the technical explanation of that, but it's going to be to their benefit, because they're going to be sharing from a wellbore that crosses 2 miles that produces significantly more than a vertical.
But that is based on the performance of that horizontal well, correct?
Yes.
Right. And so I what I'm trying to get at, and I'm hoping you understand the concept, and it's really just understanding the way that it is spaced right now. You can put 4 verticals in a 160, correct? No. Or I'm sorry, 640. Sorry. so if you can put those 4 verticals in a 640, what happens if instead of sharing 640 over 640 in another vertical, you now share 640 over 1280 in the horizontal, in the long lateral that's just been drilled? Do you have to drill more than one horizontal to get back to 640 over 640?
I think probably the best thing to do is we have some more slides, and I think we're going to address this, and this question is going to come up one more time. So I would say let's get to the additional slides that we have, which is supplemental. However we want to deal with those at a later
Sure,
after El Paso
that's fine. We can revisit. So another question was for Mr. Frenzel is: Are you aware of how many pilot programs were undertaken in the previous cause number 139, 134 lands?
I am not.
Okay. Do you know how many wells were drilled with 1,000 feet or less between them in the 139, 134 lands?
0 within the same zone.
Okay. So no wells have been drilled closer than 1,000 feet in the same zone?
That's correct. Not yet.
Do you think that the kind of previously mentioned owner in the 640 acres who has vertical wells should have concern for horizontal well drainage 330 feet away?
We're going to address that on that same slide later. I think is the best place to put that. I guess all I'll say on that one is Newfield does currently have vertical wells, and within their orders they requested no closer than 330 setbacks. Crescent Point also has vertical wells, and within their horizontal program they're also requesting no more or no less than 330 setbacks. So we're following the same pattern that's what they've come up with. But we will address that at a later time.
Okay. Thank you. So, you know, we're mentioning Newfield and Crescent Point. So how much of the engineering data that was presented is engineering data that came out of Axia-operated wells?
We've studied all their wells for over a year now.
Whose wells?
Newfield.
So how much of the engineering data being presented is Axia's own engineering data?
Well, we have petrophysics. Everything is tied to existing production. That's the way you need to do these things. Everything needs to tie together. So Newfield has producing wells. Obviously, Axia doesn't have a producing horizontal well, so we're going to Newfield's area, which is literally 660 feet away from our lands, to take their performance to apply to our area.
Okay, and so then none of this data is from operations on the cause number 139, 138 lands.
Correct. As Adam mentioned earlier, I believe we're drilling our first 2 wells right now on our first 2 spacing units.
Sure. Okay. Yes. Oh, sorry. Can we look at Exhibit K again, David? So a couple of questions here. So when you look at this exhibit, can different petrophysicists have different oil in place inputs for net pay, porosity, formation volume factor, et cetera?
Sure, plus and minus.
Okay. What do you think that plus or minus factor is? How much can they vary between those petrophysicists?
So again, the numbers have to go around, so you have to gut check everything. This is an exploratory area, so there's plenty of well data to make sure that the recovery factors match what Newfield and Crescent Point have both submitted earlier, which they believe 10 to 15%. So when you build a petrophysical model that goes into this, just keep in mind that the results can't change. The Newfield EURs can't change. If the petrophysics says there's 20% more oil in place over Newfield, all that means is the recovery factor goes down by 20%. You can't change that. So you pick the best petrophysical model you can, and then you adjust the recovery factors based on actual results, which in our case is 57 wells drilled by Newfield. So all we're doing is we're expanding that same petrophysical model to our area and applying the recovery factor that we've seen in their area. So they get 10 to 15%, so average 12.5. We use 10% just to be on the low end side because we do see 10% recovery wells. So if the petrophysics adjusts the other way, that means you have a higher recovery factor. So everything has to go around. Everything has to fit the actual data that's out there.
Okay. So then going into a couple of those numbers, under the recoverable reserves, has anybody seen those numbers in actuality, not in a petrophysical model?
Newfield has well over 1 million barrels right now.
Okay, but and what I'm trying to do is just get an idea of when every one of those is over 1 million and one of them's almost at 2.
Sure.
I take that back. One is at 853. So, but what you're saying is that out of the wells you're aware of, one of them has hit 1 million.
There's a couple wells over 1 million. So as Adam mentioned earlier,
sure.
For us not to learn from what Newfield has already done and take the next step wouldn't be prudent to our partners. So I think El Paso has alluded to on a couple of slides that we'll probably see later, and the microseismic as well, that Newfield is getting about 150 feet of height. And I've modeled all that with all the microseismic data versus the volumes that they're pumping. So when you do the math on that, essentially, you look at the microseismic data, they're getting out about 502 feet both directions from the wellbore, not 660. So they're just short. You wouldn't think that's a big deal, but that's 31%. So immediately, we're going to drain a full 660 so that we can get everything spaced properly, and we're going to do, the angle of orientation is hugely important. If you just look at frac half length, they were pretty close, but at an angle, you lose that extra distance at 45 or 55 degrees. So we're going to design across our play to drain 660s, not 500 feet based on the microseismic. By doing that, so that's why our AFEs are higher. We're going to pump bigger frac jobs. At the same time, by getting the extra half length, we are going to get the extra height that we've modeled with simulators. So we're up to 300 feet in H, so we're getting a little bit more than 70% in H and 31% in half length. So at 10% recovery, we know they're higher than that, but at 10% recovery, that gets you 1.3 million barrels. One more thing I'll add is this does increase our cost, and Crescent Point, we've talked to them about our bigger frac jobs, and they agree with what we're doing, and they are partnering up with us on this well.
Okay, thank you. So is there anything about the petrophysical models in the Altamont field as a general matter in terms of certainty that the board should know? Like how certain are Altamont petrophysical models as a general matter?
Well, one thing I'll tell you, we are very confident in our petrophysical model that we put together in this area, and we're so confident we also have a third-party expert in this area, PhD petrophysicist, that worked on Newfield's model and also helped us create our model, which is essentially now the same model.
Okay. And then just another. Then this was just from a point from earlier today. If we go back to K, the capex amount is in the 11. It says 11.8 million for capex. Can you explain the difference between the capex here and the 13.5 million a well from the immediately previous hearing today? That just seemed like a big, almost $2 million difference there, and we just want to understand the difference.
So a couple of things. At $9 million, that's our development. Our initial is 13.5. So if you average those two, you get $11.5 million ish. But at the same time, we talked about earlier, and even now, between when we complete in November, we're going to continually work these prices down. We're in a market where we do have an advantage to work and work and work and get new bids and more bids. Axia prides ourselves on trying to get water solutions, especially for a horizontal program. You got to solve that, and you can either truck it at $2 a barrel, or we're looking for alternative solutions that we're about nippled up on, and we can get that down to much, much less. That's $1 million in water hauling that leaves the AFE. So from the 13.5, we always have to plan for worst case scenario. For these actual economics, more expectations maybe, and actually getting closer and closer to the date, we're working these numbers down and we're getting the solutions that we need to. And we're always going to do this up until the day of fracking.
And then just one last question on this slide. The oil saturation that you're seeing here, do you think that's a little high, that those oil saturation numbers?
No, it's based on the data that was put together in our petrophysical model. I can tell you in the Uteland Butte, we don't make much water. It's about 20 to 25% water is all, so the numbers fly.
How about the Wasatch? Is it similar?
Up in the north, it is. There is actually a horizontal well just next to our lands. It's about 52% oil saturation, but it's deeper in the Wasatch, so it's called Middle Wasatch. We didn't really allude, but our target Wasatch 5, we're right underneath the Uteland Butte. Literally, we share a border with the Uteland Butte, so we expect the same water cut in the Wasatch 5 as the Uteland Butte.
Okay, thank you. Can we look at Exhibit L real quickly? I've got a couple for these handful of ones. I'll try and go quickly. So can you remind everyone the microseismic data that you based your belief on, that the spacing needs to be 660 within that same interval?
You want to know which dockets we got the microseismic from?
Yes. And those are the ones on there, 131 and 139, correct? Or I'm sorry, 131, 141, and 139, 134, correct?
Correct.
Okay. Are you aware if there's a mixture of working interest owners and other active operators in the lands from those applications?
Involved in the microseismic wells?
Involved in drilling vertical wells in those areas, other operators?
I'm sure there are.
Okay. And the reason I ask is because obviously we have the kind of a multiple operator issue on these current application lands. And what I'm trying to get at is that, do you believe that issue exists on the 131, 141, and 139, 134 lands?
I'm not sure where you're going with this, and it's taken up a lot of time.
They're basically basing their well spacing pattern on the two previous dockets, and most of those dockets didn't have a bunch of overlapping operators. They had much more control than, by one operator in the area. They weren't quite as fractionalized, the ownership and the operations. And that's all I was getting at.
I think we recognize that.
So, anyway, I just want to get on the record. If we can go to Exhibit M. And again, some of this is, I just want to clarify. This exhibit, it indicates natural fracture orientation east-west in that South Altamont 1022 well.
Oh, yes. Mm-hmm. Correct.
And is Axia aware of in what percentage of those natural fractures in the 1022 well are open or partially open?
We have the data. I couldn't tell you the number.
Okay, but so you're saying you have data on whether those natural fractures are open or partially open. We just don't have it today.
Correct.
Okay. Can we go to Exhibit N? And so these are the stand-up. Are all of the microseismic data points in this Exhibit N? They're all of these are south and southeast of the application lands, correct?
That's correct.
Okay. And so how far are those microseismic data points from the application lands? And you can give a range. I realize they're going to be different each one.
2 miles. We're within 2 miles on one of them that we were partners in.
Okay. Are there any ones further than 2 miles?
Sure. The other one was, I think, 3 or 4 miles just west of that one. I don't know where the third one was.
Okay. And so we've got an effective angle here of north 64 west. So is that based just on then the South Altamont 1022 well?
That's correct.
And so then the kind of next natural question is that, you know, for either one, I think this would go to either a stand up or a lay down, and based on the clarification that the west side is going to be all lay down going forward. Why would you go with a 560 instead of just doing 330 all the way around?
That was what was agreed to last time when we put our spacing documents together. And the agreement was we actually came forward with 300-foot setbacks all the way around was our original. We said we would come forward with all the data in between the setbacks of the 560s and the 330 north-south and present that at a later time because there are more well bores that we need to drill to drain this.
So did the natural east-west fractures have anything to do with the 560 setback?
No.
Just one moment. I have no more further questions.
Division?
Mr. Chairman, if I could, I think that Mr. Doucette could probably explain his question more effectively if he would be allowed to ask it.
Proceed.
Yeah, Dustin Doucette for the division. You could turn to Exhibit K. So all that data, the reserves and economics, that's for 1280 horizontals only. Is that correct?
That's correct.
Have you got any information as far as vertical wells are concerned?
We do have quite a bit, and that comes a little bit later. We have quite a bit of information on all the vertical wells out here.
As far as how much they would drain, how many it would take to drain a...
Correct. The performance of all the verticals, we do have a slide on that. That was submitted after the original documents.
Okay. So I guess the question would be how many verticals are needed to drain, and hopefully that a 1280. Hopefully maybe you can answer that later.
Currently it's 8. Currently there's space to do 8 wells in a 1280.
Okay. Does the current request as structured allow, could it allow up to 31 vertical wells in a 1280?
I don't think we differentiated between vertical, short lateral, or horizontal. It's our intent. It's because we don't anticipate drilling any vertical wells out here. So the intent was horizontal wells for us, but we left it open for the off chance that somebody needed to come do a vertical well.
Based on that sort of being a legal question, how is the request? How does it state that issue? We will address, I think, as Taryn explained, that the way it's currently structured, I believe you could have that many vertical wells, but that's not our intent, and we intend to address that very issue with additional testimony.
Okay. I'm not sure if this is a question for you. Earlier it was testified that putting vertical wells on a 640 and long laterals on 1280 spacing would cause accounting problems and also surface and create more surface disturbance. I guess the question is, and maybe if you know the accounting, that's fine, as far as surface disturbance as well, how is this causing more surface disturbance?
Adam has he'll address that, I think, along with some of the other concerns on verticals and horizontals in the same 1280. I think all that'll be lumped together.
Okay, and so I'll just ask that question later. If you'd go to Exhibit P, so I believe on this exhibit you have your wellbore 660 feet from the section line, and you're requesting a 560-foot setback, correct?
Correct.
So as far as your testimony, as far as your fracture getting to that south boundary there, that would move by 100 feet, is that correct? If you drilled it right on the setback line?
Sure.
Okay, thank you.
We asked for a 100-foot kind of drilling buffer, I guess, but for spacing, and it's the same as any other documents, they ask for the same thing, and my assumption is that's why, is you don't want to go over a hard line when you're drilling a horizontal well, because it'll mess everything up on the completion side.
But in your testimony, so it could get as close as 297 feet if you were right on that hard line?
That's correct. Yep.
Okay, thank you. No further questions.
Board members, any questions?
On your frac length, if I don't lose my voice first, from the microseismic, is that the actual microseismic that's calculated or observed, or is this what you estimate to be the part of the frac that will be effectively propped?
This is the actual microseismic, so that is a big question. Is generally microseismic shows more events than is actually propped.
Yeah.
And that's where you really have to see what. So it's always kind of the longest distance that you'd expect.
You think that's the maximum?
That is
probably
correct.
Something less than that.
That's accurate.
Any other questions? Okay, back to you, Mr. Bolda, for your next witness.
Yeah, so this is where I'll again kind of defer to the board and your advice here. So this essentially concludes our presentation in chief. Now, we have a response from EP that was filed, and so then we went back and prepared. We knew we were going to have to respond, and so we prepared some additional slides that would help illustrate our responses to their concerns and their questions. Our intent or our plan was to let EP present their testimony, and then we would come back and with these additional slides and then present them in order to address their questions. I don't know. I don't know how best to do this. I mean, you know, if you would prefer that we just go through it, we can. It may seem a little out of place, and we'll be bouncing back and forth between witnesses, but we can do that.
So basically, you have a rebuttal
Yeah.
witness.
Rebuttal witness and rebuttal slides. That's what those additional exhibits were that were
correct. And about how long do you plan your case in chief?
Maybe 45 minutes for all three witnesses, and give or take somewhere in there.
I think anybody have strong feelings about it? Why don't we go to EP and then we'll come back to you for rebuttal.
That sounds good.
So the sequence of questioning will be EP, you, and then the staff.
Okay.
Okay.
Thank you.
Okay, thank you. Sorry, a little technical adjustment here. Hey. Okay, it worked. Good. So we're just switching here.
Proceed.
Thank you, Mr. Chairman. As counsel for Axia has stated, EP's filed its response in this matter really based on one overarching concept that affects two smaller concepts. And the overarching concept is just a lack of good information, reliable information. And we've seen there's lots of extrapolating from other data, and we're not suggesting in any way, shape, or form you don't learn from what other people have done. EP just believes there hasn't been enough learned to take the 139, 138 spacing plan and extend that over another 12,000 acres. And it really falls into two categories. And that's that EP believes it's going to this will inherently create waste, and it's going to negatively impact correlative rights. And admittedly, these positions are born of the fact that you're looking at two companies that have very, very different ideas of how to develop these lands. EP's witnesses are going to give you a little bit of background on EP's experience in this basin and understanding and how many wells they drilled and why they think that a vertical plan is going to better prevent waste and protect correlative rights and maximize resource recovery rather than using a horizontal drilling plan. It's obviously up to this board to determine which one of those positions is probably closer to being right. Again, recognizing the very limited information we're looking at here. We've already heard some testimony that there's some wonkiness with the practical application of how some of these things are going to work. Again, there's lots of data extrapolation, but maybe not direct data usage. We've even now got just from a procedural standpoint, some of the things that EP was hoping that would be able to be answered in kind of a direct presentation is now only going to be answered in a rebuttal style. And again, I think we just think that shows that there is a lack of information here. From the waste creation standpoint, it's not only that lack of data, but it's when you combine that with that large area that really brings about the potential for waste. And we'll put on evidence that shows why EP feels this way. There are no wells, horizontal wells in this particular area. As Axie has testified, the area that is most similar to this area, just to the east, the 139, 138 lands, they are drilling there, but the results have not come back yet from there. And traditionally, what we would have seen with this board is the kind of pilot concept of take this smaller piece of land, do stuff there, then come back to us. This is how 139, 134 came around. This is how if I'm getting these wrong, 138, 141, the new field and the Crescent Point large horizontal spacing. All of that was based because those companies went out and got data and evidence and brought it back to this board. And quite frankly, the Axia's request doesn't even give the board that opportunity, which is another thing this board has I don't know if I want to call it precedent, but the board likes to say, hey, go out and try it and come back in a year, tell me what happened. And that's exactly how the Crescent Point, in fact, the Crescent Point application has a 5-year sunset. If this doesn't work in 5 years, you're done. That provides this board with a lot more control over those type of things. And then the second point being correlative rights. We have the issues with the conversion, and we've brought up some of those in our cross-examination. We're going to talk more about that, about how, when it occurs, and kind of the aggressive nature too of the setbacks as a general matter. With that being the case, I'll call my first witness. I understand you want to wait till the end to have exhibits accepted.
Yes.
Do you want that at the end of each witness, or do you want it at the end of all witnesses?
All witnesses.
Okay, thank you. So I'll call my first witness then, Michael Walker with EP.
Good afternoon.
Can you please state your name and title for the board?
Yes, my name is Michael Walcher, and I'm a land advisor for EP Energy.
Okay. And have you testified as an expert witness before this board before?
Yes, I have.
Based on that prior testimony, I'd like to offer Mr. Walcher's testimony as expert testimony.
Mr. Bolda, any objection?
No objections.
Thank you.
Board members? You'll be so admitted for the purposes of land testimony as an expert.
Great. Thank you, Mr. Chairman. With that, I'll go to our first exhibit, which is what? Oh, I'm sorry. I'm reminded. Mr. Walcher would like to give a little bit of background first on EP and its operations in the Uinta Basin.
Yes, I think it's important that we give you a little bit of information.
Could you get closer, please?
Sorry. Give the board a little bit of information about EP Energy's operations in the Altamont field area and our position regarding Axia's application before you this afternoon. EP Energy was formed in 2012 as a privately held company with El Paso heritage assets, and then was restructured in 2014 as a publicly traded company. We're based in Houston, Texas, and we have a field office in Altamont. EP is the second largest oil producer in the state of Utah by volume, all from the greater Altamont Bluebell field. According to UDOGM website, our first half of 2016 oil production was 2.7 million barrels of oil, which represented 18% of Utah's oil production, and that's up from 14% in 2010. We've grown our production to 16,000 barrels of gross crude oil per day from the greater Altamont Bluebell field. We currently operate 405 wells in the greater Altamont Bluebell field and own approximately 180,000 net mineral acres of leasehold and minerals, up from 170,000 in 2011, which makes EP the largest operator by number of wells and acreage in the greater Altamont Bluebell field. We've drilled 157 new vertical directional wells and performed 159 recompletions since January 2011. And we have 1,200 future vertical directional drilling locations identified in the field, some of which are directly affected by this application before you today. Since January 2011, EP has spent over $1 billion in capital and another $270 million in operating costs, developing our Altamont asset and maintaining and growing our position in the field. That's a lot of money. And finally, during these 5.5 years, we've dispersed approximately $395 million in royalties and paid over $45 million in state severance taxes. So obviously, the point of that is that Altamont Bluebell is a major asset for EP, for the other owners in the field, and for the state of Utah. EP Energy is not opposed to horizontal drilling. In fact, we are successful and experienced horizontal driller in the Eagleford and Wolfcamp plays. And we've been observing the results of horizontal drilling in the Altamont area since the first horizontal well was drilled back in 2012. And if we thought that the horizontal drilling technology would economically improve resource recovery in Altamont compared to a vertical drilling program, we'd be the first to embrace it. But we don't feel, based on our testimony today, that that has been demonstrated by the results of the horizontal drilling to date. Therefore, it's our position that before the board approves this application to extend 1,280-acre spacing for long lateral horizontal wells further into the field and displace vertical wells, it should require Axia to conduct a pilot program in the 139-138 lands to demonstrate whether or not the proposed horizontal drilling program will indeed economically improve resource recovery compared to a vertical program. And until proven otherwise, it's EP Energy's position that Axia's application, if approved, will actually leave resources stranded, leading to waste, and will be detrimental to the correlative.
I'm going to interrupt you and ask you to speak closer to the mic again.
I'm sorry.
Can you move the mic closer to you?
Yes. Sorry. So again, until proven otherwise, it's our position that Axia's application, if approved, will actually leave resources stranded, leading to waste, will be detrimental to correlative rights, and will not be in the best interest or maximize the value of the field for the benefit of the owners or the citizens of the state of Utah.
Thank you. We'll move on to Exhibit L1. Can you please describe? Oh, let me back up. We'll be presenting exhibits L1, L2, and L3 for our land portion of the testimony, where all of those exhibits prepared by you are under your input, review, supervision, direction, and/or control.
Yes.
Can you please describe Exhibit 1 and what we're looking at here?
Yeah, this exhibit shows EP Energy's area of operations in blue in relation to the current request, RAA 139-140, which is shown in red. It also shows the currently approved 1,280-acre area, RAA 139-138, in pink. Newfield's 1,280-acre order 139-134 is shown in green. Within the area of operations, EP Energy owns approximately 180,000 net mineral acres of leasehold minerals, as I said before. We own approximately 1,333 net mineral acres within the 139-140 lands. Except for the lands in 139-138, which are subject to conversion to 1,280-acre spacing, essentially all of EP Energy's area of operations is currently spaced on 640 acres with various well densities of 2 vertical directional wells per 640 to 8 wells per 640. In November 2014, the board approved Bill Barrett Corporation and EP Energy's joint application, RAA 139-124, for 80-acre density. That area, the area covered by that order is in orange. Our plans are to extend this 80-acre density into the part of the field that would include the RAA 139-140 lands once we have acquired sufficient data to justify it. Until Axia filed its RAA 139-138, all 1,280-acre spacing for long lateral horizontals has been outside of EP Energy's area of operations. We did settle with Axia on the 139-138 application, but we are now opposing this request because it covers a much larger area within our area of operations where we have a much larger material interest and have an ongoing vertical development program, as shown on the next exhibit, that will be displaced if this application is approved.
And do you have any further comments on Exhibit L1?
No.
We'll move to Exhibit L2. Can you please describe what this slide is showing and the importance of the information contained?
Yes. This exhibit focuses in on the area subject to Axia's 139-138, which is in pink, and the 139-140 lands in red to show EP's current vertical development in and adjacent to those requests. The table at the bottom summarizes the status of the 37 EP Energy operated vertical locations in and adjacent to 139-140. Excuse me. I've also added the 4 Axia Butcher Butte long lateral horizontal wells in red, the 2 that are in 139-138 are drilling, obviously, and the APDs have been submitted for the 2 in 139-140. EP Energy has been acquiring leasehold in and to the north and west of 139-140 since 2011. Not only do we own 1,333 net acres in 139-140, but we also currently own about 4,400 net acres directly adjacent to 139-140, primarily to the north and west. And I would also say that, yes, we have probably less interest in this total area, than Axia, but that doesn't mean that our interest is not important or that it's not material to us or to this application. So since 2014, we've been deliberately moving our vertical development into the south half of 2 South, 2 West, and 2 South, 3 West. We've drilled 6 wells, vertical wells, the 2 most recent being the furthest south in sections 19 and 20 of 2 South, 3 West on the northwestern corner of the application area. With those 2 wells, we now have 5 producing wells in sections directly adjacent to 139-140, and they're shown on in the black solid circles. In addition to those 5 producing wells, we have 32 planned locations in and adjoining 139-140. There are 15 with APDs submitted, which are shown in the half black circles, and another 17 that are being prepared for permitting, which are shown in the open circles. Our pre-permitting activities would include surveying, negotiating surface agreements and right-of-ways, and running and carrying surface title. It's taken an average of 17 months to prepare each of those 15 wells that we filed permits on for permitting. And we've spent over $545,000 on pre-permitting costs for those 15 locations, which averages about $36,000 or so per well. We've also spent an additional $125,000 so far on the 17 wells that are in various stages of being prepared. So we've invested a total of $670,000 so far to prepare these 32 locations for permitting, and will ultimately spend over $1 million for those 32 locations. I would say that normally we prepare locations for permitting and then we hold them in inventory until we're ready to drill them. But Axia's filing forced us to submit the 15 that we're ready now in order to attempt to protect our correlative rights.
We'll move to Exhibit L3.
Supplemental L3?
Yes, Supplemental Exhibit L3. Thank you for the clarification, Mr. Chairman.
Yeah, so this exhibit focuses in further on sections 29, 30, and 31 of 2 South, 2 West within the application lands. This is where EP Energy currently owns the largest working interest in those sections and is actively preparing wells to drill within 139-140. The purpose of this exhibit is to illustrate the detrimental effects of overlapping the proposed 1280 acre long lateral horizontal spacing over EP Energy's ongoing 640 acre vertical development program. Our 640 acre activity is shown in black on the slide, and Axia's proposed 1280 acre activity is in red. The wellbore paths for Axia's Butcher Butte 32 144H22 and 32 34H22 wells are assumed on this slide. Since those wells are confidential, we don't really know where the wellbores are going to be located. But and for illustration purposes, I've also added 2 hypothetical wells that could be drilled if 139-140 is approved, one of which would be an east-west long lateral horizontal in the north half of section 25 of 2 South, 3 West, and 1 dual lateral along the section line between 29, 30, 31, and 32 of 2 South, 2 West. In the lower left corner of each section in black is the current applicable spacing order, and so and at the right in black are details of the current spacing, and in red the details of the proposed 1280 acre spacing. So in considering Axia's request, the board has to consider the impacts of overlapping 2 conflicting development plans by 2 different operators. EP Energy contends that there are several ways that overlapping the proposed long lateral horizontal spacing over existing 640 spacing will create waste and negatively impact its correlative rights. One is by having the unit line setbacks of 330 feet and 560 for horizontals, while verticals are at 660. Second is having interwell setbacks of 330 feet between horizontal and vertical wellbores without any data to show that communication will not occur at that distance. The third is converting 640 acre units to 1,280 acre units when a long lateral horizontal well is completed. So first, the unit line setback issue. Under the existing spacing, EP's vertical wells have to be 660 feet from unit lines, while long lateral horizontals could be drilled to within 330 feet from unit lines toe to heel, and 560 feet laterally. For example, AXIA could drill an east-west oriented long lateral horizontal well along the northern boundary of Section 25 to South 3 West, 560 feet from our producing well in the southeast of Section 24. Also, the toe of that well could be 330 feet from our planned well in the northwest of 30 to South 2 West. So in the case of our producing well, we'd contend that our well would be suffering competitive drainage, which we could not economically offset. In the case of our planned well, we would have to move to a mirror location to protect our correlative rights, which would mean it would require a cost of $36,000 roughly and another 17 months of time to reposition that well, re-permit that well. Both situations would require EP to get a location exception for a mirror location, which further disadvantages EP. And that would impact all of the vertical wells that would be drilled around the perimeter of the application lands. As far as interwell setbacks are concerned, under the proposed RAA, interwell setbacks between horizontal and vertical wells would be 330 feet. EP contends that interwell setbacks that close will displace its vertical wells, causing waste and detrimentally impacting its correlative rights. For example, EP has filed APDs for 2 vertical locations in the east half of Section 29 of 2 South 2 West. AXIA has filed APDs for its long lateral horizontal wells with a surface location in the southeast of 32 2 South 2 West. Assuming a north-south orientation of the lateral and 560 feet from the section line, then our wells will be 340 feet and 470 feet away from that lateral. Our geologic and engineering testimony will show that drainage is likely to occur at significantly greater distances than 330 feet, and therefore those vertical locations will be displaced, and EP Energy will now be forced to move those locations, again at a delay of 17 months roughly and $72,000 in pre-permitting costs. But the important thing is that no matter where they are located, our vertical wells are at risk of suffering drainage from a long lateral horizontal well drilled at any time as close as 330 feet away. So in reality, even if a long lateral horizontal was never actually drilled, 12 of EP's locations within the 139-140 lands will have to be deferred at a cost of $432,000 in pre-permitting costs, just because of the threat that a long lateral horizontal well could be drilled at any time as close as 330 feet away. That, in our opinion, unreasonably strips EP of its correlative rights. Further, our engineering and geologic testimony will show that displacing vertical wells with long lateral horizontals will result in stranded resources and waste, because there's insufficient data to suggest that a horizontal well will be economic compared to our vertical program. EP will be forced to non-consent long lateral horizontal wells, even further stripping us of our correlative rights. And finally, the issue of conversion. Under the proposed RAA, existing 640-acre spacing converts to 1280s as to all future vertical, directional, and short lateral horizontals once a long lateral is completed. Since there are 2 operators in this area with conflicting development plans, it will be critical to know if, when, and how conversion actually occurs. Since their wells are confidential, we won't know exactly when AXIA's completions might occur in relation to our operations. So, for example, what happens if AXIA completes a long lateral horizontal while EP is in the process of drilling a vertical well? Are we now automatically diluted by in the well that we're actually drilling at that time? And what are the implications to contractual rights if EP Energy already has a JOA covering the 640-acre unit as to all depths with EP Energy as operator when conversion occurs? Mr. Gallegos has already testified that that JOA would just have to be amended. Well, that's easy to do if you have a single operator who's drilling the vertical wells and the horizontal wells and has a development plan. But when you have two different operators, it's a different story. What if EP Energy doesn't want to participate in horizontal wells? The JOA at 640 is a contract that's been set. And we consider that overlaying 1,280 acre spacing would be interference with our established private contract. So the bottom line is that EP cannot continue to invest capital in this area when it doesn't know when its interest might be diluted by conversion or that it might be offset by a horizontal well drilled by another operator as close as 330 feet away.
And did you have anything else to add to Exhibit L1, Supplemental Exhibit L2, or Supplemental Exhibit L3?
No.
And do you believe that Axia's request will create waste, negatively impact correlative rights, and fail to maximize recovery?
Yes.
Okay. I have no further questions for Mr. Walcher.
Okay. Mr. Bolda.
Yeah, we have a couple of questions, but in the interest of time, I will keep them brief because I think, again, we have some slides that'll help address some of their concerns and will better illustrate what that is. Mr. Walcher, do you know what the working interest of EP is in the subject lands, or can you confirm that it is approximately 10.4% in the lands that are at issue today?
Yes, I think if you divide 1,333 acres by 1,280, that's about what you get.
Okay. Another question. You mentioned that EP would be stripped of its correlative rights if the spacing request was granted, but you could still participate and develop those resources. And you mentioned that you would probably non-consent. Why wouldn't you participate to protect those correlative rights?
Well, I think if we felt that it was uneconomic to participate in a long lateral horizontal well, we would not participate. We would be forced to non-consent.
Okay. That's all the questions we have at this time.
Division?
We will await the testimony from Axia. No questions for this witness.
Okay. Board members?
A quick question for both. First of all, you mentioned that Axia and Newfield's ownership in this area is about 70%. How much Axia, how much Newfield?
I can answer that. Let me.
And then while they're looking that up, question for EP. Are there some 1280s in this proposed or in this request where EP has no interest?
No, there are 4 sections in the 20 sections that EP currently has no interest. But in the event of a 1280 conversion, we would be impacted and involved in each one of those.
Okay.
So we have an interest in the other section that would be involved.
Okay.
Yes, in answer to your question, Axia has approximately 52.5% of the interest within the area being spaced, and Newfield has approximately 19%.
Any other questions? I have one. On your vertical wells, are they single formation wells, or do you have multiple completions?
Well, that'll be part of the engineering and geologic testimony.
All right. We're going to take about a 10-minute break and keep motoring through. So anything you can do to
Trying.
expedite this would be appreciated.
Trying, Chairman. Thank you.
Board members, let's meet in the break room for quick discussion.
At 3 o'clock in the afternoon. What do you expect? I mean, read it all. No, you did. I'm telling you, it's kind of gelling right now to me. That we've kind of poked holes in theirs to begin with, slips across. But now it's almost like we've done that. Just I'm giving this support for the holes that we poked. All right? Is that what you're thinking as well? Or? Yeah, he is. Yeah, well, and again, that's why I just said, I was like, look, this is pretty simple. The board's going to decide in this area, and who do you believe? And the answer is, there's not enough information.
Which one is that? That's in section 24.
That's
24 northwest southeast. I think these are the no. See, these are just these are the producing ones. Sorry, 24 Anderson Raleigh southeast 24.
Just fine.
Council, are you ready to proceed?
I'm ready.
Okay, we're
Ready.
back on the record. Mr. Chicken, would you call your next witness?
I will, Your Honor. For the geology segment of our presentation, I'd like to call Miss Angela Kennedy.
I haven't been sworn
in. Ms. Kennedy, could you please state your full name and title for the record?
Angela Dial Kennedy, Senior Geologist with EP Energy.
And have you ever testified before this commission or this board before?
No, I have not.
I'm going to ask you to please provide the board with your educational background, your work experience, and your overall experience in petroleum geology for purposes of expert witness qualification.
Certainly. I'll start with my educational background. I have a Bachelor's of Science in Geology and Geophysics from the University of Texas at Arlington. I continued to get my master's degree at the University of Utah in 2011. I've worked in oil and gas since 2004, moving into EP Energy since May of 2015. Is that it?
I'd like to offer, based on that testimony, I'd like to offer Ms. Kennedy's testimony as expert witness testimony in geology.
Mr. Chicken?
No objections from Axia.
No, the division doesn't object and understands that there was an emergency which required Ms. Kennedy to appear, so we appreciate her taking on the task and have no objection to her testimony.
Thank you. Board members? She's so omitted for the purposes of geology.
Great, thank you. We'll be presenting exhibits G1 through G8. Ms. Kennedy, were those exhibits all prepared by you or under your or with your input, review, supervision, direction, and or control?
Yes.
Okay. With that, we'll move right into exhibit G1. Can you please describe for the board the contents of this exhibit, please?
Certainly. Supplemental Exhibit G1 illustrates the induced and natural fracture orientation. The induced fractures are represented by the red ellipses, and the natural fractures are represented by the green ellipses. The natural fractures have a strong east-west orientation. Now, the purple lines that are illustrated are the induced or hydraulic fracture trend orientation. This is the orientation that the proppant fractures will want to go to if no natural fractures are present. Now, as you move from east to west, the induced fracture angle goes from a northwest southeast to a north-south, and then moving to the west, it shifts to a northeast-southwest orientation. EP has utilized a well in Section 24, Township 2S 4W, with an induced fracture orientation of north 20 degrees east, and also a well in Section 15, 2S 3 West, with an induced fracture orientation of north 12 degrees west. Now, we used that data to calculate a north-south induced fracture orientation in the western part of the application lands. Also to note on this exhibit, there's a dashed line in the lower left-hand corner of the exhibit, and that's what we'll be discussing in Supplemental Exhibit G2.
Any further statements regarding Supplemental Exhibit G1?
No.
This is Exhibit G2. Can you, and I understand that this is the blown up area from the prior exhibit, correct?
Correct.
Okay. Can you please describe what we're looking at here in this blown up area?
Sure. This is an example of horizontal and vertical well communication. So the induced fracture trend is north-south, with fracture trend trending east and west. EP's vertical well, the Moore 123C4, is located in Section 23, Township 3 South 4 West, and it was completed prior to the horizontal well, the Thompson 4-22-3-4. This is located in section 24, section south, 3S 4 south. Now, during the proppant fracturing of the Thompson well, we saw communication in the Moore 123C4 well, which is approximately 1,850 feet apart. Now, since the induced fracture orientation is north-south in this area, that 1,850 feet communication could only come from natural fractures.
And I just want to clarify, was there, this illustrates the communication experienced, but not enough data to see an effect on actual resource at this point in time. Is that correct?
Correct, non-prediction, and the engineering also has a slide.
Correct, absolutely.
related to this.
Any further information regarding Exhibit G2?
No.
Okay. Moving to Exhibit G3, if you could please explain the contents of Exhibit G3 to the board.
So Exhibit G3 illustrates the proposed stand-up 1280-acre correlative rights effect. So this is an example of Axia's proposed stand-up 1280-acre horizontal well in the western portion of the application lands. This exhibit shows a 334 feet average effective half length of the proppant fracture, which is presented in cause 139129 for the upper Wasatch, which is based on microseismic. The effective angle is north-south in the western part of the application lands, as we described in Supplemental Exhibit G1, which means this results in the prop fracture extending 4 feet across the unit line. The natural fracture orientation is east-west. Axia's Exhibit M well, the SA10-22 well, has over 600 natural fractures. 40% are open or partially open in an east-west orientation. So EP Energy has seen fracture communication up to roughly 1,850 feet, as indicated in Exhibit G2, and we're very concerned about the proposed 330-foot setbacks between the horizontal and the vertical wells and the probable east-west and north-south communication in the offset units.
And so you believe that that foregoing testimony, the result of that is that EP is going to see a negative impact on its correlative rights based upon the setbacks Axia is asking for?
Correct.
Any further statements regarding Exhibit G3?
No, thank you.
Exhibit G4, if you could please describe what we're looking at here.
Sure. Exhibit G4 illustrates the proposed laydown 1280-acre correlative rights effect. So this is an example of the Axia proposed laydown 1280-acre horizontal well. Proposed laydown horizontal well can be 330 feet from the unit line. There's an east-west natural fracture trend, and EP Energy has seen fracture communication again up to that 1,850 feet, as illustrated in G2. We are very concerned about the proposed 330-foot setbacks between the horizontal and the vertical wells due to the communication and the competition for the same reserves. And we believe that this affects correlative rights and causes waste. There's probable east-west and north-south communication in offset units and within the unit with the 330-foot offset between wells.
Any further statements regarding Exhibit G4?
No.
We'll move on to, this is our what we'll call replacement Exhibit G5. If you could please describe what we're looking at here. I understand it's maybe and kind of compare it to Axia's as well.
Correct. This is Exhibit G5, which is EP Energy's petrophysical model over the Uteland Butte in the SA10-22-22 well. Now, this is the same well and interval that Axia ran their model, which they just presented on. EP Energy has a working interest in this well. It is a multivariable statistical model by EP Energy's own petrophysicist. Both Axia and EP models are relatively simple, and by that I mean they don't take into account heavy metals or kerogen. The table, we're going to spend a little time talking about this table. The table shows both EP and Axia's model inputs and reserves for the Castle Peak and the Uteland Butte frac zones. Now, there are significant differences in the net pay, oil saturations, oil in place reserves recoverable reserves between the two models. So let's talk about that for a moment. If you look at the table, you see 4 rows. The top 2 rows are relating to the Castle Peak, and rows 3 and 4 are related to Uteland Butte. I have to push it away to see it. Now let's look at Castle Peak first. Axia has a net footage of 222.5 net pay feet of net pay, versus EP Energy's 106.3 feet of net pay. Going to Uteland Butte, Axia has 282, virtually the entire Uteland Butte section, 282.5 feet of net pay, and EP Energy has 91.75 contributing to net pay. Going back up to the Castle Peak, looking at effective porosities, they're different between the 2 intervals and between the 2 companies. Axia's Castle Peak at 7.1 versus EP Energy's 5.3, and Axia's Uteland Butte at 7% versus EP's 8.3%. Looking at the oil saturation, that's primarily our biggest difference there. We have Castle Peak, Axia's at 79.1% versus EP Energy's 28%. Looking at Axia's Uteland Butte target, they have 74.8% versus EP Energy's 28.5%. For the rest of the table, we kept those as static numbers as far as area, recoverable, and wells, which calculate into the reserves. If you divide it by the wells, you get the recoverable reserves per well. So looking at Castle Peak, Axia at 1.1 million versus EP's 139,000, and Axia's Uteland Butte at 1.3 million versus EP's 192,000. Now it is important to note that Newfield and cause 139134 for a 1280 horizontal Uteland Butte well calculated 80 feet of net pay, 10.7% porosity, 54% oil saturation, and an oil in place of 32 million barrels of oil. Newfield and 139134 presented a decline curve analysis of the Uteland Butte predicted recoverable reserves of 610,000 versus Axia's volumetrics of 1.3 million. Historically, petrophysical models to calculate volumetrics have been very inaccurate due to inconsistencies and uncertainties and are seldom close to decline curve analysis. EP has never used volumetrics to calculate reserves because of the disconnect between the volumetrics and the actual production. EP's utilization of the petrophysical model is for lithology determination and not volumetrics, which are inaccurate. EP believes Axia's oil in place and recoverable reserves are extremely optimistic. Axia has not completed any horizontal wells within the application lands that can confirm this recoverable oil. This exhibit also shows Axia's Uteland Butte frac zone of 300 feet. Newfield has previously submitted testimony in cause 139134 that they believe the extent of the vertical proppant frac is only 145 feet based on microseismic data. So there's significant doubt that Axia can over double the frac height of Newfield's Uteland Butte wells. Axia has presented no evidence. We feel that they can capture the 300 vertical feet, and there's no data within the application lands.
And so, I mean, as a main thrust, this slide is good to illustrate then the wide differences that we're seeing in petrophysical models between Newfield and Axia and EP, with different petrophysicists developing these models and still coming out with widely different numbers.
Correct. Yes.
And in your opinion, is the relief sought by Axia going to strand reserves based on this petrophysical model?
Yes.
Yes. Any further questions for replacement exhibit G5?
No.
Okay. I should say further statements.
Yes.
Sorry. Moving on to replacement exhibit G6, if you could explain to everyone the contents of this exhibit, please.
Certainly. Exhibit G6, I'm sorry, replacement Exhibit G6 shows the area of preferred geologic facies, which represents greater oil and gas pay. So there are 3 zones that are illustrated. You have a northern zone, a middle zone, and a southern zone. And what is being illustrated is a northern source that is extending down to just below or just right at the southern extent of the application lands. But you also have a southern south that's extending roughly about 2.5 sections above the application lands. So what you end up with is this zone that captures the overlap of both the north and the south source geologic facies. So the approximate sandstone-rich southern edge changes to a carbonate-rich south of the application area. The deeper south-sourced oil and gas-rich geologic facies was identified with EP's 3D seismic and geologic evaluation of both the EP Kendall Well 315B2 and the Huber 313B2 well, and most wells EP has drilled in C4, which is 3 south, 4 west. 2 wells that did see this south source geologic facies were Axia's 2 type wells, the Cook 126B1 and the Destin 122B3, which are directly adjacent to the application lands and illustrated there. Both of these wells have produced or have an EUR of 400 to 421 MBO and 527 to 600 MMCF and are located in this overlapping preferred geologic facies. EP believes that there is approximately 4,700 feet of Wasatch and Lower Green River pay interval available. The application lands are located with maximum north and south source geologic facies. These lands may be more sandstone rich than the Central Basin area to the south. Axia's data used from the south may not be the same as the application lands and therefore not applicable.
And so based on this, I mean, is it then, you know, your opinion that the best way to access all 4,700 feet of that Wasatch Lower Green River Reservoir is going to be a vertical well?
That's our belief, yes.
Any further statements for this exhibit?
No.
We'll move on to supplemental exhibit G7.
Okay.
Please explain what we're looking at here.
So supplemental exhibit G7 includes Axia frac zone intervals and production logs illustrating stranded reserves. So what you're seeing is wells within or nearby application lands. The map inset kind of illustrates where these are located with respect to the application lands. The tops in the frac zones are related and correlated back to Axia's top and frac zones that they've presented before. Previously. Now you see several red circles. The red circles show production log production, which lands outside of Axia's 5 primary targets and the 4 exploratory targets. So let's start by looking at the first well. On the left, the Kendall 315B2. You see 2 circles illustrating 2 areas of production log data. The first area falls between the exploratory Wasatch 3 and the Flagstaff frac zone intervals as Axia is illustrated. This production log came back with 209 barrels of oil per day and 204 MCF of gas. Now the lower interval is beneath the Flagstaff frac zone, and it included 500 barrels of oil per day and 900 MCF of gas per day, which again illustrates stranded reserves if you're looking at their exploratory and primary targets. If you go to the Huber, which is the very next well, the Huber 313B2, you get the same zone beneath the Flagstaff with 191 barrels of oil per day and 1.4 MMCF. If you move over and look at the Powell, which is third to last, you see another production log data point, which is above the Garden Gulch zone with 132 barrels of oil per day. The vertical wells can access the entire 4,700 feet of potential oil and gas pay. The horizontal wells will strand resources, and it is doubtful that the horizontal well economics could access all of the oil and gas reserves.
And did you have any further statements regarding Exhibit G7?
I did not.
Okay. And I just want to be clear, let's move on to G8 and then we can go back.
Okay.
Supplemental Exhibit G8. Can you please describe what we're looking at here?
Sure. This supplemental exhibit G8 is EP energy wells that will be affected by the 139-140. This is the EP energy well locations within the surrounding Axia proposed 1280 acre spacing. The application area is outlined in red, and the Axia proposed horizontal locations are in blue. The solid red circles are 16 of EP's well locations that will be directly affected by cause 139-140. The open red circles represent EP Energy's well locations, 28 of which are within or directly adjacent to application lands.
And so, based on this, I guess is it EP's opinion that the horizontal well setbacks of 330 feet sought by Axia is going to be inadequate to protect relative rights?
Correct.
Okay. Any further statements regarding Exhibit G8 or supplemental Exhibit G8? Sorry.
No.
Okay. And based on your testimony and on the information contained in Exhibits G1 to G8, do you believe that Axia's request will create waste, negatively impact correlative rights, and fail to maximize resource recovery?
Yes, I do.
Okay. I have no further questions for Ms. Kennedy.
Mr. Bolda?
No questions at this time.
Division?
I think we'll wait until, if we could reserve the right to recall if necessary. Thank you.
Noted.
John's got some.
Oh, we do have a question, sorry.
Could you go back to the slide that has the orientation of the fractures and the induced fractures?
G1, I think it is.
G2.
G2?
Yeah, right there.
Oh,
Oh,
that's G3. Those are the.
Yeah, that's good. That's good enough right there. Why are the induced fractures running opposite direction of the natural fractures?
yeah. Right. I think this is more related. Let's see, G3. Right, because this is the stand-up, and the effective angle is north-south in the western part of the application lands. So if you go back to G1, it's mostly relating back to that north-south orientation that we've calculated.
I guess what I'm trying to understand, doesn't the induced fractures follow the natural fractures?
No, these are hydraulic or induced fractures, and they're somewhat oblique or sometimes perpendicular to natural fractures.
Mr. Chairman, we might, actually, there was one other question or point of confusion with regard to Exhibit G2. If you could put that up, as long as we have taken the time, we'd like to ask this question. Go ahead, Mr. Doucette has a question.
So on this example, you show the direction of the horizontal going north-south, correct?
Correct.
But in this area, aren't they proposing to drill east-west? And if so, how does that change your testimony?
And I just would want to clarify before she answers that that piece of it was just amended on the fly, that they're now only going to drill east-west in that area. And so part of this was we didn't know if they were going to drill north-south or east-west in that area based on the application. So anyway, just make that clear to everyone that was just changed. So go ahead.
So I still have the question, how does that affect your testimony?
Could you repeat the question?
On G2, and I think on subsequent exhibits, a lot of your testimony had to do with the information derived from G2.
Mm-hmm.
But that was based off of a north-south orientation of drilling on the well, and now the testimony today is different. Or has been set that on that western half where these fracture patterns are seen, they're going to drill east-west. So how does that affect your testimony on this exhibit and the other ones you relied on the information from this exhibit?
Right. I was a little confused at first, but since the natural fracture orientation is east and west, and we see that wellbore communication between the Moore and the Thompson well, you see that it would extend beyond that. So I don't think it would change my testimony at all.
But if you're drilling parallel to those fracture patterns, does that not change your testimony?
You would still be in communication.
So so what you're saying is the induced fractures create the potential for communication regardless of which way the well is oriented. Is that correct?
Correct. Natural fractures. Correct.
Okay. Thank you. Yeah, natural, not induced.
Mm-hmm.
I guess maybe the easier way to look at it is if you've got, I think both parties have established the east-west natural fracture system here, and it doesn't matter if you cross that perpendicular or parallel, you're still going to be hitting that east-west fracture and allow the migration to go and follow wherever that fracture goes rather than stopping it. So, for example, I think in this one, if you were to assume an east-west drill that still touches a natural fracture, it can still then go that distance, and that's kind of what what they're trying to get at, I believe. But if I'm incorrect, correct me.
So you're more or less likely to encounter those natural fractures in the west half.
You know, I'd love to have more data that would tell me if I'm more or less likely.
And are the induced fractures as conductive as the natural fractures?
Yes. More, yes.
Okay, no further questions.
Board members? Start on this end.
Maybe I wasn't paying close attention, but the 1850 distance they're using for the communication or the length of potential communication of these fractures?
Yes.
That's based on just these two wells?
Correct.
You haven't seen any communication in any of the other wells out in this area?
We haven't drilled enough, and we don't have a lot of data in this area.
Okay, thank you.
Carl, do you want to help me here? I don't understand, and I'm not a scientist, so. But it would seem to me that pressure would follow the path of least resistance,
Mm-hmm.
and the path of least resistance would be a natural fracture.
Mm-hmm. Correct.
Right. And that, as we've seen other hearings, of course they're correlating from a larger area, but it looks like it's generally a northwest southeast fracture, assuming north is straight up, and that drilling through that, the induced fractures would be on the same orientation. You're basically saying it's just exactly opposite of that. Is that so? Let's use the green and the red on Exhibit G2.
Okay.
So the green, pardon me, the red is the natural fractures, correct? Is that, am I understanding that? Pardon me, the green is the
Right. Green is natural fractures. Red is the induced fractures.
Okay, that's right. Tell me again why the induced fractures would take a harder path than following the natural fractures.
This is data that we've gathered from our own data set from XRMI and FMI data. We've actually excluded all of the low confidence data even out of those data sets. And these are the fracture trends that we're coming up with. So for the induced, and they include induced and natural fractures, open, closed, so on and so forth. So if you look back at G1, you see that shift of that data as you move from east to west and that orientation shifting as you go along. So depending on where you are over the application lands, you're going to see a different orientation of that.
And actually I had an exhibit where they had a compass and they had the blue lines basically going that showed the
A rose plot diagram, yes.
That was over there.
Mm-hmm.
But that's the best your opinion is right now, that that it's opposite of the path of least resistance.
This is the data set that we have to go on and that we have confidence in, and it's our interpretation, but it is.
Okay. Thank you.
And Mr. Chairman, I think the point that EP is trying to make here is that, again, there's not enough information to get some definitive stuff here, but this is 2 real wells that experienced real communication at 1,850 feet. So what happens when they're, 330 or 660 away from each other? And that's the point of that.
Well, let me ask a follow-up question then. The communication could be both positive and negative. Is that correct?
I suppose it depends on which well you're talking about. But
Well, let's say that you have the well shown on G2 with both the red and the green.
Mhm.
And let's assume that a horizontal well is drilled within what you would call the communication zone.
Mhm.
There is a circumstance where it could, the horizontal well could drain the reserves from the vertical well, correct?
Correct.
There's also a circumstance where the horizontal well could add reserves and communication to the vertical well.
We haven't seen evidence of that here, but
Theoretically?
theoretically.
Okay. Thank you.
Can I follow up?
Please.
Do you have any evidence of any kind of structural occurrences of, say, faults, or is there have you done any stress strain models in the area of these 2 wells? I'm a little concerned that we're using 850 as the basis and then extrapolating it throughout the region. Could there be some minor faulting, or is there a change in the structure there that could have induced 1,850 feet of communication?
That's a good question, and we just don't have that answer for you.
Thank you.
Mr. Chicken, call your next witness, please.
Certainly. I'm going to call Mr. Steve Biancardi. He'll be sitting here momentarily. Mr. Biancardi, can you please state your full name and title for the record?
Stephen Biancardi, Reservoir Engineering Advisor for EP Energy.
Have you testified before this board before?
Yes, I have.
On engineering matters, correct?
Yes, I have.
Have you testified as an expert before this board before?
Yes, I have.
Based on that former qualification, I'd like to move the board to have Mr. Biancardi's testimony and evidence submitted as expert testimony.
Mr. Bolda?
No objections.
No objection.
Board members? He's so admitted.
We've got Exhibit E1 up on the board. And if, Mr. Biancardi, if you could explain E1 and what everybody's looking at here.
This is this slide here represents EP Energy's drilling activity, vertical drilling activity since from 2011 to 2016. We've drilled 157 wells during this period. I would like to point out that, or note that, well, to the left there's a color code that tells you what the year that the wells were drilled, and so you can get a sense of activity per year. In 2015, during the price of lower commodity prices, as a result of our vertical program, we were able to continue drilling, and we drilled 33 wells during that period, and when many other operators terminated their drilling programs. We have drilled well to the southwest, west, and north of the RAA area, and with respect to the initial completions of these drill wells, we typically will drill or complete 7 or 8 stages of the Wasatch and then put the well in production after that point.
Do you have any further comments on Exhibit
No,
1?
this slide here just shows our activity for the from 2011 to 2016.
Exhibit E2, can you please describe?
Yes, this is our recompletion activity for the same period. We've recompleted 159 wells, and this is a central part of our EPE's vertical program. What we're doing here is as I stated in the original drill and complete, we typically will complete 7 or 8 stages of the Wasatch. We leave there may be 1 or 2 more stages of the upper Wasatch, and then the lower Green River yet to be completed. And then this slide here shows our efforts of recompleting those zones. This is accomplished by setting a plug over the existing production and perforating the wellbore to add additional zones, and then stimulating the zones with either prop and frac or acid treatment. And this, particularly for the lower Green River, there's water zones to be concerned about. So if there's a water zone present, we'll pump acid at lower rates to minimize the height growth in an effort to stay on the productive zone and avoid the water. We generally produce the recompleted interval by itself to reduce the initial bottom hole flow and pressure, then either drill out the plug over the existing production, combining the recompleted interval with the originally completed Wasatch, or we can do a second recompletion if we have additional lower Green River available to us, and then we'll produce that and then combine all that at the same, combine all after that flows down a little bit, we'll drill out the plugs over both the first recompletion and then the original recompletion, and basically combine the full flow. So we'll have all of the Wasatch producing and all of the lower Green River producing. We've recompleted 159 wells since 2011, and we've improved the initial IP30 rates of those recompletions from 70 barrels a day to 200 barrels a day through our efforts and through our learnings of what zones are productive, since the petrophysics are difficult to ascertain, and with respect to water producing. We've done some testing and individual testing, and we have a better understanding of which zones produce water and which zones are more productive of hydrocarbons. And with that, we've increased our results 130 barrels a day over that time period. For 2016, we've recompleted 34 wells a day, and it contributed 4,000 barrels of oil per day just from the recompletion activity. And that's 4,000 barrels out of our total of 16,000 barrels of oil per day that we're currently producing now. So the recompletion program is adding or contributing 25% of our total production. So it's a critical part of our vertical program, and which allows us to complete the full wellbore and put it all in production.
Any further information on Exhibit E2?
No.
Moving on to Exhibit E3, if you could please describe its contents.
This slide here represents our activity over in a given area. This is in the C4 area, 3 South, 4 West. The blue dots are our EP Energy's vertical well activity, and the orange dots are over there in 2 South. Some part of it is in 3 South, 4 West. Some parts are in, the bulk of it is in 3 South, 3 West. The orange dots are the horizontal wells, and there's some black dots in there, which are the vertical wells. The purpose of the slide is to demonstrate our pace and ability to develop its resources vertically and compare EP's activity to an adjacent area. In this area from 2012 to 2016, we have drilled and completed 87 well bores. 85 of those have been completed. We're currently completing one well bore, and one well bore is yet to be completed. Many of the sections drilled have third and fourth in section wells in them, and since June or through June 2016, we produced over 6.9 million barrels and 11.1 million cubic feet of gas. In addition to the initial completions, we've also recompleted 28 of these well bores into the upper Wasatch and lower Green River, which I described on the earlier slide. During the same time period in the adjacent area, there have been 13 vertical wells drilled and 23 horizontal wells drilled and completed, and cumulative production from those wells has been 3.6 million barrels and 4.9 million cubic feet of gas, or 4.9 BCF. 2.6 million barrels and 3.9 BCF are from the horizontal well bores. This slide here is just to show to illustrate that through our vertical activity we can develop our resources rapidly.
Any further comments on Exhibit E3?
No.
Going to Exhibit E4, if you could please describe what we're looking at here.
This is a depiction of 4 sections. We have 4 wells in 4 vertical wells in section 14. Where we got section. This is all in section 14. Section 14 is C4. Section 23 is C4, which are the vertical wells. And section 13 is C4, and section 24 is C4. Adjacent sections which have 1 horizontal well each. And this illustrates how. Okay, so there's a depiction of the 4 vertical wells. Excuse me, the vertical wells in section 14 and 24, and how the horizontal wells relate to them. And in the middle is a cross section showing the. On the left is. Okay, to the left is the moon, and 114C4, and to the right is the more 123C4. And in the blue blocks show where we have our initial completions and our targeted recompletions in the Wasatch and the lower Green in each of those well bores. And the red blocks show the target interval for the horizontal well bore. So this is really the difference between the horizontal program and the vertical program. The vertical wells will drill through and complete the Wasatch initially, and then add the upper Wasatch and lower Green River formations to that vertical wellbore to where the whole wellbore is completed, and all the resources available that contacted by that wellbore have been completed and on production. Versus the vertical or the horizontal well, which targets one interval, and it can't access any other formation or intervals other than the interval that it targeted. So it's a difference in the concept of and philosophy of how to develop the resources, either vertically or horizontally. And just with respect to the activity over the same time period, the EP Energy, we drilled 7 wells in 2 sections. The cumulative oil production has been 600,000 barrels of oil and 700 million cubic feet of gas. The 2 horizontal wells drilled have produced 200,000 barrels of oil and 325 million cubic feet of gas. Again, showing that the vertical wells, the recovery and resource recovery of the vertical wells is more rapid than has been demonstrated here by the horizontal program.
Any further statements regarding Exhibit E4?
No.
Move on to Exhibit E5. If you could please describe the contents of Exhibit E5.
Yes, this is the Moore 123C4, which was discussed earlier in the geologic presentation. And to the right, and this is our well. To the right, they have circled when the Thompson horizontal well was completed to the east, and our well was producing about 150 barrels of oil, and then went to 0, and we were producing about 250 barrels of water, which is the blue line, and it jumped up to 500 barrels of water per day. This aligns with the exact date of the initial completion of the Thompson offset. And then over time, the well did recover. What we're seeing here and demonstrating is communication between the well, but we'll say that we haven't seen any a loss of resource from this well bore, but we are seeing communication between the 2 wells.
Any further information you'd like to provide about Exhibit E5?
Yeah, the concern here again is that the 2 well bores are 1,850 feet apart, and we're concerned about what happens if they're 330 feet apart. would there be a loss of reserves or damage by the activities of the two wells being next to each other.
We'll move on to the final supplemental exhibit E6, which is the final engineering exhibit.
Yes, what I'm illustrating here is comparing the vertical program in the B2, B3 area to a horizontal well in that area, a potential horizontal well in that area, and it's basically a type well analysis. In this area, we're expecting to recover vertically 425,000 barrels of oil. It was developed on a zero-time curve of the wells drilled in the area. But it was also tied to the way we're doing our recompletions. So the recompletions are timed about 2 years out. The way it works is that on the left is the vertical well. We do the initial completion in the Wasatch. Our type well is showing we're recovering about 400 barrels a day initial. We let that produce for about 2 years or so, and then when we get to about 40 barrels a day, that's when we start kicking in our recompletion program. And this plot here is showing that we expect to have 2 recompletions in this wellbore and then a drill out. So the first recompletion would bring the well up, and we set a plug over the Wasatch, and then we would do that completion. In this area, we're getting about 165 barrels a day initial rate, and then it declines. We let that decline to about 40 barrels a day again, and then we do our second recompletion, which is showing exact or similar IP30, 165 barrels, but it's going to be a little bit less interval. So it's the volume that it contributes is a little bit less. So we let that decline down in a shorter period to 40 barrels a day, and then we do a drill out, which then combines the second recompletion with the first recompletion with the original Wasatch completion. That brings on about 120 barrels a day. We usually see some flush production, so there's a fairly steep decline off of that, and then it levels out and then declines to its ultimate recovery. Running our drilling capital for this area is $4.3 million to drill and complete the well originally. Then we have future capital of $740,000, which for the 2 recompletions and the plug drill out, and that results in a 25% rate of return. This is a typical rate of return that we've been seeing in a vertical program. It's based on 100% working interest, just 85% net revenue, just setting it up, and then we did run it on a 5-year strip. From 45.50 to 54.35, and then we're flat pricing after that. The gas price goes from 302 declining down to 296, and then it's flat pricing after that. Again, that yielded a 25% rate of return. Then I looked at the 1280 horizontals that were available to me. I pulled all the horizontals that were 1280 horizontals that Newfield had drilled in 3 South, and had 20 wells that I modeled. I came up with, did a zero-time analysis on that, basically bringing all the wells at the zero time just so you get an average well performance. Then I went and forecasted each of the wells to get a reserve trend. And basically the analysis yielded the same result. So I have the horizontal wells based on the horizontal wells drilled by Newfield, delivering about 423 MBO and 860 million cubic feet of gas. Using the same, using 11.8 million as a D&C capital for that well, and the same pricing that I use and same working net revenue that I use for the vertical program, I get a 6% rate of return, which is our concern, and we're seeing that we can develop the resources vertically and get a good rate of return, and then horizontally, we've looked at the horizontal program several times, and we just haven't been able to make the numbers work for us. And then we also believe that the other component is that we do believe restraining resources. We can complete the full Wasatch Lower Green River stack with a vertical well versus committing to one interval and a horizontal well.
And just to make a clarification, there's been a bunch of discussion about east-west fractures. Can you discuss how the vertical wells can also take advantage of those?
Well, the vertical well, this one thing that we can do with the vertical well program is one is to avoid sharing reserves, and if we can, like right now we're spaced 4 wells per section in this area. As Mr. Walter mentioned, that there's 80 acre spacing to the west. We're very interested in spacing or getting 80 acre spacing to the east. And then we can space our wells to where they're off pattern or off azimuth, to where the wells aren't interfering or communicating with each other, particularly with the east wells, the east-west natural fractures. And then knowing what the induced fractures are, basically you can spot your well so that you can minimize the interference from one well bore to the next.
Okay. Did you have any other information to add in connection with Supplemental Exhibit E6?
No, I guess the only other thing I would add is that currently we are spaced 4 wells a section, and we do believe that it may take more than 4 wells a section to fully develop the full resource. That's why we're very interested in the 80-acre program, which would give us 8 wells in this section, and then we would evaluate the performance of those, and which we have spaced in the to the west and in the south half of B4 and in C4. Evaluate that performance, get some well data, and then bring that to the board to see if we can extend, if warranted, which we believe it would be, if warranted, extend that spacing over to the lands to the east so we can drill more wells and recover more resources vertically.
Okay. And just as a few more questions, were exhibits E1 through E6 prepared by you or with your input, review, direction, supervision, and control?
Yes, they were.
And do you believe that that AXIA's request will create waste, negatively impact correlative rights, and fail to maximize resource recovery?
Yes, we do.
Okay. I have no further questions.
No questions.
We have a few. Mr. Doucette would like to ask a question about Exhibit E5.
Yeah, so when that went to 0, so you had no production from that well at all? For what period of time?
Well, for 1 day.
1 day?
We took the hit for 1 day, yes, sir. That's where the, just to the left of the arrow, you can see the production spiked, and then the green line is the oil production, and it went to 0 on that day. But then the well did recover, and then and along with the increase in the water production. So basically, you managed through that, and essentially work the well to get the well back online, and recover the resources.
So there was no mechanical issues with the well bore?
No, no, sir, there was not. It was just an influx of water that took the well down. Yes, sir.
And then, as you go farther in time, like into late December, January time frame, it's actually up higher than what you were prior. Can you explain?
Right. Well, it goes to
that?
Yes. Okay. So we're seeing some communication, but we're about 150 barrels a day. Then, if you'll see that there was a to the right of that arrow, the well ticked down twice, or actually it's 2 days. I don't know if you can see that from your end, but the first failure there, that was an alarm, high level alarm that shut the well down, and then we started getting some gas interference. So basically, we lost production for a couple of days, and then they worked the well to get it back on trend. And then you can see that we're about, before this event, we're doing about 150 barrels of oil per day. And then as you work through some of that, yes, the initial production was a little bit higher, but it worked its way back down. So I mean, we're seeing that the well recovered. We are seeing communication, but we really aren't seeing a reduction in reserves. And but then again, this is 1,850 feet apart. This is our concern, and we're thankful that the well recovered, but we're also concerned about the 330 spacing that is offered in this RAA.
Mr. Biancardi,
Yes.
you testified that you examined the new field production in the area to the south of the application lands. Is that right?
Yes, sir. I looked at, I pulled the production and created a 0 time and actually forecasted all the 1280s that they had. Yes, sir.
And have you examined any of the records in the forced pooling matters for those lands?
No, sir, I have not.
Well, it's my recollection, and I don't know if it was for the same lands, that Newfield decided to switch to horizontal wells because the vertical wells were not as productive, and that they classified their vertical wells as being good, I think, if they had greater than 20% recovery. I'm just doing this by memory, but it seemed that, from my recollection, most of their wells averaged, or else they didn't drill, more than 20% recovery for the long horizontal wells. How is that consistent with your 6% recovery finding?
Well, that was a 6% rate of return. That was an economic rate.
Right,
of return.
and I'm referring to their rate of return as well. I'm sorry, misspoke. I guess I'm just wondering how your analysis squares with what is apparently Newfield's experience.
Well, okay, I'm not familiar with that that hearing or that order, but I don't. There could have been the capital is different. I don't believe that Newfield was running capital this high. So if you're running capital against the same reserves or similar reserves, higher capital, then you're going to end up with a lower rate of return. I will tell you that I know that then in their 139, 134, they were quoting about 600,000 barrels of oil on average. On here, I was getting 450,000 barrels on trend and 425,000 barrels with an economic limit, because I'm quoting here economic reserves.
Oil prices were different too.
And the prices are different. Yeah.
Yeah, that's true.
But it's I think the prices could have been different. Most likely they were if it was several years ago, and I would venture to guess that the capital is different.
All right, thank you. That does help. And what is the area that you believe your vertical wells drain? Currently, the spacing allows less wells than I guess you think you'll be able to produce from.
Right. That's a very fair question, and since we're having problems with the volumetrics and the petrophysics and getting the production to match up with that, I can't give you a specific answer. I can tell you that we have drilled wells on a four well per section pattern, and we're not seeing production performance or production degradation from those four wells in a 4-well pattern. So that's why we're interested in trying the 80-acre pattern or 8 wells in a section, and so we can then determine if an 80-acre infill is appropriate. I would say that it's the 4 wells in perfect spacing would be 160 acres per well. I think the vertical wells are not draining 160 acres because we haven't seen evidence of sharing of reserves. That's why we're very interested in testing the 80-acre pattern.
And you've asked or through your counsel, and this may not be a fair question to you, that there be that this matter not go forward, that it's premature. That's Axia's request. Is there any reason that EP would have to drill in the same application lands during the period that the matter might be held in abeyance to see what happens with the currently being drilled horizontal wells? It's not a production question.
With respect to having to drill versus being able to drill, I would say that unless there's a lease, maybe Mr. Walter would be better able to answer that, what our leasehold situation is and whether we'd be losing leases if we didn't drill a well.
Thank you. One more question by Mr. Rogers, Mr. Chairman.
Could you tell me how many feet of pay are in the Moore 123 well?
Yes, I can tell you the gross interval on Exhibit E4. We have a gross pay interval of 3,610 feet.
3,610.
Yes.
And in the offsetting horizontal well, how thick is that pay?
In that well, we have 215 feet of gross pay.
So what we're saying is that 250 feet of pay has affected that 3,610 feet of pay zone to a zero production?
Yes. Yeah, the east-west natural fractures, they can be very conductive, and that's where, you get an influx of water from the stimulation job, and if the system or the production system of the next example, the Moore 123C4 can handle it, it would just shut down.
So the roughly 3,300 feet of pay produced nothing over that period of time?
Well, for that one day, until we were able to recover it, yes, sir.
Okay.
That's all the questions the division
Okay,
has.
board members?
Did any frac sand get recovered in that well along with that water, or was it just frac fluid?
No, sir. The oil went to 0 and the water went to 500.
Was that? Could you tell if that was frac water or formation water? Was there any way to tell?
We don't have a test on that. We do know that event occurred at the same time that the Thompson well was being completed.
Okay.
I mean, it's just more of a, the well went down, and, why, basically you're searching for a reason. Why did the water increase, from 250 to 500? And then we found out that the Thompson well was being completed at that time.
There's an old adage that I try to live by, and it's better to remain silent and thought the fool than open your mouth and remove all doubt.
Confirm it.
But can we go back to E5? Let me ask this question. And maybe I missed the explanation, but you're showing the impact from the offset horizontal completion occurring in December. My first question is, what happened back, you may have already discussed it, but what happened back in the 1st of October that caused that drop in oil production and increase in water production?
I can check, but this is what we do normally is when we drill and complete our wells initially, they flow, and then we let them flow to a period of time to where they can't flow anymore, and when the well lays down, which that's what that profile appears to be, the well wasn't able to sustain flow, so we installed our pumping unit, and that's where we got our lift from the end of October, the well's now on pump. So that initial flow, and that's why it's, one of the reasons why it's so smooth, it's just the well bore is just flowing on its own naturally, and then we produce it down to the point to where it cannot. And then you have artificial lift installed.
That makes sense. Any reason or theory on why the well returned, even though there's an increase in water, your production of oil essentially came back after the impact from the horizontal completion? Are you thinking that was just because of the influx of the fracking fluid?
Yes, sir. Yeah, you see the water also, it returned to about 150 barrels a day as well. Or excuse me, 250.
And now here's my really dumb question. One of the other exhibits showed comparison between recompletion of a vertical well and the horizontal well.
Yes.
Can you not do any kind of recompletion on a horizontal well?
Well, if you could, if the vertical part of the well bore is in the lands that are where you're able to not at an exceptional location, right? So if you're within if the offset for 330 or 560, depending upon where the vertical well or where the vertical part of that horizontal well bore laid, or outside of that to where you're within the legal boundaries, you could recomplete the well. You could get one recompletion in that horizontal well. But if the vertical part of that well bore is on the section line, or sometimes they want to drill the well out of section and land the horizontal at 330 or 560 in section, right? So then that part of the vertical well bore can't be accessed at all because it's not part of that leasehold. So it depends on where yes, you can, but it depends on where that vertical part of that horizontal well bore is.
Yes.
I'll piggyback on Chris's question. You've offered substantial testimony and data today on the detrimental effects or potentially detrimental effects of horizontal wells on verticals. Is there any evidence we would actually enhance recovery from a vertical well through horizontal drilling?
Is there any evidence? We haven't seen any degradation. We haven't seen any improvement in well performance. So at 1,850 feet, here in this example, we're not seeing any degradation or improvement either way. So we don't have any data, and again, that goes to the spacing concern that we have, where this application will get you to 330 or 660. If we have you may have some communication there, and it could go either way. You could I guess you could enhance the performance of the well, which you'd be thieving. One well will be thieving from the other.
Thank you.
So what's a safe setback between a horizontal and a vertical well?
Well, we don't know is the real answer. I think 1320, that's for spacing vertically, is safe, but that's probably more than you need. I know that the 80-acre spacing application allows for 990 between wells. We'd be interested in testing that. But we don't know. There isn't any data. That's what we need to find out.
Then you through with your case?
Yes, our presentation in chief, correct. So I guess it's rebuttal over there.
You have a rebuttal?
Yes, we do. We do, and it's why we reserve some of our questions. We think a lot of this rebuttal will answer some of those issues.
And, okay. Let's go to you then, Mr.
Okay.
Holda.
I'd like to call the first rebuttal witness, Mr. Adam Sayers. Let me switch the screens. Can you please state your name and business address for the record?
Adam Sayers, 1430 Larimer Street, Suite 400, Denver, Colorado.
And your current position or relationship to Axia?
Currently, I'm the president and founder of Axia 2.
Okay. We're going to turn to Exhibit Q at this time, and can you please explain what this exhibit shows?
Sure. This was a lot of the questions early on. We're going to just hit this actually head on. And in fact, I think the board will be happy to hear that this is something that we agree with EP on, that there is an issue when you have multiple operators, as illustrated by Mr. Chicken earlier. And we're going to attempt to illustrate it. But first, I'd like to point out on the right-hand side, this would be an illustrations of Section 29 and 32 of 2 South, 2 West. Lies within our application lands, and is really an area where EP has interest in the northern section, and Axia and Newfield have interest in not only the northern but the entire 1280. But this is why we picked this particular area. This is where EP has filed permits. Okay, so I'm going to illustrate the potential issue that we're going to have that Mr. Chicken started to point out. As it relates to these two particular sections, Axia and Newfield own 71% of that 1280, and we actually own 45% with Newfield in the upper section. They're 29. And so EP has filed permits, vertical permits. And so I'm going to talk to you about the impact that this has in terms of our horizontal development here. If they went ahead and drilled the 4 wells in the upper section, 4 wells in vertically in the bottom section, you can see on that bottom left-hand side, it would impact basically 6 wells. So when you look at the diagram, we've got two horizontal wells, but remember, we have 3 total in a stacked pattern. So in this particular case, we've got a Garden Gulch, a Carb Member, and a Utland Butte for illustration purposes. So this would represent impacting 6 total wells. But let's analyze 1 well. If these wells were to be drilled and current setbacks that we're asking for, 330s from existing vertical wells, were allowed, this would impact basically 3 stages of fracs per parentheses there. So in other words, we could not frack 12 stages in each one of those wells. 12 stages out of, say, 40 or 45. So you're talking about 30% of those reserves we could not impact. And so then when you look at, well, at $45 oil, would we go ahead and drill a horizontal well that's been impacted by reserves by 30%? The answer is probably not. But then, you know, in Mr. Moon's previous question, you know, what would be a setback that you would prefer? And he said 1320. This 1320 would probably eliminate most, if not all, of our horizontal wells in here, because remember, they're completing up and down the section as they testified. And so this comes front and center of this particular problem that we have. And the state in the memo to the board has indicated a preference to you know, go ahead, you know, potentially space this on 1280s, but reserve the right to keep verticals, short horizontals, directionals on a 640 basis. That would be the problem right there. Is we have permits submitted here, EP has permits submitted here, and we can't coexist. And so it's important for the board to recognize this. Because it will hurt reserves. One of the benefits that we have in our particular acreage position in the 4 spacing units that we spaced in June, then the 10 that we're applying for today, we have very few vertical wells. That's a good thing. It's a really good thing for us. It's just very, very important that we have the opportunity to drill these horizontal wells. When you look at the amount of reserves lost, let's look at that. So EP has testified that they believe they can drill 400,000 barrel wells. Taryn's going to testify later. We believe that's aggressive. But let's give them the benefit of the doubt. If they drill both of these sections vertically, 8 wells, we're talking about 3.2 million barrels. We've testified to the commission we think we can drill 32 wells. And these are over 1 million. We believe they can be over 1 million barrels. So you're talking about 32 million barrels versus their ability to produce 3.2, a 10-fold difference. So you have a massive performance difference. I don't buy the testimony that we're creating waste because we're potentially missing one particular deep zone. We're talking about 29 million barrels recoverable difference here. And we're not guessing at this. And I appreciate his testimony about average EURs that Newfield has displayed on their 60-plus horizontal wells. I'll say 2 things to that. One is none of us here believe that Newfield's off and running on a 6% rate of return program. It'd put us out of business. And Newfield would stop drilling if that's the case. It's not the case. The 423,000 is looking at wells that were done at the beginning when, you know, thank goodness Newfield has done these 60 because they've gotten better. Every other resource play in the country, the best wells are as completions change. And if you look at how Newfield has done over time, in other words, wells in 2010, 11, 12, 13, they've gotten better. And so today, if you looked at what Newfield has done and normalized it, in other words, taken the short laterals, 5,000 footers, and put it to 10,000 feet, today Newfield would come out and we would, and our data would tell you that they would expect 750, 800,000 barrels. I've also testified that we're doing some things differently. We anticipate better completions based on cemented laterals, some other items. And so this notion that it's a $420,000 MBO play at 6% does not ring true to us. Secondly, when we sat through some testimony that said, well, we're concerned about 2,000 foot between wells, and that there's some communication, and yet they're coming back saying, well, maybe it's on 80s. That doesn't make sense to us. We went through every single well that Newfield had, looked at it from what did they pump, the job sizes. They're very right. Newfield does look at 145 foot of net pay. we're pumping different fluids, pumping bigger jobs to get a little bit more increased frac height. So we are adjusting to all these items, but it does, this particular exhibit Q does illustrate the necessity for the board to address the spacing. When in the memo to the board from Mr. Alder, and this notion of keeping 640s, that just wouldn't work for us here. And so one change that the board could make is make 1280s good today. In other words, not when it's drilled, because you'd avoid all those problems of they're drilling a well, then we come drill a well, and I mean obviously we that just does not work. And so if you got spacing on 1280s today, the beauty is all the interest owners behind Newfield in Section 29, they get to participate. And when you're talking about across our position, EP having 1,333 acres, 10%, and we're 71%, that has to come into account. It's very important for us to defend our interest owners, our royalty owners, and develop it the best way we see fit. And so while they're correct, there are some big numbers out there, but we also believe in them. But today, if you took Newfield's current performance on 10,000 feet, you're 800,000 barrels, not 400. And secondly, we need to stop calling this a pilot. It's not a pilot. When Newfield has drilled some of their best wells exactly adjacent to our sections, I mean, we're not talking 2 miles away, 3 miles away, 4 miles away, adjacent. In fact, we could look at wells within our lands and book them as PUDs. And I know this because we've met with the bank and we can get debt on it. I mean, that's SEC proved undeveloped locations. And so we talk about this being a pilot, and almost in the sense that Axia's rogue on this idea. And I want to remind the board that we believe it's horizontals. Newfield believes it's horizontals, has drilled 60 plus wells, has a current rig that's drilling now, and Crescent Point. So you have 3 operators that believe in the horizontal development. And I think that's really important. And when you see EP slide on their 157 wells that they've drilled in the last 5 years, I commend them on that. We like to see development. If they find a resource and open up a key to something new, guess who else benefits? We would, as offsets, as would, if we are successful, EP would certainly benefit. And they have 1,300 acres out of 180,000 acres. But of their 157 wells that they've drilled in the last 5 years, 1 well was within a mile of this application lands. And so I do think if they truly believed it's 425,000, they would have been out here earlier.
Thank you. Do you have any additional items to add to this exhibit?
No, I would just reiterate the necessity to address this issue today in terms of we obviously, if they drilled vertical wells in this particular 1280, it would negatively impact our reserves and development program. It is a very, very difficult area to coexist. And I will make one last comment as it relates to our previous order, because our previous order is consistent with this, that the 1280 would not be established until we drilled a long lateral. Okay? And we did that because there was concerns that, well, we don't want to do a 1280 day one, so Axia can come out here and drill a vertical well and hold a 1280. We acknowledge that. We acknowledge that. We know royalty owners would be concerned about that. And so at the request of the division, they asked us to go ahead and space it, that it goes to a 1280 once you've, gone out there and done what you said you're going to do. And that worked. In this particular case, it doesn't, because we have permits, EP has permits. I believe we've called the state. I'm not sure who we talked to, but obviously had the concern of, what is the state's process in approving these permits. And so if EPs does get approved, it would have a huge detrimental effect to us. So this is something that we need to address. And again, one of the ways to do it is to go ahead and establish the 1308 or 1280s day one. Again, there's language in our about verticals, directionals, and short horizontals. It's a second fiddle to us. We have no plans to do that. So if there's language that we can write around that, but I think the easiest thing to do today is to ask for the board to approve for the 1280s day one.
I just want to point out that that's obviously different from our amended and restated request, and Adam explained why. We went off of what was done in the previous spacing work because that's kind of the agreement that everybody came to, including the division. EP wasn't as heavily involved in that and didn't object to it, and didn't present the same vertical APD issue that they do here. And as Adam has stated, one possible solution is to make these spacing units effective from day one, and then we don't run into the vertical APD issue, the competing operatorship, and also. Again, we requested the option to do vertical, directional, or short, lateral, horizontal, but I think what Adam is saying is that they'd be willing to drop all that from the request because that's secondary. If for some reason down the road they decided, we need to come in and we got to plug one in here to recover this, and it's the only way we can recover it, well, then we would come back. But I think there's a solution here. But I wanted to point out that is a difference from what was requested.
Just a question for Brad. If you have two competing applications, I mean, isn't it kind of a given that the majority interest holder in that spacing unit would get approved, right? I mean,
that's not the way you've done it in the past.
It's who first come.
In the past, if say there were two competing operators and I got an application in, I would process that application first. If I know there's some contention. The only case where I've actually had to deal with that in the past was there were some issues between Crescent Point and Finley. And what I did there, because I knew both of them, it came to my attention because one of our people doing on-sites called me and said, hey, I'm looking at duplicate APDs from two different operators. So in that case, I talked to both operators and asked them to figure it out between them first, and I didn't act on any of them. They came to an agreement and they settled it between them.
I've just always assumed that you need to be a majority interest holder in a spacing unit or have joint agreements with other operators in order to drill a well.
Yeah, and people have asked me that question before with the same assumption, but I was never comfortable with the legality of declaring one mineral owner dominant over another mineral owner, but I haven't had to go there.
So that's all I have on Exhibit Q. Again, these are some rebuttal slides, and so I may have to bounce around from one witness to another. Turning to Exhibit R, again, this is addresses, and we didn't address this at the time or ask questions when they discussed the alleged interference of the wells, but here's a slide that is our answer for that. Taryn, could you please explain this slide, this exhibit?
Yeah, and this actually, there's a series of slides here, but this will address El Paso's exhibits G2 to G4, and as you can see, we have different tape measures. We measure about 1,635 feet on the south well, which is the Moore well, which is the one that they thought there was some interference in water on that particular well. We also look at the Kajamal well to the north. So in order of completion, the horizontal well was fracked, and then the Moore well was completed, and then the horizontal well was completed. But then the Kajamal was completed after that just because it's a horizontal and a vertical well, if it's going to migrate one way, they're putting the same size fracs on the vertical well, it's going to migrate the other way. So we looked at that to see if we could see any interference or any water influx on the horizontal well, because you have a big target to hit, let's put it that way, versus a vertical and a vertical. And we're going to show you that we not only don't see interference on a reservoir basis, and that's what I care about, on the Moore well, you don't see it in the Kajmal within the horizontal well either. So
that's the next exhibit, Exhibit S.
Correct. So on the top, you can see the Moore well, and what we did is we actually did expand it out past the month to see if the wellbore was impacted. And I've looked at this in Colorado. If a well is impacted in another well, you can tell if it's just water, it cleans up, comes right back to trend, and that's what we look for. But if it's not, you immediately see a decline in that well. It's immediate. In fact, the well that fracks into it is worse than the parent well. You don't see that here. So on the Moore well, you can see the water influx as they indicated in the triangle there. That's when the horizontal well was completed. But as you can see, as you pointed out, it actually comes back stronger. And this is another 1.5 or 2 years worth of data to today. And as they testified as well, we don't see a reserve impact from that, possibly a little bit of water migration, and that's it. We took that farther. So again, now they've fracked the vertical well towards the horizontal well in this case, and you can see the horizontal well decline is on the bottom there. The Thompson, the triangle represents when that vertical well was fracked, and you see nothing. You know, it's right on trend, no interference. In fact, the well increases just a little bit, but water does too, so cut doesn't change. So there's zero interference, zero impact from the vertical to the horizontal in that case, and that's at 1,600 feet.
Turning now to Exhibit T, and we're trying to go through this, being mindful of the board said we're trying to go through these really quickly. Exhibit T, can you please explain that?
Yeah, so we took that further. So Newfield has drilled wells 1,320, even closer to that, with horizontal and horizontal. So you got the two biggest targets fracking 50 stages each. If it's going to happen, it's going to happen here. So as you can see in the first one, on the map down below, it's just south of our land. You got A, B, and C. So they've drilled 3 wells that are essentially 1,320 apart. On the first one, the original well produced for about 6 months. And you can see what Newfield does, and they may have recognized this, but this is common practice. I always shut in my wells anywhere near another frac well, just to eliminate any possible migration of fluids to the other well and the cleanup phase. But as you can see, so Newfield shut in the well about April or August of 2014, and when they brought it back on after the new well was fracked, it came right back to where it was, and you can see it's still on trend out a 1.5 years later. And that's at anywhere from 1,328 up to 1,488 feet apart. The second well, B, we're going to look on the upper right-hand chart. Same thing. They shut the well in to frack the new well, and this well has been on for a little over a year. So you can think of a horizontal well as draining reserves for over a year. These things come on at 1,500 barrels a day. So after a year goes by, they frack a new well 1,320 feet away, 1,459, the Dart well, and you see no impact on the original well. At the same time, the Dart well was one of their more recent fracks in 2015. The Dart well is over 1 million barrels, 1,040,000 is that well. So there's zero interference bottom hole between these two wells at 1,320. And then one more example on C. These ones are 1,216 feet apart, so even closer. And the same thing, we just see the same thing. So they shut the well in to frack, they bring the well back on, and you don't see any difference on trend, which when you're developing, putting together a development program, that's what we need to look at. Are our reserves impacted? And you can see from these, they are not.
Thank you. Now, turning to Exhibit U, can you explain this exhibit?
Yeah, so you see 2 sample wellbores, kind of like we just looked at. Newfield had drilled 2 wellbores, 1,320 feet apart. On one of El Paso's slide, I think G3, and we kind of went over this, the natural fractures were extending past the lease line, or the theoretical open natural fractures that go east-west were extending past the lease line. So if you actually measured that cartoon that they drew, and there's no way to know how long a fracture extension system is or a fault system. Even seismic is not going to show you what a natural fracture system is. We know there's fractures everywhere. We don't know how continuous they are. But based on the data that we just looked at, it's certainly not 1320. So if you look at my cartoon here, I drew the same size natural fractures that they depicted that went across the lease line, and they're 1,290 feet to make their story work. If you had that, you would absolutely see communication between these two wellbores. If you had natural fractures hooking up like that, you would see it, and we just saw evidence that you do not. So Axia believes the fracture system to be much, much less continuous based on lack of communication. And quite frankly, so does Newfield. They've submitted to the state 7 wells in a 1280, the 8th well being on the lease line. So they're believing 660 spacing as well. Findings suggest fractures cannot be continuous as a norm. And again, we believe fractures exist everywhere. But again, to the point of the board, it needs to be connected with frac sand, not water. So water is not going to create any kind of drainage downhole. We need to get frac sand in those areas, which is depicted by the microseismic, again, as the maximum. Frac sand is something less than that.
Exhibit V, please explain that to the board.
This exhibit kind of goes away. This kind of addressed what our possible north-south, true north-south orientation was. Since we decided to go east-west, unless I need this, we can skip past this slide.
Yes. Exhibit W.
So this shows the results in the worst-case scenario on our land, which is 19 degrees, a lay-down setback. As you can see from it's the same as before. The important statement is based on the previous slides when we saw or looked for any kind of communication. Axia believes that drainage is dominated by the hydraulic propped fracture. Natural fractures will enhance permeability and storage, and performance shows it does not extend drainage significantly, if at all, in our primary targets. So we just saw evidence of that. So when you take the actual microseismic data as it sits, just like we have on all the other slides, at 19 degrees, you can see 560 setbacks to the north. We're still 366 feet from the north line and 229 feet from the west line in our worst case angle spot on our lands that we're asking for today.
Now Exhibit X.
Exhibit X goes away. That's talking about a stand-up. Exhibit Y. So this is what we kind of talked about, and Adam alluded to, that the numbers don't go around the way El Paso portrayed them. This response is in response to El Paso's E3, where they show that the vertical development on the township on the west, and this is southwest of our acreage now, as compared to Newfield's pilot program, development program on the right-hand township. First of all, we look at the vertical wells. We'll just start on the west side, and there's more wells to do, and we recognize that. To do this whole township on 4 wells per section, they're going to need to do 144 wells. They've done 81 so far. That's fine. So at 160 spacing or 160 drainage, that's 12,960 acres. If you look at the EURs on this area, I know they looked at CUMES. CUMES doesn't tell me anything about well performance and drainage. But when you look at the EURs on this, there's 25 Wasatch-only wells that are 188,000 barrels. There's 54 Green River Wasatch. They've already completed the Green River now, so this is a combination of 213,000 barrels. And there's 2 Green River-only wells that completed up to the Douglas Creek of 43,000 barrels average EUR. So let's see what that means on a township basis now. Move to the bottom of that side, 3 south, 4 west. All zones, vertical full township development is 144 wells. Times 213,000 barrels EUR, you're going to get 31 million barrels out of this township. Now let's move to the right-hand side. There's 19 horizontal wells. So the first assumption was a horizontal well is a horizontal well is a horizontal well. That's wrong. 10 of these are Green River in the Uteland Butte. And first of all, it's 224,000 barrels average EUR. It doesn't sound that great, but the average length of these is 4,200 feet. This is their pilot area. That's why we're asking for 1280s and 9,900-foot laterals, so that we can take advantage of doing all these frac stages at the economics of drilling horizontal wells. So when you take 4267 and 10 wells and 660 spacing, right now in the Uteland Butte, they're only accessing 646 acres of this township so far. They have a huge infill program coming back, and they're going fast. They have a 1-rig program. They spent a lot of time in the section or township next door, but they have drilled 3 more wells this year. in this area. And they're long laterals, and as Adam alluded to, they're not doing it at a 6% rate of return. So what does that mean? You also have 9 Wasatch wells in this area that average 396,000 barrels EUR. Again, 5,205 feet average length, and it's less than half what the full length lateral needs to be. So move to the bottom. What does that mean? And this is stunning, the differences, and this is why Newfield has abandoned the vertical program and is going horizontal, as well as Crescent Point. If you look at the Uteland Butte only, horizontal full well development, again at 660 drainage, I told you that's 646 total acres that they've currently accessed. That's 64.6 acres per well. So 224,000 barrels a well. So what I did is I figured out how many barrels are they getting out per acre that they've actually completed so far, so that I can figure out when they come back to this area and fully develop, we can see how many barrels they're going to pull out of this township. And also keep in mind, this is their pilot area. That's why they're short laterals. They have improved more than 50% if you look at today's EURs, which I don't even consider in this, you don't have to consider in this scenario. In the Uteland Butte only, you get 3,467 barrels per acre. Times 23,000 acres in the township, you're going to remove 80 million barrels in one zone in the Uteland Butte. Recoverable. This is actual EUR data and actual, this isn't any petrophysics, this is actual answers right here. The Wasatch 5, there's one well, you can see a star on it right in the middle. It's actually a little better. 985,000 barrel well. Its average length, one well, is 8,525 feet. You can say, well, that's close to a long lateral. They got another 1,400 feet short of being a long lateral, a true 9,900 footer. So when you put those numbers out there, it's another 176 million barrels when they develop the Wasatch 5 all the way through. In the middle Wasatch, they've done 8 wells. They average 322,000 barrels a well, but the average lateral length is only 4,790 feet. Again, less than half the length. So again, barrels per acre. Now in the middle Wasatch, I think things change, and I think Newfield believes that too. I think it's 4 wells per 1280. It's not in our primary targets, but they've done it, and we're using it in this scenario. So at 4 wells per 1280, that's now 51 million barrels additional recovery out of the Wasatch 5, proven targets that have been drilled in this township. And then you have the Castle Peak. So there's been 1 well in the Castle Peak, not in this township, but Newfield drilled it right next door, 5 miles to the east. They're going to come back and do the Castle Peak because that was a 1 million barrel well. 941,000 barrel well was that one. That's going to pull another 175 million barrels out of this township on 8 wells per 1280. So the numbers are enormous. On top of that, El Paso mentioned they're recompleting. Well, this area is good up to about the Douglas Creek. They haven't even tested the Douglas Creek yet in any of their lands. Crescent Point has. So it's just a matter of time before they get to that zone. Don't even know what reserves to put on it, but the Douglas Creek does exist in our area, and it's a good-looking target. It's one of our primary targets. And then you have the Deep Wasatch. They keep saying that you're never going to do the Deep Wasatch. This is bypass pay. We've drilled horizontal wells down to 13,000 feet TVD. If the reserves are there, we can go get it. It's just not on our radar right now. So we can develop this whole area, bottom to top, TGR3. In fact, with these zones, we still have zones above us that we want to complete. So we have TGR3, we have Garden Gulch, we have a zone above the Garden Gulch, and then we have the Deep Wasatch here. So let's bring this back into perspective. On the left-hand side, again, 31 million barrels. On the right-hand side, in the proven targets, the primary proven targets, you have 307 million barrels recoverable, and that's Uteland, Butte, and Wasatch. The secondary targets, Castle Peak, is another 175 million barrels, which they proved 1 township over. Over 500 million barrels recoverable out of this township, and this just shows it's 10 to 15 times more recovery than they've shown with actual data from vertical wells. The numbers are stunning, and like I said, this is why both Newfield and Crescent Point have switched over from vertical wells to horizontal wells, as they can pull so much more oil out of these things horizontally.
Okay. Exhibit Z. After you take a drink. This is a map. So I challenged our geo staff
I've looked at all the EURs, and I'm going to show this on the next slide. But from north to south, the EURs are deteriorating fast. So I'll show it on the next slide, but you have decent, and most of the vertical play, I'll remind you, is north of this township. That's where the big wells are up to the north. But so this actually this is USGS data, and this actually shows kind of the same thing, that the Wasatch, Colton Wedge is pinching out as you come toward our lands. And our EURs actually show that it's a little worse in 2 south, 2 west than on the edges. So this was a decent explanation of what might be happening with the EURs coming into our area. I really don't care what it is. This is one answer. We do know that the EURs are dropping as you move into our lands.
Okay, Exhibit AA.
So this shows the what I was just talking about. This is the 3 townships just north of our spacing units. And if you look at the top third, the top 2 sections of those 3 townships, you get an average Wasatch-only EUR of 330,000 barrels. You get a Wasatch Green River EUR of 434,000 barrels. So that says roughly 100,000 barrels for the Green River. So moving south 2 miles, essentially 2 miles, you get a Wasatch only of 263,000 barrels. So you've dropped almost 100,000 barrels already in the Wasatch only wells. And then when you look at the Wasatch Green River wells, averages about 320,000 barrels. And then when you get to our lands to the south, Wasatch only, there's 16 wells down here. And not many wells have been drilled, but we've drilled 8 of these in our area. We've completed up to the Green River. So we have a good insight onto the performance of these wells. But the Wasatch only EURs are 131,000. The Wasatch Green River are 180,000. So you can see just this huge deterioration within our area of EURs. So what does that mean? And I'm going to tell you, I know they said that these are 400,000 barrel wells. Well, BBC, which is who we acquired for this area, has one of those 400,000 barrel wells. But when you average all 8, we average 200,000 barrels, which is really close to the 180 that we see here. So you can't take your best well in the area and run your economics. We're actually taking it's a statistical play. It's just a statistical play on a vertical basis. So you have a 400,000 barrel well right next to a 90,000 barrel well. You just have to play the stats and see if it works economically. And we're going to show you it doesn't. If you use a 180,000 barrel well in a 1280 now, so we're in just a 1280, you get 8 wells. The current spacing orders is 4 wells per section, so you get 8 vertical wells in a 1280. At 180,000 barrels, you're going to pull out 1.44 million barrels out of that township. Go to the horizontal side. On the right-hand side, you can see a 1280, that same 1280 in the Uteland Butte, 8 wells per 1280, 1.3 million barrels each. You're going to pull out 10.4 million barrels out of just the Uteland Butte. Castle Peak, 1.1 million is what we're saying, and just to the south there, they had a 1 million barrel well in the Castle Peak. That's another 9 million barrels out of the Castle Peak. LP marker as we keep moving up section, and we can do more zones than what Newfield is. We're deeper and hotter as we move to the north, so keep that in mind. So we drilled our wells, and we like the gas shows and the oil shows that we saw here. Another 11.2 million barrels out of the LP marker. I talked about the Douglas Creek a little bit. This one really lights up on our logs. Again, 8 wells per 1280, 1.4 million barrels a well. 12 million barrels additional recoverable out of the 1280. Then you have the Wasatch 5. Again, 8 wells, 854,000. This is the zone that Newfield's done 5 times and averaging like 950,000 barrels. It's a good, solid zone. So we might be under on that one. 6.8 million barrels recoverable out of the Wasatch 5. 50 million barrels recoverable out of the 1280 now on a horizontal basis versus 1.44. It's 35 times more oil. Let's say they want to do 8 wells instead of 4 wells, so double their number. It has no impact. So now you're at 2.8 million barrels. It doesn't mean anything. It's such a small amount of oil compared to what can be done horizontally.
There's one additional slide that wasn't included with the additional exhibits, but when we were putting this together, better illustrates the numbers here, and Julianne does have copies, and I'll give you a copy as well. It's really, again, it's kind of an addition to the prior slide, Exhibit AA, and expands on that.
Vertical type well and application.
Am I good? And really, this slide just answers another question that the board had on the economics of this, and why would Newfield be drilling wells in their area at a 6% rate of return. So we looked at the vertical viability in this area. Again, we just saw 180,000 barrel vertical wells at $5 million, which El Paso provided in their testimony on a vertical completion in this area. It's deep. It's deep to get all the way down to the Flagstaff, 12,000 feet. So you lose about $2.2 million on a vertical well. So essentially, that's why they're not being drilled up in this area. Horizontally, this is taking a Newfield average EUR in the Uteland Butte only. So if you take all their data as a 9,900 foot lateral without applying any of their latest completions, they would tell you they're probably 70, like Adam said, they're 729 is what the data shows. They're probably 750 to 800, but a 729,000 barrel EUR. And currently, they're at what we said development cost is. They're at 60 wells, 65 wells. So their AFE, which we're partners on, is $8.7 million. So when you do that, you get a 24% rate of return. That's why they're drilling 8 wells this year and putting another $70 million into this play. But look at the PV10. So that can be misleading. 24% rate of return maybe is on the low end of what a lot of plays are, but the PV10 is $4 million a well that they're gaining out of this program versus a vertical well.
Okay, Taryn, in your expert opinion, then, will drilling the horizontal wells on a 1,280 acre basis maximize resource recovery multiple times over drilling a vertical drilling program and prevent waste, all while protecting correlative rights?
Yes.
I have no additional exhibits that concludes our rebuttal. At some point, we need to a motion to admit the exhibits that we presented. But
then we're going to go to you, Mr. Chicken.
Thank you, Mr. Chairman. I'll try and
rebuttal. Of rebuttal.
I know. rebuttal of rebuttal. A weird situation, but true. Can you pull Exhibit Q up? So, and I guess this is a question for Mr. Sayers, because he testified to this. When we're looking at this exhibit, this is showing the problems that a horizontal operator encounters when there's existing vertical wells, correct?
Yes.
Okay. So this exhibit is basically another one where I think the parties agree that vertical wells just aren't compatible with Axia's long lateral horizontal plan. Is that accurate?
Well, I'd answer it a little bit differently. We do have some existing wells vertically within our spacing order. And what we've presented, I think, two vertical wells. What we presented to those working interest owners, that there's a benefit to going to horizontal. But as it relates to I think your intent is, look, if these wells are drilled, would it impact our horizontal wells? It would.
Okay. So does Axia plan to drill any vertical wells?
Not at this time.
Okay. And the same thing with directionals, correct?
Not at this time.
So what's the reason for future verticals and directionals to be on 1280s?
Don't really have a need for it. It was consistent with existing spacing orders that were done by Newfield and others. But as of this time, we have no plans for it. We could make a case if we eliminated that option. We could come back and ask for them in case we needed to.
So is that a change to the amended RAA then, that you wouldn't need?
I suppose it would be a change to the RAA,
like
yes.
for going forward. I understand the existing, but okay.
Yes, I mean, it
Okay.
would be a change.
And you've mentioned Newfield, and I think I want to just clarify something. Was Newfield's letter filed in this cause support or no objection?
A better question for David.
Yeah, we can pull out the actual a letter, and I think it speaks for itself. It says what it says in there.
And what I'm trying to get at here is there's a whole lot of, well, Newfield would say this and Newfield would say that, and I'm just, why isn't Newfield here saying that?
Because they have no objection to the testimony that we are presenting, and they have worked closely with Axia in preparing the testimony and exhibits and sharing data, because they have a large interest, and so they have an interest in this going forward because they may plan. I don't want to talk to their plans. I'm not in a position to talk to their plans.
Understood.
Yeah.
So is there any data from Axia or Newfield that shows that competitive drainage isn't going to occur between verticals and 330 foot away horizontals?
I'm sorry, could you repeat that?
I don't believe we've heard any data that shows competitive drainage would not occur between a vertical and a horizontal 330 feet apart.
That competitive drainage. I'm trying to dumb it down for me. Sorry. Look, when
any information. Okay, let me articulate better. Has there been any data that the horizontal well, 330 foot away from a vertical well bore, will not drain it?
I'm not aware of any data.
Okay, thank you. Can we, if we can quickly move to Exhibit S? So this one is obviously showing in rebuttal between the Thompson horizontal and the Moore vertical, correct?
Yes.
Okay. Is it fair to say that when you look at this slide and the testimony provided by the parties, that again, this is an area where they see things the same in terms of both parties agree that there's been communication, but there's no reserve impact, correct?
It does look like there has been water from something coming into the Moore well.
Okay. So would you term that communication?
No. Communication I refer to as differently as reservoir communication.
Okay. Let's go to Exhibit T. So the question, oh, is this the right one? I think so. Oh, it is the right one. Okay. So just a few questions on this one. The first one is that you testified that Newfield shut in its wells while the offsetting wells were being completed?
It looks like that, yes.
Okay. And what again is the reason that they shut in wells over 1,000 feet away?
Yeah, it's kind of the same reason we alluded to before is, with the fracs that are going on today, hybrid fracs and or slick water fracs, fluid can go places where proppant can't. And like I said, it just could just be a migration of fluid over to that well, and it may not happen the day of the frac, it may happen later, or it may not happen at all. It's just we do the same thing at Axia. If I'm fracking in the area, I'm going to shut in the wells in that area just to minimize any kind of operations or any kind of water influx from that well.
Okay. But so the shutting in has a distinct purpose in definitively preventing any communication or water or any
it's more
talking
of a,
between
it's
the wells.
more of a precaution.
Okay. So when we look at this exhibit, you have the wells that you were pointing to, your kind of example wells, A, B, and C there. So the Jorgensen, the Close, and the Ranch. Do you have any tests? Do you have any tests of similar to these where the wells are less than 1,227 feet apart?
Yeah, those are the closest so far.
Okay, so 1227 is the closest, but the application seeks 330-foot setbacks, correct? They're just 4 times smaller than the only test we've got.
That's in the opposite direction of the hydraulic fracture. We're in the hydraulic fracture direction. We're saying 560s, just like Newfield has in Crescent Point. In the non-fracture direction, we're saying 330s, just like Newfield and Crescent Point.
So, but in either case, the only actual test that we have, the closest test we have, is 1,227 feet, correct?
That is correct, with no communication.
Okay, thank you. We can go to you. I think we've some of the questions from the prior one answers that. One of the ones I want to understand on this is, are those 3 wells in the same interval, or are they staggered?
These are Uteland Butte wells.
So every single one of them is Uteland Butte. Okay, no staggering.
Nope.
Okay. So in cause 138, 139, which actually is referenced multiple times, Newfield had commented on the unknown length of the natural fracture system, and that they could be greater than 330 feet east-west. Or can you comment on that at all?
I cannot.
Okay. Let's move to Exhibit V. Sorry, I apologize. One moment. Just want to clarify the orientation of north 19 degrees west, and why that particular orientation was chosen.
That is Axia's interpretation of the worst frac angle that we will see, the most north-south that we will see across these lands, and that's gathered from more data than you see here.
Okay, yeah. I guess I think you've answered my question. My question is that number is an interpretation of data and not necessarily a hard number.
It is, and again, it was more to refute if we went north-south in this area. As El Paso suggested, we're 4 feet over the line in a north-south direction with 330 setbacks. But in a lay-down scenario, it's pretty much irrelevant because we're 560 from the north line now.
Okay. Can we go to Exhibit Y? So, correct me if I'm wrong, but on the left-hand side of this exhibit, Axia's position is that if you take 213 million barrel EUR and multiply that by 144 wells, you're going to end up with 31 million barrels recoverable, correct?
Correct.
Okay. And on the other side, at the top where you're talking about the proven targets, you talk about that in that same land mass that you can fit 144 wells in, if those wells were horizontal, you would get 307 million barrels recoverable.
Correct.
Okay. How many wells does it take to get to the 307?
It's at 8 wells per section. It's 144 wells per zone.
No, I'm talking about horizontals.
Yes.
Right.
Exactly.
So in order to get the 10 times recoverable reserves, you have to drill almost 700 wells.
Okay.
Does that sound accurate?
Sure.
Okay. So, again, I don't know how else to put it other than so then your position is that if you drill 10 times more wells, you get 10 times more you get 10 times more recovery?
My position is you cannot get that out of the township vertically. It can't be done. We've seen the EURs here. You have to go horizontal and essentially put 120 clusters in these wellbores to truly drain this rock.
Okay, but I think the point's been made. Okay, and then the last one is Exhibit AA. If you pull that one up. And I just want to confirm the calculations that you're using at the bottom. The calculations you're using at the bottom, those again are all based on the volumetrics, correct?
That is correct.
Okay. So the petrophysical models we discussed earlier.
That's correct.
And then, you know, one of the things I'm looking at here, and earlier we talked about the Cook and the Dustin. Where would those be located on this map?
I don't know where those are. Northwest. It's in the middle. 2 South 3 West, I think, and
certainly if somebody else is more
sure
knowledgeable over there, you can tell us. I mean, because okay, there we go. So we see where those are, and I don't know how we put up two things at once. What was the EUR for the Dustin? And let me back up. Maybe it's easier to say this. I don't know how we compare these two slides. What I'm trying to do is say that the Dustin would be in that middle range on slide AA, and the Cook would be in the lower one. If we can confirm that, because I think that's really what matters, because those are the. So in other words, can you confirm that the Dustin would be in the center strip on Exhibit AA, and the Cook would be in the bottom strip on AA? And feel free to jump back and forth as much as you need to.
That's right.
That's accurate. Okay.
Mm-hmm.
So what's the EUR on the Dustin?
I don't have that. I think. Well, okay. I think El Paso put some numbers up there of 400,000 barrels. Let's see where that is.
It's their exhibit G6.
It's what?
Their exhibit G6.
Yeah. So I'm sure the EUR is on my slide somewhere, but El Paso is showing 420,000 barrels on the left-hand well and 400,000 barrels on the right-hand well.
Okay. And assuming they're accurate, are those both Wasatch Green River wells?
I don't know the answer to that one.
Okay. So if the EUR on the Cook is 400, but it's in the same. What I'm trying to understand is the EUR on the Cook is 400, and the Wasatch Green River EUR for that lower strip is at 180. That seems like a big difference. Is there a reason for that?
Sure. So I mentioned this earlier. This is very statistical. Bill Barrett owns 2 wells in the same section. One well is 471,000 barrels, and the other well is 92. It's a statistical play. If you go to the very north end of that, you have 7 wells greater than 900,000 barrels on the far north edge, but the average is 434. It's statistical. So on the north edge, you have 57% of your wells is less than 327,000 barrels, so which we would call economic at these costs. So over half your wells are uneconomic on the north edge. So this is statistical. So I'd answer that well. Those 2 wells are not an average for the area. And we know because we have a 400,000 barrel well also.
So then how do we use these strips to average out everything that's going to be in there? Because what you're testifying to is that you could have wells that vary widely within each one of those strips. Is that correct?
You could have wells vary widely within one section.
Okay, so even worse than this. I mean, they vary even more so, and within one tiny section inside of that whole strip, and there's 20 of them in there. So okay. Do you think that has that vagary, how they vary so much even within a section, how connected to the depth of the well is that?
Are you asking, are they Wasatch wells? So the wells that Bill Barrett has goes all the way down to the Flagstaff. So we have 8 wells that are in the Flagstaff, and quite frankly, when we've looked at this whole area, you have to go deep in order to make good well. So that's where the play is, in the Flagstaff and Colton. And the rest is kind of recompleted, as we talked about, the Green River, because the well is there. You can't drill a new Green River well in this area on its own. Can't happen. It's not going to be economic. It needs the Wasatch, the deep Wasatch, to even have a chance, and in our area, it's not there.
We don't have any other further questions. I would just reserve a few minutes for a closing once in the order that the chair seems fit.
Okay. Thank you. Division?
We have no questions for the witnesses. We appreciate the testimony. We would appreciate, and I know that it's very late and everybody's tired, but in order to advise the board, we would like a few minutes to kind of
No, it's your turn.
discuss. No, I mean a few minutes amongst ourselves to discuss. Frankly, I think there's been the question of how the vertical wells should be allowed and whether they should is sort of a historical fact, and we might be changing our position. We need to kind of talk about that, and I don't know if now's the time to do that or what, but we don't have any questions for these witnesses. I think it's
But you're going to come back with a recommendation, or at least advise the board on your
We'd just like to address the change in position that has been made by Axia relative to the vertical wells, and I think we just need a little bit of time amongst ourselves to decide that.
Tell me how long.
5 minutes?
Okay, we'll come back at 15 after.
I'm just going to object to it. And look, if they want to reserve it and we get the comment on it and send something in or something like that, that's fine.
Back on the record. We're with the division.
Thank you, Mr. Chairman and members of the board. And I'm not sure that this is testimony or questions, but there was a lot of confusion about how the vertical wells should be controlled under this order and under the previous order. And I think it had to do with this competing method of which is the most economical or the best way to develop this field. It wasn't really at the insistence of the division, except to the extent that we were concerned that it might be to the disadvantage of some vertical well owners if depending on how the 1280s were developed. Having heard the testimony today, we think that probably the fairest position that the division would like to see the board adopt, and I understand the board may take this under advisement and may have additional questions for the parties, but based on what we've heard, we think going to 1280 as of the entry of the order for all wells makes the most sense, and then limiting the vertical wells pending some further testimony to the 4 wells per section by the existing order and the existing testimony would work. So that's, I'm not sure I can explain it or answer any questions, but between the division we'll try. But we just thought we should advise the board that we think that's the best way to deal with the vertical wells. Okay. I can tell I answered your question.
The question I had is, when you say by limiting the vertical wells, what does that mean?
The number of vertical wells would be limited based on the existing orders, which I think are 4 per section. But they would be shared, but production would be shared on a 1,280 acre drilling unit basis. I can tell there's a lot of questions, but that's...
Mr. Chairman?
Yeah.
Yeah. Well, I guess I would just ask Steve, so I think I understand what you just said, but this issue of whether if there are vertical wells, they would share on a 640 or 1280. If the divisions come around to the view that the 1280 is better, I guess I just would wonder why. I've sort of thought that was the one issue that I haven't really heard much testimony that even goes to that issue. You know, the issue of how vertical wells would interfere with those horizontal plans, particularly as you make the setbacks bigger, and the effect on the laterals and all of that testimony, I think I understood very well. But it seems to me that whether those vertical wells that would be doing that harm to the horizontal program are sharing on a 640 or sharing on a 1280, the harm is the same as far as I can see. So I guess if the division's liking that 1280 for the verticals, what's changed?
I think the division would agree pretty much with what you said about the harm being the same regardless of how it's shared. There wasn't a strong position about whether it should be shared on a 640 or a 1280, but you want to address that, either of you? I think we're concerned that there's some gaming and potential for waste, and so believe that that would discourage vertical wells, frankly.
So the 1280s would discourage vertical wells compared to the 640?
That's my personal opinion. Nobody else said that.
Okay. I would ask council, we're going to start with EP, and then we'll finish with the petitioner. I want you to not leave here thinking, you know, there's any confusion in our minds exactly what you're asking for.
Absolutely. Again, it's late. I'm going to keep it brief, and I think there's some clear points we can see from what we've heard today. Every party here, including the division and certain members of the board, have recognized throughout all the testimony that there is a dearth of data. There is the interpretation of third-party data. There's a lack of knowledge. There's testimony that hasn't been put out, and that's been the position of EP all along. Is there's not enough to be able to extend to this, and they fall back on the concept of, there's 2 wells being drilled right adjacent to this area right now that would answer a lot of these questions, that would fix a lot of these problems. They're close to verticals. They are, the intervals that they're being, drilled in, and again, a lot of that's going to be confidential. Nobody in this room except for Axia is going to know what those are. This board should have the benefit of that data before making a decision, which is literally deciding which one of these 2 companies is going to develop this area, because that's really what it's coming down to. One of them wants to drill verticals and no horizontals. The other one wants to drill horizontals and no verticals. I think that's been the testimony. And so, the answer can't be throw one or the other one out of the area. The answer, we have to work together to come to an agreement, or come to a rational spot. And I just don't believe that the board has the evidence in front of it that allows it to do that at this point in time. We've also had 3, 4 on-the-fly changes today in the hearing of what the amended RAA looks like. We've heard that they're going to change things with the APD and the practical side of things. There's also been, issues with, and in Axia's defense, and they've been very accommodating in that same way. But I think, it's been this board's penchant when you have a bunch of changes like that to lay those out and get evidence on the specific RAA that's been forwarded, rather than one that has 3 or 4 potential amendments that haven't been articulated really beyond kind of an idea. Again, we'd ask this board to kind of follow its own precedent. Let's see what the 139, 138 lands do. Get some real hard evidence from Axia's own wells, and use that information to make its decision. I don't know. I don't want to belabor the point. I mean, I think that's really where it's at. There's not enough data, and that's going to, create waste, and it's going to impact correlative rights. It's going to leave stranded resources in the ground, and I just don't think there's enough data for the board to make this very important kind of big decision, because that's what's hidden behind all of this. Is the decision here really decides who's going to develop that area. Because otherwise it's going to be, a race every time, and poor Brad's going to be beating his head against the wall trying to figure out the APD situation and other things like that. And so in closing, we'd ask that the board deny Axia's amended RAA at this time, and await further data that's really not that far away. If those horizontal wells are drilling and going to be completed and put on production shortly. And the last thing I'd like to add too is the Exhibit AB that was offered. I mean, obviously, we got that exhibit a half an hour ago. If we would have an opportunity to provide a short comment on that after we've been able to look at that exhibit and critically analyze it, because again, it's stuff based on volumetrics and numbers that are interpretive numbers. We would not object to its inclusion in the record. Otherwise, we do. EP does object to its inclusion in the record simply because there's just been no time to formulate proper cross-examination for it. But other than that, we would rest for the balance of our time.
Axia. Pardon me, Steve, do you want to make a closing, or I assumed that you made the closing?
We probably have. I mean, I think in a perfect world we have,
Yeah,
we have made the argument that this might be premature and that it would be better to wait until the results of these wells and treat it as a prototype. But I think the thing that's clear from the contesting in this is that things aren't going to stay still. It's not static. We don't have a moratorium, or we don't have one party
either party that controls enough resources. So things are going to happen, and I think in deciding how they should move forward, I think the recommendation that we made just a minute ago probably summarizes it. But I would like to indicate that's part of the reason we have probably shifted from the idea that otherwise we should wait and see what happens with these two sections that are being drilled.
Just, if I could, before you do your closing, I'd like to make sure the exhibits are admitted. Yeah.
Absolutely.
Starting with Axia. You didn't offer B, but it will take administrative notice of that. It's just the previous orders.
Yeah, it's the previous orders.
So
and
we
it's
have,
already filed.
and then there's a certificate of service. We'll take administrative notice of that. So we have A, B, C, D, E, F, G, H, I, J, substitute K, exhibit L, M, N, O, P, Q, R, S, T, U, V, W. X was not admitted. I don't think you've.
Yeah, X was filed. We went through it briefly because of the change from settling on going laydowns in the 2 South 3 West. No, X.
Then
No, we can leave that out.
Then I have Y, Z, A, and then what's your position on AB?
Yeah, I understand Mr. Chicken's concern. We would be okay allowing them to file a comment about it, but we would like it admitted.
So
and no objection under those circumstances. And if the chairman would like to set a timing for that, we'd be happy to take a deadline for that comment and any limit on length, because I'm thinking a page or two. But just in case you want to set those limits, we'd welcome that.
2 pages, and can you do it in a week?
Absolutely.
Okay. So, you've heard the list. Mr. Chicken, do you have any objection to admitting all of those?
I'm sorry.
You have an objection with admitting all of those?
No objection to any of their the exhibits you just read with that caveat.
And same, no objection by the division.
Board members, any objections? Okay, those exhibits are so admitted. Now to EP Energy, I have no exhibit A. I have
Correct.
L1, L2, supplement L. Pardon me. Let me clarify this. I have no L. Okay, let me start over again. We have L1, supplement L2, supplement L3, supplement G1, G2, G3, G4, replacement G5, replacement G6, supplement G7, supplement G8, exhibits E1, E2, E3, E4, E5, E6, and then the resumes that are exhibits B, B, D, and then the resume of Miss Kennedy.
Correct.
Okay.
And we would move to admit all of those.
Any objections?
No.
No objections.
Board members? Those are so admitted. Okay, thank you for that. And Miss Kennedy, we appreciate your filling in at the last minute and wish the best to all of your team. Okay.
In closing here, I would like to give my time. I think we'll just take a minute, or a minute or two to Adam, because I think he's summarized what the main issues are, and then I will just briefly address right after what the changes are and what we'd like the board to do. Adam?
Yeah, again, I'd like to reiterate, AXI and Newfield's interest here at 71%. And by the way, EP's not the balance; they're 10%, and so they're a small percentage within here. And you saw a lot of testimony here. No question, there's a big difference in how we're going to develop this, and we very much had to display what we believe to be the amount of waste that would be presented if it's allowed to be drilled vertically and interfere with our horizontal program. And to answer the question of what's changed, and Mr. Alder's recommendation of going to the 1280s directly, then with the 4 vertical wells really per 640 limit, what it does is it creates one operator in the 1280. And so that's going to eliminate, we would never go drill a well that's going to impact our planned horizontal well and so forth. But it puts forth, we're going to have to sit down with EP and try to come up with a solution. But what it does protect us from, if, for instance, the 1280s formed, it would prevent, in our mind, we'd go to the state and say, okay, look, now we're majority interest. We can't allow these vertical wells that are currently permitted to be drilled. And so then it would force a discussion between us and EP, and we do our best to prevent that waste from happening. So that is very important to us, is to prevent unnecessary waste.
As Mr. Chicken mentioned, there have been a couple of changes, and that's based on the responses that we've got from the division, from EP, trying to find a resolution to the issues that were presented. And in order to do that, we had to try and come up with some solutions and workarounds. And so that was the impetus for the changes, with the exception of the deciding to go lay down 1280s. That's been since the time of filing this application. Additional data has been gathered, and they've been able to conduct more analysis, and so they were finally able to arrive at that conclusion that it should go lay down. But everybody's been noticed about that, and that's not an issue. I think Axia's testimony has proven that they can maximize or better maximize resource recovery and do it to prevent waste, and all while protecting correlative rights. And EP Council did note that what you are deciding is who's going to operate these these lands, and it comes down to, are we going to let a 10% working interest owner operate these lands, or a party who owns a much larger interest? And that is Axia, along with Newfield support. So with that being said, I'd ask that the board approve the request as amended by the testimony and exhibits presented here today. And that's it.
Let's be clear what those amendments are in the board.
Yes. The first is going lay down instead of stand up 1,280 acre spacing units and 2 south, 3 west. The other, you guys help me out on this. I wrote them down.
1,280 acres.
1280 from the beginning.
1280 from the beginning, from the date of the order forward.
How would you propose handling the existing wells?
As we had in our request, those will be left on 640, because then you got an issue of making it retroactively effective and having to balance reallocation of the proceeds. So we'd ask that those remain as they are.
Limiting to 8 verticals.
Yeah, the other thing we didn't ask for, but has been proposed, is I guess that we would be willing to limit it to 8 verticals, and as was brought up in testimony or questions, that with the way it was worded, that you could have up to 31 vertical wells. We don't want that. We didn't intend that. Anything else? I think that summarizes the changes.
With that, I am going to venture that the board would like to take this matter under advisement, and don't expect an answer today. We will expect your comments in a week.
Next Wednesday, yes.
Question, so the 2 wells that are currently being drilled, when will those be completed and have some reliable production data?
We'll be in the November and hopefully December timeframe, weather permitting.
And then your plan for that rig next?
Well, depending on outcome of obviously this hearing, we want to start. We've already actually started permitting on these lands, and so they're just subject. So we want to come out west and begin as soon as we can, as soon as we get the land work done and the regulatory piece wrapped up.
Is it contracted right now to stay here and keep drilling?
No, but
or
we have that option though.
Okay, I see.
Yes.
Okay, a motion to adjourn is in order. All in favor, say aye. Any opposed? Okay, we are adjourned. Thank you very much.
Thank you.
Thank you.
Do we still want to meet tomorrow morning, Tim?
1 week. That's true. That's true.